11 ಹಾಕ್ರಿ ಯಾವ್ದು ಹಾಕ್ರಿ
81 ಕಡೆ
ಇದಕ್ಕಿಂತ 11 ಹಾಕ್ರಿ 4
ಫಸ್ಟ್ 03 ಹಾಕಿದ್ದೀನಾ
81 ಹಾಕ್ರಿ
81 ಇದೆ
11 ಹಾಕ್ರಿ
82
52 41 60 57
67
57 60 78 41 36 45 78 61 89 67 55 80 75 80 58 51 22 202 91 8 44
ಇದು ಒಂಚೂರು ಕೊಡ್ಬಿಡಿ ಸರ್ ಹಂಗೆ
2 weeks 2 weeks ಇವನ್ ಹಾಕದ
ಇಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಇದನ್ನ ನೋಡಿ
ಇದು ಬರಲ್ಲ ಹಾಕಿ ಅರ್ಜೆನ್ಸಿ ಇದ್ದಾರೆ ಅವ್ರು ಕೊಡಿ ಅರ್ಜೆನ್ಸಿ ಬರ್ಬೇಕು
ಇಲ್ಲ ವಿಡ್ರಾ ಮಾಡ್ಕೋಬೇಕು ಅಷ್ಟೇ ಬಂದ್ರೆ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಇಲ್ಲ
ಆಯ್ತಾಯ್ತು ಅರ್ಜೆನ್ಸಿ ಎಲ್ಲ ಅವರು ನಾನು ಹೇಳದ್ನಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಇಲ್ದಿರತ್ ಕೊಡಿ ಅಂತ ಸರಿ ಮಾಡ್ಕೊಳ್ಳ2 weeks ವೈ ಅಲ್ವೇನಮ್ಮ ಸ್ವಲ್ಪ ಸ್ವಿಚ್ ಆಫ್ ಮಾಡಕ್ ಜಾಗ ಇದು 300 ಮೆಮೊ
My lords, yesterday I moved memo, my lord. It's today, my lord.
What is that urgency?
My lord, action is today, my lord. It will be taken up tomorrow, my lord.
Tomorrow, not.
Please.
Lord, and my application has been rejected by the lower court, order 6/17, amendment of written statement posted for the evidence on Monday. Kindly have it tomorrow, Raj.
Monday.
Alla, Monday,
I tell you not.
alla, Monday it is coming. Kindly have it tomorrow, Raj.
Party in person. I have fought interim order. And summons have been served on the.
Third.
Served.
Monday.
Monday.
My lord,
ಬರ್ತಾರೆ ಆ ಕಡೆಯಿಂದ ಬರ್ತಾರೆ.
my lord, the petitioner's including application have been dismissed. And it is relating to the ancestral property, and so it may kindly be posted on Monday, my lord.
What is that urgency, Mr.?
It's posted for hearing, my lord, that's the reason.
When?
It's posted on 27th.
27th. Yes, 27th.
ಆ ಕಡೆಯಿಂದ ಬರ್ತಾರೆ. wait.
What is that urgency, Mr.?
They created a third party interest.
Hmm.
I've heard an application for not to create a third party interest. But the matter was adjourned today.
No, what is that order you are challenging the trial court?
We are telling the compromise petition, my lord.
Hmm.
We have been alerted to non-existence property.
Hmm.
Therefore, I am challenging the compromise
Yes,
petition.
25th. Yes.
My lords, a fresh matter, my lords, on Monday, the request is to be lifted tomorrow, my lords, on Monday, the surveyor is appointed, my lords, to survey the property.
Yes.
My lords, that takes place, my lords, the miscellaneous petition that we have filed, my lords, to set aside the ex parte judgment.
Tomorrow. Yes, tomorrow.
It was listed yesterday, Your Honor. I am for the respondent. They are trying to dispose and to create a.
What has happened yesterday?
It has not been listed. It has not been reached.
Yesterday, Tuesday. Yes.
Today.
Tuesday.
Not the done, my lords, my photo from declared as by the approved proceedings, my lords. Out of nowhere, petitioner has come and filed the including application, my lords, in approved proceedings, have filed the ID for vacating state.
Vacating stay. Yes, 27th. Yes.
My lords, 2022 commercial suit, my lords, the stage for cross-examination of the close. So petitioners are sought for this WP to reopen the stage. I am for the respondent. We do not press for the petition. It may be allowed, listed and allowed, my lords.
Tomorrow. Yes.
The urgency, my lord, suit for recovery of money, my lord. Tomorrow it is posted for marking of documents, my lords. It was,
Yes, 27th.
But
Let them marking a documents.
tomorrow it is posted for marking, my lord.
Let them mark, Mr. Nothing
Delivery
will
was
happen. If there is any urgency, it's going to pass any order, then only. Yes.
Yesterday, we argued a matter
Yes.
regarding the writ petition for the commercial court execution. I forgot to mention, my lord, that though the honorable court directed us to appear before the executing court, but by filing pleadings and filing documents ಅಂತ ಒಂದು ವರ್ಡ್ ಇಲ್ಲ ಅದರಲ್ಲಿ. ಅದಕ್ಕೆ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಅದನ್ನ ಫಾರ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ನಾಳೆ ಲಿಸ್ಟ್
Yeah, what is that?
if I appear, my lord, without any, I was ex parte, my lord. I have not filed any application for recall of the order or permission with documents, evidence and all. So therefore, that may be observed on order alli, the executing court to decide whether the commission appointment was correct or not. And then if it is necessary.
No, I said entire execution petition has to be decided in accordance with law.
Correct, my lord.
In that, if you want to file any objection, you can file it.
That should be observed.
That is there, yes, that will be.
That may be observed, my lord.
That will make it in that order.
I'll request for, let it be on record.
Yes, thirdly, then post bada, adu chamber li irಬೇಕು. We will see that.
Much.
We have not curtailed anything, Mr. I have said that.
All contentions may be kept
Kept
open
open,
with
yes.
filing objections and documents.
Bada chamber. That has not yet signed, yes. Yes.
My lord. Limitation, 6 years condonation, the matter is urgency, so actually for Monday, please.
Suit for?
Petitioner.
Suit ಏನು? ಹಾ, ಏನಾಗಿದೆ?
ಅದರಲ್ಲಿ ಸೆಕ್ಷನ್ 5 ಲಿಮಿಟೇಷನ್ ಆಗ್ತದೆ 6 years condonation ಮಾಡಿದ್ದಾರೆ.
6 years ಎಲ್ಲಿ ಕಂಡೋನ್ ಮಾಡಿದ್ದಾರೆ? No, see, when suit is filed for partition, what is that limitation, Mr.? Tell next week on date today. Yes.
My lord, I think delivery warrant has been ordered, my lord, without appointing court commissioner. Suit for declaration and injunction, my lord. I think execution is.
Yes.
My lord.
Withdrawal. Tomorrow, yes.
Let's-
Monday, yes.
Lots in a suit for partition and for defendant.
Tuesday, Tuesday.
Declaration and injunction.
Hmm.
3992 was rejected by the trial court as well as the constitutional court. However, this honorable court in a writ petition challenging 26 line application had observed that a commissioner has to be appointed for determining the 39 rule 1 and 2 purpose. However, so was not the case. Challenging the MA order, we have come before this court. There is apprehension of construction in the disputed area, my lord. If I may
Yes.
request for tomorrow, my lord.
Monday, yes.
Great.
It's a fresh matter for either for tomorrow or Monday.
Yes.
Play a suit for partition notes. I am defendant. I had filed I for amendment. That has been rejected. Now day-to-day trial is going on. Therefore, Monday it could be had.
Tuesday, yes.
Great.
For what? Main arguments. Yes, 25th, yes. 25th. Please, my lord.
This is a fresh petition. Challenges to warrant for attachment issued by the execution court. It's a commercial court, maybe back tomorrow.
Why?
It's a warrant for warrant for attachment of
Yes,
movements.
tomorrow, yes.
Great.
What is the suit for? Suit
For my lord, they have not been made party.
compromise petition before where?
For the civil court.
No, the civil court compromise petition, you can't challenge that. Only Loka Adalat, otherwise you have to go before the same court.
Compromise of.
Loka Adalat or civil court? Yes, Tuesday, yes.
My lords, appearing with the pleading applicant, the petitioner, being a bank, has filed the present petition challenging the maintainability. However, they have not arrayed us as the party, and in the present petition, and an interim order of stay has been granted by this honorable court. Therefore, an application for implement.
Then vacating.
Yes, please, my lords, vacating of stay.
My lord, 4 writ petitions of the year 2022
Hmm.
filed by the City Corporation Shivamogga
Much
challenging
obliged.
the order of temporary injunction in respect to the portion of the tank bed area, my lord. On every rainy season, there will be a flood. Lord, by virtue of the interim order granted by the trial court, the corporation is not in a position to make any civil work to prevent the flood.
An order has been passed.
Lord, that was in the year 2022, against which, my lord, an appeal was filed.
Hmm.
That came to be dismissed. The writ petition is of the year 2022.
22, one date for the next.
The 4 matters.
Yes.
Can say it,
Hmm.
20 into 16, my lordship. Execution petition filed, my lordship. Next week I'll hard rock.
Next week alone put it. Yes.
2 dates itself, my lord, it has closed the arguments and court set for judgment on 28th, my lord.
What is that you are challenging?
I had filed an application for rejection of claim. Claim was rejected, my lord.
Hmm.
The other side has preferred an appeal. They had taken 6 dates and trial appellate court allowed them to take dates. On the second date itself, my arguments has been closed and it has been posted for judgment, my lord, on 28th. Kindly, my lord.
What is that you are there? Your appeal, you have succeeded that rejection of the client, that they have challenged.
They have challenged, my lords. I have not been addressed my arguments in appeal, my lords. I filed an application for addressing the arguments. That was also rejected without advancing the matter, my lord.
Now, what is that? See, there is no any order has been passed.
28, they have posted for judgment, my lords.
What is that you are challenging?
My lords, I have to address my arguments.
I three addressed argument and any order has been passed.
My lords,
You are challenging. See, that is a degree. That is a degree. Appeal has to be filed.
they have
there is-
filed appeal, my lords.
ಆಯ್ತ್ರಿ ಅಪೀಲ್ ಅಲ್ಲಿ ಏನಾರ ಆದ್ರೆ RSC ಆಗುತ್ತೆ.
ಅಲ್ಲ,
ನೀವು ಎನಿ ಆರ್ಡರ್ ಪಾಸ್ ಯು ಆರ್ ಚಾಲೆಂಜಿಂಗ್ ದಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
that's
ಹಿಯರ್.
my lords, that I had sought for time. That was
If
rejected.
you have filed any application, they have rejected, you can come.
Advancement application itself is
And advancement application under which provision?
151.
151, everything 151. Why that? We wait for that. They will pass an order. They may reject it also.
They rejected, my lords. If they, my lords,
No, they can reject their appeal itself. When they are rejected,
I had not addressed my arguments, my lords. That's what, my lords. I may be.
if you are not addressed arguments means why you have not appeared on that day?
Second date, I was end up in.
Everything you are not appeared, then you have filing in a writ petition.
No, my lords, second date, my lords.
Yes, take this on 27th, yes.
28th is judgment, my lords. Monday, my lords, training day.
No, then 28th, yes.
Lord,
We'll have it on 28th.
petition in 2016 matter, my lord. In this case, petitioner and respondent has been died. LR application has been
Yes,
filed.
date
ma-
given.
Another memo is so next week.
Now, the suit I have read the was filed by some of the member. The court has which was filed under order 128. That is challenged before this honorable court on the ground that it itself is not mentioned. And then interim order was upheld. Now what they are doing is they are trying, they are inducting the new members and also they have called for AGM. So
Yes, you have filed an application for vacating.
they have filed,
27th, yes.
but
Suit for partition. He filed an application for appointment. Though it is a legal error, but the trial court has rejected the IAVN.
Yeah.
Meanwhile, the petitioner and the respondent colluded and formed the sites and they are going to negotiating and selling the property. Thinking of that.
Yes, 27th, yes.
Tomorrow.
Not tomorrow, Tuesday.
My lords, in a suit for declaration, my lords, the subsequent purchaser has filed an impleading application, has been impleaded as a petitioner number 3, plaintiff number 3 in the suit, my lords. Because, my lords,
You are the plaintiff.
I'm the defendant, my lords, in the suit, my lords. Now he has been transposed as plaintiff number 3, and during the pendency of the suit, he has alienated the property, my lords. The impleading application came to be allowed.
No, who is alienated?
The plaintiff has alienated the property.
You are the defendant. What
I'm
is
the defendant, my lords. But he doesn't have any right. During the pendency of the suit, he has alienated the property.
ಆಯ್ತ್ರಿ ಲೆಸ್ ಪೆಂಡೆನ್ಸಿ ನಿಮಗೇನ್ ಬರ್ತ ನೀವೇನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ how you
And even without calling for the objections, my lords, on the very same day, the application came to be allowed, my lords.
yes 27th, yes.
Lordship, this present petition, I was the plaintiff in the original suit, your lordship, and the suit was for partition. I had filed an application for amendment of the plaintiff, your lordship. The only reason is there has to be an incorporation of certain paragraphs with a property which has to be incorporated, which have gone in my lineage. And the matter had surpassed the stage of evidence, your lordship. When I had filed the application came to be rejected. Subsequently, I have come with a writ petition. I had got an order of stay in the matter, your lordship. Now the matter is presently set down for final hearings, and both the defendants and plaintiff are in their evening days. If it is to be heard on that, then I can succeed with my suit in the further proceedings, because the suit is of the year 2009, your lordship. For that reason, I'm going for final hearing, your lordship.
Final hearing next week.
For page wise adjournment, list number 1, page number 1, serial number 1 to 6. Page number 2, serial number 7 to 18. Page number 3, serial number 19 to 27. Page number 4, serial number 28 to 34. Page number 5, serial number 35 to 39. Page number 6, serial number 40 to 43. Page number 7, serial number 44 to 47.
My lord, appearing for the petitioners in 46, serial number 46, my lord. My lord, we have to take steps to bring the LRs on record, my lord. Kindly weeks accommodation.
Yes. At the request, 2 weeks time is granted to do the needful.
46 and 46.1, my lord.
Yes.
Page number 8, serial number 48 to 54.
Number 50, my lord.
Only. Serial number?
Serial number 50, my lord.
50.
50.
My lord, I'm appearing for R3.
Senior is
It was-
not feeling, my lord. Kindly have it on Tuesday, my lord. Ready.
Have you informed the other side?
My lord, we have not received any intimation. I am appearing for R3.
Application. R1 filed an application.
Yes.
R3.
What happened? Finally, and the date for the last date of hearing also.
Avran is not well and.
He is not well.
Monday.
Tuesday, please.
Monday, Tuesday.
Tuesday, please.
Yes.
My serial interim order may be expected.
My
Interim
lord,
order
serial
granted
number 47.
Till next date of hearing.
My lord, serial number 47. I have filed an application for extension of time in the lower court. The previously extended time has expired, so my lordship.
Wait, when now that only adjournment, don't argue here. Yes.
Number 52, madam.
Hmm.
I for respondent number 1.
Hmm.
Out of state and I have intimated email.
Yes, at the request,
So is there, it may be.
at the request of counsel for the respondent, leave this matter next week. Interim order granted earlier is extended till next date of hearing.
After 26.
Yes, Bharat, first week of March.
My lord, apologies, serial number 46, kindly interim order may be extended, my lord.
36 interim order, if any, is extended till next.
Obliged.
Page number 9, serial number 55 to 57.
Serial number 57, my lord. Petitioner in this case, weeks time may be granted. Senior the Gro Pravesha is kindly have it.
You are
next
appearing for?
Petitioner in this case.
Have you informed the other side?
I will inform.
First inform, then come. There is an IA for vacating. Yes, then you mention, yes.
Page number 10, serial number 58 to 60. Page number 11, serial number 61 to 68.
65, my lord. I am for the respondent. I need 2 weeks time to address the argument. But yesterday only I have received the documents, my lord. And moreover, I have informed to them to give subsequent documents.
Have you informed that counsel for the petitioner?
No, my lord.
You inform and come, yes.
But yes, but I don't know his address.
You have to find out and inform, mister. You don't know means what? Yes.
Page number 12, serial number 69 to 80. Page number 13, serial number 81 and 82. Page number 14, serial number 83. Quota number 20 matters, list number 2, page number 1, serial number 1 and 2.
My lord, I appear for the OL, my lord. Serial numbers 1 to 3 may be adjourned to when the regular bench commences, my lord, either 6th or 13th, my lord.
Yes, leave this matter on 13th March. Yes.
Page number 2, serial number 4.
Yes.
Page number 1, for preliminary hearing, serial number 1, Prakash T. Abbar for petitioner.
Lord, I appear for the defendant in the court below. Lord, the suit is for recovery of money against my husband. The loan hand loan said to have been taken by my husband. The property is the wife's property, which was gifted to her much before the
Suit
transaction.
for recovery of money.
Suit for recovery of money. Lord, the allegation against my husband was that he has taken certain hand loan and issued the checks. Lord, my husband died. The property was gifted to the petitioner, my lord, several years prior to the loan transaction. Lord, now the plaintiff has filed an application for attachment before judgment. Lord, that order came to be, the application came to be allowed. Without there is absolutely, there is no amendments made in the affidavit seeking the, in the application seeking the attachment before judgment. But IA is at annexure D, my lord, in page 45.
Yes.
And this property, my lord, has been already mortgaged with the bank. The allegation in the affidavit is that I may alienate the property. Lord, that too, for the husband's loan, the wife's Sridhana property is being attached.
No, is it Sridhana or you have got it from your husband?
No, husband only, my lord.
Okay.
It is a Hindu female's property, my lord. Even otherwise, my lord, the property was gifted several years prior to the loan transaction.
Is it, there is no liability on as a wife?
Pardon?
The wife has no liability to discharge the loan of the husband.
Lord, now if the wife succeeds to the property of the husband, my lord, she is. Lord, 38 rule 5, my lord, the provision powers cannot be exercised in a straitjacket manner. So it should be with circumspection and with utmost care, because in the affidavit, there is no such apprehension is mentioned. My lord, may kindly peruse in page 46. The alienation is not that I may sell away the property. It is already mortgaged with the bank. I have produced the necessary document to that effect.
Which is that property?
Property, my lord,
of
property
the-
description is at in page 45.
In order attachment is. Now you have any judgment to show that the Sridhana property cannot be attached?
Well, that I can give, my lord, the matter requires consideration, my lord. Therefore, it may be taken up tomorrow, my lord.
Yes. The request is this matter tomorrow.
Serial number 2, Pradeep GC.
Yes. None appear, leaves this matter next week.
Serial number 3, Geeta Devi MP.
Petitioner minutes may be passed over.
Password.
Passed.
Yes.
Serial number 4, Sanket M. Enagi for petitioner, Kumar.
I am appearing for the petitioner.
Yes.
My lordship, petitioner is the defendant.
Yes.
Suit is for declaration and possession, declaration and injunction, my lordship. When the matter was listed before the trial court for main argument of the plaintiff, the plaintiff has filed an application under 6 Rule 17 for amendment of the plaint prior, my lordship. We have filed our detailed objection, but trial.
What is that impleading that amendment they sought?
My lordship, kindly see the page number 75, my lordship. This is the application they have filed. Page number 75, Annexure F. This is the application, my lordship. Proposed amendment. May I read, my lordship? Plain prayer column at prayer A, at first line, delete the word absolute and incorporate the word joint in its place. And further at line 3 of prayer, after the words as only daughter, incorporate the line and is entitled to her legitimate half share in the social property.
Can partition a declaration?
No, it is initially they have filed suit for declaration injunction. Now by way of amendment, it is turned to the entire nature of the suit is changed, my lordship. And the trial, the learned district and session judge has given the finding.
Where is that?
The finding is at page number 87, my lordship, kindly see. Para number 10 onwards. To determine, may I read, madam?
Yes.
Para number 10. Further, it is well settled that all amendments ought to be allowed which satisfy the two conditions. A, of not working injustice to the other side. B, being necessary for the purpose of determining the real questions in controversy between the parties. If the amendment as proposed is allowed, no right accrued to defendant would get defeated, as the said defendants are denying possession of plaintiff and are contending that they are in possession of the property which was earlier in their occupation. Further, as the refusal of the request seeking amendment does not preclude plaintiff from instituting a fresh suit, the refusal of the request leads to be multiplicity of the litigation. In the well-considered view of this court, if the amendment is permitted, the amendment, though sought belatedly, also helps in avoiding multiplicity of the proceedings. And
so a partition agli, is there any bar under law? If it is not, instead of filing in a fresh suit, they amend it.
No,
That is what that now, if it is not cause any prejudice to you, then if the suit is not barred by limitation, then that can be amended. Instead of fresh suit, they have do it. This is an amended suit with a new prayer.
My submission is the suit is listed for on 24/1/2005 for the main argument of the plaintiff. At that time, they have filed this amendment application. And one more submission is
now consider that this is a new suit.
No.
How it will affect you? Partition suit. You are the family member.
No, sir. I am the purchaser. Defendant is the purchaser. I am purchasing this suit property.
Who are that other? Only you two is there.
Yes, my lordship.
Then what is that in the prior share and all they have mentioned?
No, my lordship. Plaintiff is the stranger to the scheduled property. She is claiming that she is the adoptive daughter of the vendor of my sale, my lordship.
No, see, ultimately what will be that prayer?
Prayer
If that amendment is allowed, what will be that prayer?
Yes, my lordship. In the year 2018, they have.
Where is that plaint, Mr.?
Plaint is amended plaint. I will just pass it on.
Yes, you give that. What will be that prayer meaning of that amendment?
Kindly see the page number 17. Page number 17 is the prayer. Earlier, they are asking for
Declare that plaintiff is the giant owner of the plain scheduled property having inherited the same and her mother, Srimati Saraswati, has the only a daughter and is entitled to her legitimate half share in that two children. Consequently, declare that register sale deed dated. Yes.
Earlier, they are asking absolute owner. Now they are asking joint owner. And this is the third time they are asking amendment, my lordship. 2018, they are asking for amendment.
Stay of order dated 4/2/2025, passed on IA number 21 of 2025, in OS number 5843 of 2017 by 858 additional city and session judge, Bangalore, till next date of it.
My lordship, they are already appeared through caveat, my lord.
Who?
That respondent plaintiff. It is already served to the copy to them also.
Yes, he is not there.
Please,
Yes, state, the caveator is directed to take notice.
please.
Yes.
Till number 5.
They have further proceedings.
Yeah, no, that order only stayed. Why further proceedings
Please,
you
please,
want it?
please.
Number 5, Jagadisha P for petitioner, Harsha Kumar Gowda.
In
This
appeal
case,
for
I am
the
for
respondent, my
the
lord.
petition, my lord.
Yes.
My lord, I filed the application for 26 rule 10A application that was dismissed by the trial court without taking into consideration of the factual aspect of the case is concerned, my lord. That is the annexure. The order was passed in page, running page number
What is that
60.
suit for?
The suit for declaration and injunction, my lord. Later on, they filed the application for amend the plaint, my lord. They are inserted the suit for possession also.
That is you are challenging.
Please, my lord.
No, what is that wrong in that?
Please, my lord. My lord, earlier, the suit was represented by the general power of attorney holder, my lord. Till the commencement of the cross-examination was taken place on 23rd up to 2023, my lord. He has not produced any document in respect as a GPA holder. Even photocopy is also not in the file. Once the cross-examination was started, the specific question asked by the counsel was appearing for the defendant number 2, where is on what authority you appear before the court? He stated that I am the GPA holder. Where is the question of where is the GPA in the file? Entire GPA was searched by the court, my lord, as well as the witness therein. There is no GPA, find out. Later on, they filed the application for order to my lord. On that way, on that time, my lord, they are produced earlier in the annexure E. That was produced before this court, my lord. Sorry, annexure E. That's also marked before this court, my lord.
Where is that?
Please, my lord. That is annexure D, my lord, sorry.
Annexure?
Page number 46, my lord. They stated that it was misplaced, so that I filed the application, my lord. That application came to be allowed on 23/12/2013, my lord. That is in the order sheet also. Kindly see the order sheet is also mentioned, my lord. Later on, my lord, I filed after that, they filed one more application on 7 Rule 18, stating that the original GPA was found out. Later on, they are filed one more application, my lord. During that, my lord, at the first instance, this GPA was registered. Up to 23/11/2023, cross-examination was started. They are not producing a single piece of the affidavit filed by him, the wakalat signed by the PA holder, and all the documents before the court is signed by the public power of attorney holder only, my lord. When the matter was posted, cross-examination, there is a specific question asked. Later on, my lord, they come up with this GPA and the annexure D, my lord. After that, they are filed one more application to insert it. Another GPA was found out in the exhibit T23, my lord. The learned trial judges are taking the view that, my lord, the already exhibit T23 is a document inter se between only a document, so that the exhibit 28 is not the considerable. My lord, this is both the documents are marked on the same day, my lord. This is the.
No, what is that order you are challenging?
My lord, the order passed by the trial court without sending the, because of in the bare eyes, my lord. Kindly see the annexure D. This is
No,
there.
you will come to that order. What is that order?
Please, my lord, that's annexure. Annexure H, my lord. Page number 66, my lord.
68.
68, the running is.
What is that application?
Please, my lord. In that application, my.
Under order 26, rule 10A.
Please,
CPC appoint a court commissioner, court commissioner.
To send the scientific investigation to signature. Because of 2010, they filed the suit, my lord. Up to 2023, there is no document.
You have filed an application.
Please, my lord, I filed the application. That application came to be rejected by the court. So that I challenge before this honorable court.
No, that comparing that signature of
Exhibit D 23 as well as the D18, my lord.
what is that?
That is the D23 is the GPA special power of attorney executed, the alleged executed by this plaintiff. And the same, the sale deed also executed by the same plaintiff, my lord. That is also produced on the annexure E, my
What is
lord.
your case? Was sale deed is executed by
By
whom?
the plaintiff, original plaintiff, my lord. This is the bogus GPA created by.
What is the facts of the case, Mr.?
Please, my lord.
What is that suit for?
Suit for declaration, injunction and possession, my lord.
On the basis of?
On the basis of the alleged adoption deed, my lord.
He is claiming an adoption. deed.
Adoption deed. He was the agreed purchaser for the property from the adopted son, alleged adoption, and that is a biological father was one Veerappa. They are adopted one Mallappa. Later on, that issue is running before the court, my lord.
Now,
Now,
is that plaint, Mr.?
plaint is in the
My lord.
page number, annexure A.
My lord, the issue is very simple, my lord.
Annexure is, the annexure,
Right.
annexure A, my lord.
Wait, I will hear.
My lord,
Let me
the
understand.
issue is very simple, my lord. My lord, the plaintiffs, the suit has been filed by the plaintiffs through the GPA holder, through GPA dated 17/7/2010, my
Where
lord.
is the plaint, Mr.?
Annexure A,
Plaint
my
is,
lord, page number
Wait,
14.
Mr. I will
Annexure
not-
A,
I
my
want
lord.
to just get the
Please,
clear
my lord.
facts.
Please, my lord.
Understand the facts,
Please, my
then
lord.
we can, yes.
An annexure A, my lord.
Annexure,
A, my lord.
Hmm.
My lord, in this matter, there's
the GPA holder, Mr.
my lord, GPA holder is one K. Shivrama, my lord.
Shivramu is representing all plaintiffs.
All plaintiffs, my lord.
Hmm.
And my lord, that GPA has been produced in the plaint, along with the plaint, in page number 248 of the plaint, my lord. It has been recorded by the learned judge in
You have
in
to
the
be
order.
produced when filing the suit.
Yes,
with the
produced,
GPA holder.
produced. Photocopy has been produced.
Yes, what is the date of the GPA?
GPA dated 17/7/2010, my lord.
17,
7/2010.
2010.
Yes, my lord.
Now what has
That,
happened?
that is marked as exhibit P23, my lord.
Yes.
And my lord, now, my lord, at the time of the examination of the PW1, my lord, the original GPA has been misplaced, my lord. And for that, the new GPA has been executed by the plaintiff.
Why exhibit P23, it is marked, it is
They,
before.
my lord, thereafter, the new GPA has been executed, dated 27/7/2023, my lord.
Why new GPA has been executed?
Because that earlier GPA has been misplaced, my lord. After executing the second GPA, the first GPA was found, my lord.
You have produced the exhibit P23 is not an original.
Original, my lord.
Then L misplaced, I totally.
Early, no, my lord, with the plaintiff GPA holder, my lord, only. Earlier it has been misplaced, my lord. After executing the second GPA, the first GPA was found.
Answer that question. You have filed along with that suit.
Yes, my lord. The photocopy,
It is a part of the court copy.
photocopy has been filed, my lord, at the time of filing of the suit.
Not original.
Not original, my lord. And my lord, thereafter, due to the misplace, my lord, the second GPA dated 27/7/2023 has been executed, my lord. 27/7/2023.
23. Yes.
And my lord, thereafter, they filed the application for production of this GPA, my lord. And after that, my lord, a few months, the original first GPA has been found, and thereafter they produced, and the court has been accepted and marked as exhibit P23, my lord.
23, yes.
And as on the force of the defendant, the second GPA has been also marked as exhibit P28, my lord. And my lord, in support of the plaintiff case, my lord, they have marked one sale deed dated 19/11/2003, my lord.
1911?
2003 sale deed, which is not under challenge, my lord.
No, what is the sale deed?
This is the sale deed, one of the site executed by the plaintiff in favor of one Satnarayan, my lord. This is not under challenge, my lord.
Yes.
Now he is filing the application to examine the signatures of the sale deed dated 19/11/2023 and new second GPA dated 27/7/2020.
No, that sale deed is executed by GPA holder.
No, my lord, original plaintiffs, my lord.
But our signature, what is that signature in that GPA executed by that?
My lord,
original
their
plaintiff?
contention is that, my lord, the sale deed is executed in the year 2003, my lord. The second GPA is executed in the year 2023, after 20 years, my lord. For the naked eyes, a slight variation is found, my lord.
Saying that there is no GPA has been executed by the plaintiff. Is it their case?
That is their contention, my lord, but that is not stated in the affidavit, my lord. In their, along with the application, they have not stated, my lord. The application is very vague, my lord, and there is no purpose in filing the application. Kindly see the affidavit, my lord. Page 61, my lord.
But plaintiff are not disputing that.
No, my lord, plaintiffs are not disputing. Even the plaintiffs are ready to come before the trial court and
What is
say,
that?
my lord.
In the cross-examination dated.
No, even assuming that it is not in a GPA, when the plaintiff said that, yes, we have executed, what is else,
But
Mr.?
nowhere since from the beginning 2010 till 2023, my lord, there is nowhere stated, even the wakalat filed by the PO holder only.
My lord,
Nowhere is
may I
stated, my
pa-
lord, because of.
Where stated what?
That means to say, my lord, in the original, what my learned friend has argued before the court, they are produced
No,
before the
if
court.
the plaintiff has come before the court saying that, yes, we have not executed in a GPA, then it is different. They have not disputed, we have executed in a GPA, so and so has been contesting that matter.
My
What
lord,
is
that-
your?
That fact is nowhere they are not stated. Plaintiff is not till today, they are not appeared before the court, my lord. Only PA holder was appeared before the court.
That's
In
why
all-
GPA has given only for the purpose that we can't go there.
Please,
Therefore,
my
you
lord,
have-
at the first instance, why I.
May I pass one order passed by the trial court, my lord.
That
In
is
this,
suspicious in nature. When the matter was posted in the cross-examination, there's a specific question asked.
they says that they have no objection to send the,
Please.
for the
Please, my lord.
examination, my
On
lord.
24
But what is the purpose, my lord? There is no purpose in sending the signatures, my lord.
2023, my lord.
And my
Kindly,
lord, there are.
That's a list
Wait,
of.
Mr.
That's
Obrogra.
a list of documents also they have furnished, my lord. On the defense side, the plaintiff has furnished the exhibit P 120, P1 to P28, 22, my lord. In the first instance, they are not produced the even GPA at the first instance. Later on.
Where is your application?
Please, my lord.
Have you said that plaintiff has not executed the GPA?
Please.
Is it your pleading?
No, my lord.
Where is it that, Mr.?
Page number 61, my lord.
Yes, where is the pleading that plaintiff has not executed? He has forced the signature, then we'll see.
The para 4, my lord.
Para?
4. I state plaintiff who are the 4 persons, that is the Manjunath, Mallesh, G.K. Ananda, Gururaja are the alleged executed GPA in favor of the A.K. Shuram, so has to conduct the above case. And in fact, the original alleged GPA never produced by the so-called GPA and the case being permitted to conduct the procedure further. The alleged GPA is final come up with the GPA allegedly executed by the plaintiff.
Yes.
And the state that GPA holder being examined at PW1 is examined the more than 4 persons. And in the cross-examination at 2/12/2025, a specific question being posed to the PW1 found in the exhibit page 23 to the effect that EP 18 ಮತ್ತು 18ನ ಸಹಿಯನ್ನು ಕೈ ಬರಹ ತಜ್ಞರ ಕಳಿಸಲು ಅವರಿಗೆ ವರದಿ ಪಡೆಯಲು ನಿಮ್ಮ ತಕರಾರು ಯಾವುದೇ ಇರುವುದಿಲ್ಲ ಎಂದು ಸಾಕ್ಷಿ ಇಲ್ಲ ಎನ್ನುತ್ತಾರೆ.
ಅವ್ನು ಕೇಳ್ಬಿಟ್ಟು ಅವ್ನು ಹೇಳಿದ ತಕ್ಷಣ ಕಳಿಸ್ತಾ ಇರೋದು ಅವನೇ ಸಾಕ್ಷಿ. Object of that act has to be, section has to be satisfied. ನೀವೇ ಕಳಿಸಿರಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
No, my lord, kindly see the,
See, in fact, he has submitted that you can send it. I have no objection. That means to say that.
Just to mute, my lord, kindly see the exhibit D24 and the E, my lord. Just for a moment. Just for a moment, you kindly see the exhibit D, my lord.
The exhibit?
D, page number 46, my lord. Annexure D, sorry, Annexure D, page number 46, and Annexure D, page number 50.
46 ಏನಿದೆ?
My lord, the signature found on the both the documents is clearly indicated that, my lord.
Whose signature?
The plaintiff themselves has they alleged, they are contended that, my lord, the GPA was special power of attorney was executed by the earlier, the present original plaintiff. I am content it's a fabricated document because of the intention, the modified intention the PA holder himself has created. So that
No,
he
that
come up with this
plaintiffs
court.
are ready to file an affidavit.
Please, my lord, if
My
they
lord.
are ready to file.
Yes, file an affidavit before this court.
Yes, my lord.
Please,
And my lord, their
That
allegation.
is the end of the matter. Mr.
Yes, my lord.
Unnecessary all. You file an affidavit that I have executed. It's end of the matter.
Next
When
week,
will you file it?
next Monday or Tuesday, man.
Yes, Tuesday.
But until
Much-
that stay the.
Nothing will happen, Mr.
24th.
And my lord, without giving the evidence before the
They are
trial court,
coming
they filing
before
the
the court and say that what is your interest?
ಅಲ್ಲ Monday the day ಅಲ್ಲಿ
ಆಯ್ತು ಇರ್ಲಿ ಬಿಡ್ರಿ
next-
ಮಂಡೇ
and the
ಏನಾಗುತ್ತೆ
next
Tuesday.
day,
Yes, my lord. Much obliged.
Tuesday you file that affidavit, Mr.
Please, my lord. ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಂಡೇ ಇದೆ ಅವ್ರು ಒಂದು ಡೇಟ್ ಕೊಡಿ ಅಂದ್ರೂ ಕೇಸ್ ಇದೆ ಅಂತ ನಾನು memo
ಆಯ್ತ್ರಿ,
ಹಾಕಿದ್ದು.
ಮಂಡೇ ಏನಾಗೈತ್ರಿ?
ಎವಿಡೆನ್ಸ್ ಹಾಕಿ ಅಂತ ಕೇಳಿದಾರೆ ಅದು
ಆಯ್ತು.
ಫೈನಲ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅದಕ್ಕೋಸ್ಕರ.
ಆಯ್ತ್ರಿ, ಈಗ tomorrow if they have filed an
ಅಲ್ಲ,
affidavit.
Tuesday ಇದೆಯಲ್ಲ
I
ಮಂಡೇ.
will impose a cost on you.
Please, my
Impose cost on you. Plaintiff has filed an affidavit
my lord.
saying that yes, you have executed.
My lord.
What is
This is
yes?
because
Yes,
of
let us see. Let them file affidavit Tuesday.
Serial number 6, Ananda K for petitioner.
Yes,
For the petitioner.
yes.
It's a peculiar case, my lord. But the petitioner is the defendant number 6 in the suit filed by the first respondent for suit for specific performance. But the facts of the case is that not the petitioner and the first respondent and one Sri Nandisa C kindly enter into an agreement to sell
Suit for?
specific performance.
Hmm.
Filed by the respondent number 1 against the petitioner and the respondent number 2 to 6 herein. But the facts of the case is that, my lord, the petitioner, the respondent number 1 and the one Sri Nandisha C were jointly entered into an agreement to sell with the respondent number 2 to 6 herein as per annexure A. Your Honor, kindly page number 20. The name of the petitioner was shown in the Prasad Reddy Talla, page number 21. The name of the Nandish and the page, say second para, Mandya Jilla, Matturu Talaku.
I thought defendant has executed an agreement of sale to plaintiff.
Plaintiff, the petitioner, the first respondent, another one, Sri Nandish, jointly, my lord. Thereafter, my lord, on the same day, the defendants have executed the separate registered agreement also as per B, C and D in favor of 3 members, my lord. The petitioner and respondent number 1 and another Nandi C. In addition to the original unregistered agreement, they have also executed the registered agreement, my lord. Then since they have not come forward to execute the sale deed, both the petitioner and respondent number 1 and Nandi Sasi approach the one Sri advocate. I may be not permitted to not to say the name advocate, my lord. Advocate to issue a legal notice to the defendant, my lord. Accordingly, the said advocate on behalf of the petitioner herein issued the legal notice to the respondent number 2 to 6 herein, my lord. And thereafter, they also issued the replay notice, legal notice in page number 51. Your Honor, kindly see the name of the advocate.
No, now that what is that order you are challenging?
Now, my lord, there is very same advocate now they filed the suit in respect of the same property against me in this on behalf of the respondent number 1.
No, he has issued a notice on behalf of you.
Please, my lord. And not only on behalf of me and the respondent number 1.
No, you have approached him and filed a wakalat he has filed. How can he, without your wakalat, he can file it, mister?
No, my lord. He filed a suit against me where kindly see the page number 15.
No, he has filed a suit against, he is the appearing for the plaintiff.
To issue the legal notice in respect of the same matter, in respect of the same subject matter on
No,
my
he is the
behalf.
plaintiff.
He filed the case against me also.
What is that you are challenging now here? Before?
Then I request, my lord, because at the time of issuance of the legal notice, I have made several communication with the.
What is that order challenging here?
Now, then, my lord, during the pendency of the suit, my lord, immediately after filing the application, written statement, I filed an IA. Kindly see the another page number 100 annexure M, requesting as per the debarring the said advocate from conducting the
Page
case.
number?
Page number 100 annexure M.
Yes.
I filed application under chapter 2, section 2, rule 33 of the Bar Council of India rules and section 126 of the Indian Evidence Act. And requesting the debarring the said advocate because I had made several communication with respect of the same subject matter.
I thought.
Then, my lord, he filed an objection and learned trial judge, though come to conclusion that he acted based on my instructions only on the ground. Kindly see the page number 120, the impugned order, para 14. The learned trial judge made elaborate discussion saying that, my lord, the said advocate acted based on my instructions and issued the legal notice.
Where is that page?
Page number 140, 120, my lord, para 14.
Yes.
I may be permitted. As per the provisions of the Bar Council rules, it is not permitted the advocate to give a legal notice on my behalf. Who is it?
Is it that, where is that Bar
Rules,
Council?
rules, my lord.
Bar Council rules.
Bar Council rules, my lord, part 4, rules governing advocates. Part 4, my lord.
sorry, part six rules governing the advocates. Part six.
Yes.
Then in that, my lord, the chapter 2, section 2, rule 33, your lordship.
Yes.
An advocate who has at any time advised in connection with the institution of a suit, appeal or other matters, or has drawn pleadings or acted for a party shall not act, appear or pleaded for the opposite party.
Yes. Heard. Issue notice. Stay of further proceedings in OS number 92 of 2021. Pending on the file of additional senior civil judge JMFC Madhur till next date of hearing.
Serial number 7, Sanjay Krishna V for petitioner, T. Sheshagiri Rao.
Is it not, it will not permit you to give a complaint to bar council?
But as per the instructions, he had already given a complaint also, my lord. But it's a disciplinary proceedings, sir. Here he may misuse my communications while
Yes.
conducting.
Yes.
My lord, seeking short
declaration.
Yes.
My lord, seeking short accommodation, my lord. Senior was out of station, my lord. They went.
Lord, the difficulty is matter is on the
Kindly have it,
24th.
it's on next week.
Wait, you have to see is urgency. If there is an urgency, caveator has no right for seeking an adjournment. If there is no urgency, I will grant it. Yes.
Lord, the difficulty is this. The matter is on the 24th. It was posted for defendants, 5th defendant's evidence finally. So at that, my lord, what happened before the trial court was, I am the 5th defendant. 5th defendant is before my lord. Suit for declaration and injunction. My lord, I have filed the written statement. My husband, that is the 5th defendant's husband, files an application. I want to lead evidence through my husband because if your lordship sees at the time of sale transaction at page
Order you are challenging?
application filed under order 3, rule 1 and 2 to lead evidence on behalf of the 5th defendant.
On behalf of your husband?
Wife, yes.
Yes.
What, section 120 of Evidence Act is very clear. Wife or husband is a competent witness for.
Have the knowledge of the case?
They have the knowledge. That is why I am drawing my lord's attention
Now, what is
to
that?
kindly take page 39.
Now, court is rejected your application.
Rejected my application. Saying that I have not assigned health reasons.
Yes, now what is the stage now?
Now stage is for defendant's evidence finally. That is for my evidence finally. If I don't lead evidence.
When?
The 24th, my lord.
No, you will undertake that you will not precipitate that matter. I will attend it.
Yes, ma'am.
Yes.
Yes, ma'am. Kindly register on 24th, my lord.
Precipitate. Yes. Learned counsel. You are the plaintiff, no?
Yes, ma'am.
Or one.
I am the final.
Serial number. Counsel appearing for respondent number 1, caveator. Praise time and undertake that you will not precipitate the matter before the trial court till next date of hearing. Yes.
Kindly register on 24th, my lord. 24th.
24th and 27th. Yes.
28th, my lord.
28th.
28th.
Yes.
Great.
Serial number 8, PC Sunita for.
Lord,
Yes.
I am the first defendant before the trial court, my lord. Plaintiff has filed a suit for recovery of the amount of rupees 44,35,000, my lord. In that suit, my lord, we are entered into an compromise, my lord. Compromise petition is filed, my lord. Order 23, Rule 3, Kilgadai, we have filed compromise petition. The decree was, compromise decree was passed, my lord. Thereafter, my lord, in the plaint, my lord, kindly see, my lord.
Where is that compromise degree, madam?
Compromise degree at Annexure C, my lord.
Yes, what is that degree?
Decree, my lord, claim for, my lord, is not proper, my lord, because since we are compromised only in respect of 44 lakhs 35,000, my lord. Here, my lord, claim amount, my lord, in addition to 7 sites we have purchased, my lord. That also was included in the compromise.
No, you have signed the compromise, is it not?
Compromise decree I have signed, my lord. Kindly see the compromise decree, my lord. Compromise petition, my lord.
You want to see that compromise. If it is compromised, you have agreed, it's end of the matter.
Please, my lord,
Now the execution.
oh, please, my lord, here, my lord, he has filed for recovery of amount, my lord. Now, my lord, executing court, my lord, has passed an order, my lord, for giving possession of the property, my lord. That is not proper, my lord. Since, my lord, once the register sale deed is
Who has filed an execution petition?
plaintiff, my lord.
Decree holder has filed.
Decree holder has filed.
You are a judgment debtor.
Please, my lord.
Now,
One
what is that order you are challenging?
I am challenging an order annexure H, my lord.
What is that?
Page number 93, my lord.
Annexure H.
Please, my lord.
ಎಲ್ಲಿದೆ annexure H? Annexure H ಇಲ್ಲ only G ಇದೆ.
Alla,
Last-
sorry, G net. Page number 93.
Page number
93, my lord.
93. What is that order?
Case called before Lok Adalat, the advocate for the decree holder has filed a memo stating that the special bailiff delivered the vacant possession of the decretal scheduled property to the DHR. Hence, in view of the said memo, the execution petition is disposed of.
ಏನು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಅಂದ್ರೆ
Disposed of ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ
because
ಏನದು ವಾಟ್ ಇಸ್ ದಟ್ ಮೀನಿಂಗ್ ನನಗಂತ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ನೀವ್ ಹೇಳಿ ಏನಂತ ಹೇಳ್ಬಿಟ್ಟು
My lord,
The
special
special
bailiff was appointed.
ಡೆಲಿವರ್ ದಟ್ ವೇಕೆಂಟ್
deliver-
ಪೊಸಿಷನ್ ಆಫ್ ದ
Possession,
ಪ್ರಾಪರ್ಟಿ ಟು ದ ಡಿಗ್ರಿ ಹೋಲ್ಡರ್
please,
ಪೊಸಿಷನ್ ಡೆಲಿವರಿ ಆಗಿದೆ
ಹಾ.
ಎಸ್ ದಟ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ವಾಟ್ ಎಲ್ಸ್ ಯು ವಾಂಟ್
my lord, since my lord, once the register sale deed was executed in my favor, my lord. I was enjoying the sale deed and I have pledged the sale deed before the bank, my lord. When that is so, my lord, when once the register sale deed is executed, my lord,
No,
the
what
court
is
has
that?
no power to cancel.
No, what is that?
Only
compromise
has to
degree.
recover, the remedy is open for
No,
recover,
what is the compromise degree?
compromise kindly. see.
In terms of that, you have to hand it over the possession.
In terms that handed over the.
Then what else that?
My
part
lord,
is-
the suit itself, the relief, kindly see the relief, my lord.
No, I'm
Kindly
not
see.
on that, madam. It is in a compromise degree. You both has agreed and signed. It is attained finality. You have not challenged. It's end of the matter.
I have not-
Execution has been filed to execute that. Court has executed. Now you are saying.
My lord, in the sale deed was not cancelled, my lord. Sale deed was in my favor, my lord. Only the possession was delivered, my lord. Possession is delivered, my lord. Even then, my lord, special bailiff was appointed, my lord. I sought for objections, my lord. Even
Yes, you take notice,
objection
please.
is also refused, my lord.
Yes, notice.
I sought for stay, my lord.
No,
Since
possession is already delivered. What?
Possession delivery agide, say register sale deed is with us, my lord.
ಇಟ್ಕೊಳ್ಳಿ ಅದಕ್ಕೇನಂತೆ ಅದಕ್ಕೆ ಸ್ಟೇ ಬೇಕಾ ರಿಜಿಸ್ಟರ್
ಹಾ ಅಂಕಲ್ ಸ್ವಾಮಿ ನಾನು ಅದನ್ನ ಪ್ಲೆಡ್ಜ್ ಮಾಡಿದೀನಿ.
Madam, position is already delivered. What you want to stay there?
My lord, register ಅದು ಕಾಂಟ್ರಾಡಿಕ್ಟರಿ ಆಗೋಗುತ್ತೆ ಯಾಕೆಂದ್ರೆ
Notice ಹೋಗಿ ಬರ್ಲಿ, then we'll see, yes. Now what can stay? It is already delivered the position.
possession delivery ಆಗಿದೆ.
ಮತ್ತೆ ಇನ್ನೇನ್ stay
Once-
ಮಾಡಕ್ಕ?
Once my lord,
Yes, yes,
sale
yes.
deed is
Yes.
Serial number 9, Ravi Shankar, yes.
Petitioner or the plaintiff before. They filed a suit for partition and separate portion. Defendant number 1 to 7 are the family members and 9 to 11 are the purchasers. After service of summons, suit for partition and separate portion. After service of summons and for filing return statement, I made an application under IR number 7 on 23/9/24, restraining the defendant number 9 to 11 not to change the nature of the property. Now they filed.
Change now.
Not
to
to
alienate.
alienate ಇದೆ ಅದಿದೆ ಅದಲ್ಲ. Not to-
Change ಅಂತ ಅಂದ್ರೆ ನೀವು ಕಲ್ಟಿವೇಶನ್ ಏನು ಮಾಡಬೇಡಿ ಅಂತ ಪಾರ್ಟಿಷನ್
ಅಲ್ಲಲ್ಲ, ಅದಕ್ಕೆ- ಅಲ್ಲ ಇದಲ್ಲ ಕಲ್ಟಿವೇಶನ್ ಅಲ್ಲ. They are changing, they are converting the sites. ಅದಕ್ಕೂ ಅಲ್ಲ
whoever succeed they will get it.
in a partition suit.
Partition suit ಅಲ್ಲಿ only relief that not to create third party interest.
ಅಲ್ಲ ಅದನ್ನ
Third party interest not to create ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ಈಗ ಏನಾಗಿದೆ, ನಾನು ಈ what I am seeking is IA is not decided now. I am seeking a direction to the trial court to dispose of that IA in a time bound manner.
Where is that IA?
Annexure C, my lord.
Page number 21.
Page number 21,
Who is that respondent?
9 to 11, my lord.
Yes. Issue notice. You want to take hand summons?
Seven.
Yes, in addition, petitioner is permitted to take out hand summons to the defendant, respondent.
Till then they should not change the nature of the property. my lord. That is-
You are seeking in a direction to dispose of IA, now you are seeing that, yes, you.
if you lordship may kindly direct the trial court to dispose of the
Therefore, You take in hand summons and move that matter, I will dispose of it. Yes, that's what I said, hand summons. You serve it, next day move that matter, we will dispose.
ಲೇಔಟ್ ಆಗ್ಬಿಟ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ ಅಂತ.
ಆಯ್ತು ರೀ, ಲೇಔಟ್ ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ it will
ಅಲ್ಲ,
be
that
that
is-
part of you. Tomorrow if you succeed, you will get that.
Agriculture land,
Just, stall that one of your family members is.
he is not a
developing-
family member, that is the reason why.
Yes,
He is not, he is a purchaser, that is the reason.
yes, you serve a copy and move that matter. Yes.
Serial number 10, Nataraj Baba.
One to
But if you develop also.
1 to 7, your last may can you dispense with note?
Huh?
1 to 7,
1 to 7 there, yes.
they are
notice
the,
to-
now the relief sought in the application is 9 to 11,
9 to
11,
Ah.
9, 10 and 11.
filed in a memo dispensation, dispensed, issue notice to 9 to 7, 9 to 11,
9 to
9 to 11, in addition, permitted to take out hand summons to 9 to 11.
Serial number 10,
Petitioner, my lord.
Present the council.
Yes.
Suit for declaration and injunction, my lord. But application for court commissioner to locate the properties has been rejected, my lord.
Suit for?
Suit for declaration and injunction, my lords.
Hmm.
My lords, we have contended that there in the portion of property,
Hmm.
there is a burial ground and tombs are located
Hmm.
in the suit shall A property. But my lords, the defendants, without verifying the records and without locating the property, they have purchased the land and saying that it is their property. But in the evidence, they have stated that where the tombs are located, that is in the different survey number. That is the reason why we have filed applications to locate the survey number and also locate the tombs where it is located.
Hmm.
That has been rejected on the ground that I am collecting the evidence. Kindly see page
is
85, my lords. That
Where
is
is
the
that?
DW3 evidence,
Page?
83, in page 83, 85, my lords.
Hmm.
DW3. ಸಾಕ್ಷಿಗೆ ಒಂದು ಫೋಟೋವನ್ನು ತೋರಿಸಿದ್ದು ಅದರಲ್ಲಿ ಗೋರಿಗಳು ಜೋಗಿ ಸಿದ್ದೇಗೌಡ ಅವರ ಕುಟುಂಬದ
Your
ಗೋರಿಗಳಾಗಿರುತ್ತವೆ.
application for appointment of commissioner,
Please, my lords.
where is that order?
Annexure A, my lords.
Hmm.
Annexure A page, reasons from page 22, my lords.
Page?
22, my lords.
Hmm.
Shall I read, my lords?
Yes, yes.
The plaintiff have filed the suit for against the defendant for relief of declaration and permanent injunction with respect to the suitable property. When the case was set down for the main arguments, at this stage, the plaintiffs have come up with the application seeking for appointment of court commissioner. That is the assistant director of land records, Kanakpura, to find out the location of the survey number measuring 25 and half guntas in survey number 137/1 of Nagarsukote village and to find out the tombs in the suitable property and the submit the report. As per the plaintiff case, they are the absolute owner and the possession of the suitable property. On the other hand, defendant contend in that both said already produced documents and also led evidence. There is no ambiguity in this case and there is no necessity for the appointment of court commissioner.
Hmm.
My lords, in the 10, para 10, my lords,
Hmm.
this suit for the suit, this is the suit filed for the relief of declaration and permanent injunction. It is a settled principle that the suit for injunction, the possession plays a vital role and the only factum of possession and interference can be taken into consideration. And the parties owns a burden to prove their possession through oral and documentary evidence. There is hence herein this case the plaintiff have sought for the declaration and injunction. They are the absolute owner and they are the possession of the suitable property. And they explain the differences from interfering with their peaceful possession and enjoyment of over the suitable property. It is pertinent to note here that the plaintiffs have alleged that defendants are trying to interfere with their possession. The possession of the suitable property of the plaintiffs, it can be proved by the oral and documentary evidence. It is settled principle law that the commissioner can be appointed for the collection of evidence.
Hmm.
The court commissioner will be appointed only when there is ambiguity in the evidence. There is a ambiguity in our case, my lords.
Yes.
And the evidence is such a nature where under neither the documentary or oral evidence would shed lights on these aspects because of its peculiarity. The question of right of the parties in the respect of the potential property cannot be delegated to the commissioner. Inspect and preparation of.
Yes, Mr. It is now that latest judgment said, even for evidence, collection of the evidence also.
Alla
commissioner-
collection, that is kindly, I have gone through it, kindly take that judgment, madam. Justice Anantaram Nagale. Just pass. Good evening. Anantaram Nagale.
Yes.
Kindly go to paragraph 13.
Paragraph?
13. At what stage?
1-3.
ಇದರಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಆಗೋಗಿದೆ. On facts also, he has no make, he will not make out the case. I will, because this judgment is referred to, I will read the judgment first. The next question is, at what stage of the proceedings in a suit, the application can lie? As could be seen, as could be easily noticed from the provisions, the provisions is not at stage entry. Thus, the provisions can be invoked either before the commencement of trial or after. If the application is filed before the commencement of trial, the court, having regard to the pleadings and records, may allow such application before the commencement of trial. For example, in a given case, if report necessary for consideration of the application seeking some interim measure, before the commencement of trial, the commissioner can be appointed. In a case made out for such appointment, other hand, again, having regard to the pleadings and record, if the court finds that there is a likelihood of that after the evidence of the party, the need to appoint a commissioner may not arise, that the court is of the view that it can call the application only after recording evidence, then it may defer the appointment commissioner till that time. The decision as to when the report is to be received from the, taken from the higher facts and circumstances of the case. Then kindly go to the 11th paragraph at para 20.
Yes.
Para B, I will read only para B. It is not that the learned judge did not say that evidence can be collected by the evidence. Para B is very specific. The discretion exercised on power 20 of the Code of Procedure is not governed by the form of the suit. The court can appoint a commissioner of any kind, provided a report of the commissioner and order 26 of the code is necessary for elucidating the matter in dispute.
Yes.
So elucidation comes in when there is ambiguity in the evidence.
No, that is what they are saying, that there is an ambiguity.
I will come to that. What is the ambiguity? I will come to that. Now kindly bear in mind, the suit is not in relation to what they say is application whether the terms are in existence under in the survey number 37/1 or 37/2. Either it is 37/1 or 37/2. Now the suit does not relate to 37/2. Kindly take the print.
Yes, we'll hear that. We'll hear, will you take notice?
Please, I have taken notice.
Yes. So and so. Is, you are taking caveat for whom?
Mr. Raju will take notice.
No.
1 and 2,
which-
1 and 2, 1 and 2.
1 and 2. Caveator is undertake to notice 1 and 2. Issue emergent notice to respondent number 3. Yes.
Stay, my lord.
Proceedings.
Because it is posted for final argument, my lord.
Will not come in the way of stay.
That's what that I.
No, my lord.
This issued, yes.
My suit.
Yes. Stay of further proceedings in OS number 188 of 2011. Pending in the file of third additional civil judge, JMFC, Kanakpura till next date.
Public.
Cell number 11, Nandish Gowda GP.
Lord, the writ petition is by the defendant number 15 before the trial court. Respondent is the plaintiff, my lord, filed suit for partition and separate possession. My lord, defendant number 1 to 14. Prior to the filing of the suit itself, my lord, they are already alienated the Schedule B property in favor of the defendant number 15. That sale deed also got called in question before the suit by the plaintiff. And during pendency of the suit, my lord, the plaintiff, my lord, entered into a compromise with this purchaser, defendant number 15, and she executed a confirmation deed in favor of the defendant. Annexure C is the confirmation deed. And consequently, my lord, she filed Annexure D, in page number 58, 38. Consequently, my lord, the compromise petition, my lord, the filed before the trial court. Compromise petition, now, my lord, in view of the confirmation deed taken place between, she has no claim against the item number B schedule property is concerned. Since, my lord, all the members of the family already alienated that property item number B in favor of the defendant number 15. But compromise petition, my lord, the trial court rejected, holding that, my lord, the partial compromise is not maintainable. The relevant portion, my lord, in page number 48. So, court come to the conclusion, it is permissible, but the plaintiff has to settle the entire claim. My lord, I am only concerned with the schedule item number B. In page number 48, my lord. In page number 48. I have heard the learned counsel for the plaintiff and defendant number 15. The Honorable Apex Court in case so and so has opinion that the partial compromise is permitted. The that partial compromise is permitted, the legal position may be true that in a partition suit, partial compromise is permitted. And there be more than one preliminary decree, but to such a compromise, all the parties to the suit must be present. My lord, all the parties, my lord, defendant 1 to 13 already executed the sale deed prior to the filing of the suit itself. Para 3. Recently, the Honorable Apex Court in Prashant Kumar Sahu and others and so has opinion that compromise by some of the parties is not permissible. My lord, it is not my case, my lord, it is by the sum of the parties. Means all the parties to the suit may be signatory to that compromise petition. In absence of all the parties signatory to the compromise, partial compromise, enter to the plaintiff and defendant number 15 is not proper.
Nobody is represented by other.
No, they are not pursuant to service of notice. They are not appeared, not filed any written statement also.
And unrepresented.
Yes, hence I have not.
Where is that confirmation deed executed by?
Confirmation deed, my lord, in page number 30, in page number 29, annexure C.
29. This
29.
is executed by whom?
By the plaintiff in favor of the defendant.
Plaintiff.
Defendant number 15.
Other defendants has executed in a sale deed.
Sale deed in the year 2000 and 2006 itself. That is.
Where is that sale deed?
Sale deeds kottilla nanu, but that sale deed also called in question in page number 22, kindly turn into, my lord. The prayer B, alleged sale deed 20th/4/2000 and 26/4/2006 executed by the defendant number 2 to 13 in favor of the defendant number 14 and 15 in respect of the plain schedule.
Now only the plaintiff has not executed. Now he
Yes,
has
they have executed a confirmation deed in my favor.
No, he has signed that
Yes,
compromise deed.
yes, my lord. I am concerned only with respect to schedule item number B only, my lord. And she
Yes.
wants to, by virtue of the, my lord, the confirmation deed.
Issue notice stay of further proceedings in OS number 2288 of 2021 pending in the file of third additional senior civil judge JMFC Bangalore, rural district Bangalore till next date of it. Emergent notice.
Please, cell number 12, Iremated Maheshaya.
Appearing for a petitioner. My lord,
Yes.
there is a trust existing for maintaining the business of the Kanika Parameshwari temple, my lord. The present petitioners are tenant under the trust, my lord. Thereafter, my lord, present respondent in the year 2008 in a registered one association in the name of temple and try to get the administration of the temple from the earlier association, my lord, and filed one suit, my lord. That suit is still pending. Again filed a criminal case, my lord, 2 criminal cases. The police filed B report. Thereafter, upon the.
Now, what is that you are challenging?
Now, the present respondent, my lord, filed eviction suit against the present petitioner, my lord. Present petitioner is tenant under the original association, my lord.
Which is that original association?
My lord, original association is, my lord, Kanika Parameshwari Temple Religious Trust, my lord. Now, the suit is pending regarding the owner genuinity of the trust, my lord, filed by the present respondent, my
Oh,
lord.
that,
Thereafter, the
you are
present.
running any business there?
Yes, my lord. Yes, my lord. Thereafter, present respondent filed a suit for eviction against
Why
the
it is in the
petitioner before the
commercial court?
commercial court, my lord.
Hmm.
Before the commercial court, suit for eviction, my lord.
Hmm.
I have filed my written statement, my lord. My written statement came to be rejected on the ground that the written statement filed by the present petitioner beyond the 120 days, my lord. My lord, the file kept in cancellation for the period of 41 days, my lord. I have mentioned the same, my lord. Kindly see the page number 6, my lord. I have mentioned the table, my lord.
Commercial court.
My humble submission, my lord, the period before the cancellation, my lord, that has to be excluded from the days of 120 days, my lord.
Provided where the defendant fails to file in a written statement within that period of 30 days, he shall be allowed to file in a written statement. As may be specified by the court for the reason to be recorded in writing and non-payment of such cost. Court deem fit, but which shall not be later than 120 days from the date of service of summons. On expiry of 120 days from the date of service of the defendant shall be forfeited. Now, this says
Yes,
from
my
the
lord.
date of service of summons.
Yes, my lord.
Where
Within
is that,
30 days.
which law says that it has to be excluded?
My lord, kindly see the page number, my lord, 6, my lord, and the table, what I have mentioned.
No,
my lord.
you see that rules, Mr.
Yes, my lord, 120 days, my lord.
120 days.
120 days, my
Hmm.
lord. My lord, since the file is in mediation, my lord, I am unable to file return statement, my lord.
See, rule says 120 days from the date of service of summons.
Yes, my lord.
If it is pending in that mediation,
Yes,
that
ma'am.
has to be excluded. Where is that? I am not finding anywhere that. You have to find out that which is that law which can be given for exclusion, Mr. You said from the date of summons 120 days.
120 days.
Then it's the end of the matter.
But, my lord, the
Court
days.
can't make any legislation and expanding that, Mr.
Kindly pass it over, I will submit one judgment, my lord. In
Find out
Delhi High
judgment
Court,
or any other interpretation of this.
in Delhi
provision
High Court, my lord, excluded the.
That you
period.
produce,
Please, pass it
the-
over.
when law question is there, you have to be, get it by the judgment, Mr. Yes, when do you want?
You will pass over.
Pass over.
Cell number 13, Chokka Reddy.
For the petitioner, my lord. The petitioner, the suit for permanent injunction, my lord. Filed IA number 1, my lord. The my lord, the petitioner is acquired the property 2001, my lord. 24 years from the petitioner is in possession of the property and paid, my lord, the up-to-date tax and current bill from the 2003 and ration card and the all the possessory documents produced before the trial court.
Yes.
But trial court records the reason. My lord, the plaintiff has made out not made out the urgency of the case, my lord, and peruse the documents.
Now suit for?
Suit for permanent injunctions, my lord,
Uh,
for not to interfere the position of the plaintiff.
what is
The
that?
plaintiff has acquired the property under register stage 2001.
What is that urgency for you that?
Urgency, my lord, there is a photos we have produced. The defendants are, my lord, they are trying to interfere in my position.
Where is that?
That is the photos we have produced annexure J, my lord. Earlier, the sheet house in the construction from 21 years, my lord.
Yes.
That is the current bill, my lord, from the 21 years. I have produced from the sanction of the power,
These are directed.
2003, my lord.
Status quo in
My lord,
respect of
status co, my lord,
and scheduled
it
property.
will affect the parties, my lord.
Then you take notice, then we'll hear. We don't know what is.
They did not appear before the trial court, my lord.
No, you take hand summons
It
here.
is the prima facie documents we have produced, my lord, the sale deed or the kata, tax, the current bill and ration bill, all these things.
How do issue notice? In addition, petitioner is permitted to take out hand summons to that respondent. Yes. You take hand summons and move that.
Cell number
And
14.
status quo may be maintained, my lord.
You said
I
you
will-
don't want, let it be.
Yes, please. I will serve the copy
You serve and move that, then we'll see status.
by
quo.
hand summons, my lord.
Yes, hand summons.
Cell number 14, Ravi Shankar for petitioner, Balakumar.
My lord. Yesterday matter, my lord.
Yes, why it is urgent yesterday?
At my request, it is urgent to today.
Yes.
Only to inquire regarding the death certificate, what they have produced in this proceeding. My lord, this is a suit for.
Just give brief facts.
Just I will.
My lords, the suit filed, suit for bare injunction, my lords,
Yes.
concurrent finding on the interlocutory application filed under order 39, rule 1 and 2. The defendant plaintiff
No,
had
both
succeeded.
court has, yes.
Please, my lords.
Then
That
what is
the-
that point he has made out to Ravi Shankar yesterday?
My lords, the death certificate, my lords may kindly see. Yesterday we had produced certain documents, my lords. My
Yes.
lords may kindly see page number 20, my lords, in the documents produced.
Yes.
The property was purchased by, my lords, I have document number 2, my lords, initially, page number 3, my lords.
Yes.
Document was purchased by Mallegoda,
Hmm.
father of defendants, my lords. Now the grandfather of the petitioners
Yes.
before, my lords.
Yes.
Purchased by Mallegoda on 8/11 to 1969, my lords. My lords, Mallegoda dies, my lords, on 22/10/19.
No, he said that when Malagoda was
Yes, yes.
alive
I-
itself,
that's
there
why-
was a partition.
Please, my lords.
No-
Ink page number 20, my lords, 22/10/1990 is the date of death of
20?
Mallegoda. Page number 20, my lords.
Page number 20.
He
Yes.
died on 22/10/1990, my lords. My lords may.
1990.
Please, my lords.
They
My lords
said
may now-
2000,
1982, they say that there is a partition deed entered into between father of the respondent, Shivegoda, that is the plaintiff before the trial.
and
court.
Jayamma.
Jayamma, wife.
What
of-
is the date of partition?
My lords, 82. my lords.
5/10 to 1982.
1982.
5/10,
1982.
1982.
82. At that time, that Malagoda was alive.
Please,
That is your case.
please, my lords.
Ah.
And also they had major sons.
Yes, now that, on that basis, you are claiming
that's
an.
the
Yes,
thing.
my lords. My lords,
My lord-
kindly see.
Now I
along with-
understood that. Yes.
My lord, if you look into the partition deed dated 5/10/1982, page 35.
ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ?
ಅವರೇ ಈಗ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ, ಅಂದ್ರೆ ಟೈಪಡ್ ಕಾಪಿನೂ ಹಾಕಿದ್ದಾರೆ, ಅದನ್ನು ಹಾಕಿದ್ದಾರೆ.
35.
ಪೇಜ್ 35 ನಲ್ಲಿ
ಹ್ಮ್.
ಟೈಪಡ್ ಕಾಪಿ ಇದೆ.
Yes,
ಆ ಸೆಕೆಂಡ್
yes.
ಆ ಸೆಕೆಂಡ್ ಲೈನ್ ಅಲ್ಲಿ ದಿವಂಗತ ಮಲ್ಲೇಗೌಡರ ಪತ್ನಿ ಜಯಮ್ಮ ಮತ್ತು ದಿವಂಗತ ತಿಮ್ಮೇಗೌಡರ ಮಗ ಶಿವೇಗೌಡ. ಅಂದ್ರೆ 1982 ನಲ್ಲಿ ಮಲ್ಲೇಗೌಡ ವಾಸ್ ನೋ ಮೋರ್. ಪಾರ್ಟಿಷನ್ ಎಫೆಕ್ಟೆಡ್ ಬಿಟ್ವೀನ್ ಜಯಮ್ಮ ಅಂಡ್ ತಿಮ್ಮೇಗೌಡ. We have filed.
Yeah, that is what.
That's the thing. I will take this lordship to the death certificate, my lord, page 20. Now they are relying upon it.
Yes,
Lordship,
Not now, my
before
lords,
the
it was
trial
all
court,
placed before the trial court.
yes, yes.
this document is not placed before the trial court.
Yes, let us see now.
Your lordship, kindly look into this document.
Yes,
Death certificate dated 22/10/1990.
yes,
This certificate is obtained on 5/2/2018.
yes,
This is issued by the village accountant.
yes.
A competent authority is the Talsildar or the medical officer of the each taluk in the revenue belt. Not the village accountant has no authority to issue it. No seal, no it is not an authenticated document.
You are disputing this.
Definitely I am
You are
disputing it.
That you are disputing this.
I am disputing that this document is produced only in this
That's
proceeding.
original, madam, this.
Eh, eh.
Because
Who will?
in that document says he is dead.
Yes.
In the
Please, my lords,
hearing
that's
meeting.
why we are saying that this is a fabricated document, my lords.
Now that this is, where is that original? Now they are disputing this.
My lords, this is the test before, my lords, now we have filed a suit for declaration also, my lords, before the trial court. My lords, may kindly see that.
No,
the
now
document-
I want that, where is this original of this?
Please, my lords, I will secure the original and produce my.
Produce
my
that.
lords.
That is
Please,
what,
That is the only point.
At such time, let us,
Malagoda has been,
please, my lords, this is issued
that
by,
person is in a dispute here.
That is the thing.
please, my lords, this is issued by Registrar of Births and Deaths, my lords, not somebody. My lords may kindly see.
Yes, yes.
Online copy, my lords,
No, you
QR
pro-
code is available. My lords may kindly.
Yes, all is there. You produce that original.
See this. My lords may kindly see. Register, Chief Registrars of Births and Deaths.
Yes, yes. No, that
QR code is also there.
documents which appears to be in the format, but you want to see that original.
Please, we will secure, my lords. Till such time, my lords, they are.
Good. Then death certificate is the ultimate.
That is the
documents
truth.
to-
Definitely, my lord. That's why, that's why it took time, because in the death set, in the partition deed, all the joint family properties.
You are able to produce any death certificate that he has died on 1980.
That's, I will also get it in
they
fact,
have
because
not produced.
in the
My
return.
lords, along with that, my lords,
may
may
make
kindly
one
see, because this is also an
No, madam.
fabricated documents. One
If you,
second.
no, I understood everything.
Please, my lords.
If you produce that original,
I will.
definitely that is an.
That is the thing, my lord.
My lords, my lords,
Because he was not dead as on that day when that, that is the only crucial.
In fact, in the return statement.
But my lords may kindly see that apart, my lords, may kindly see page number 1, family tree that we have produced, my lords. This they cannot dispute. My lords, Timmegoda, the father of Mallegoda and, because Mallegoda and Shivegoda are stepbrothers, my lords. Timmegoda had 2 wives, Achamma and Timmamma, my lords. From Achamma, Timmegoda had 4 children. And Shivegoda was the only son of Timmamma. Well, though in
All
case,
that-
if we agree that the daughters were not considered for division, Timmegoda had one more son, Sagnegoda, Mallegoda. They cannot now,
No,
they.
that is different. First, Malagoda himself is not dead.
Yes.
Then that is an.
Yes, my lord.
That is the thing, my
And
lord.
along with that, my lords, Timmegoda.
No, there is no further argument.
Please,
You
please,
produce
my
that.
lords, till
Okay.
such time, let them not disturb my possession.
Well,
because the
from
defendants are in
From
possession.
1982,
We'll have it on tomorrow itself. You get the documents, then I will
Because
pass
I
it on.
need to secure from Hassan, my lords.
Yes,
that's the reason.
Monday, Monday. Yes,
Till,
please.
let my lords may direct them,
No,
though I
because
not,
From when that injunction order has been rejected,
the injunction has been granted in my favor, my lord.
it is concurrent
it is
finding,
favor in both the court.
Both the courts, my lord.
Yes.
concurrent finding. my
Based
lords.
upon the,
When it is granted,
My lords, 25/10/1982, my lords. 2022, my lords, the
2022.
22 and
Last
16/11/24.
4 years that order is in operation.
Yes.
4 days, nothing will happen.
Much.
Yes. On Monday.
Please, ma'am.
Yes.
Till number 15, G. Balakrishna Shastri for petitioner.
Lord, the
Yes, Mr.
plaintiff, my lord, is the petitioner before lordships. My lord, annexure A is the order. An application for amendment of the plaint filed by the petitioner plaintiff is rejected by the declarant trial judge.
What is the suit for?
My lord, suit is for, my lord, declaration of title and for mandatory injunction directing the defendant to deliver possession.
Yes.
That, my lord, is the suit.
What is that amendment now yours?
Amendment, my lord, is the first defendant's name is shown as Rehana Bhanu. I also want to add an alias name, Rehana Khanam, because in some title deeds, my lord, her name is shown
No,
as.
only one card.
That is one aspect, my lord. Second, how my title is flowed and how the defendants have no title. These facts are sought to be stated. That is, I mortgaged the property in the year 2002 to the second defendant. Second defendant, my lord, without authority, sells it, my lord, in favor of one Ramanjanappa.
Yes.
Then Ramanjanappa sells it, my lord, in favor of one Mobin Taj.
Yes.
Mobin Taj sells it to the first defendant. Thus, I say, my lord, first defendant has no title. Original owner is myself. I have only
Then why
created
it is-
mortgage.
Why it is rejected?
Case is posted for defendant's evidence. Therefore, my lord, the trial court has rejected. But your lordship says, my lord, I was not cross-examined. I filed chief marked documents. They did not, my lord, cross-examine.
No.
It was posted for defendant's evidence.
What is the reason you have given for a delay in that application?
The delay, my lord, the one is, my lord, he is illiterate, my lord, belonging to weaker section of the community. These various particulars, my lord, relating to what of title, my lord, were not, my lord, within his knowledge, my lord. And now, my lord, he is advised to seek this amendment. Now, my lord, he is not adding any prayer.
No, no, that's,
Yes,
there are three things.
yes,
If you are not adding anything,
yes.
there should be also see that why it has not been raised in the first instance if it is available.
True.
That has to be also seen.
True.
Then whether it is relevant to that case or not.
No, my lord.
Unnecessary, we can't go on.
Now, my lord, it is like this. Now, my lord,
No,
in spite of
relevancy,
these amendments,
no, relevancy is there.
yes.
Now, only thing is that 7 years, why you have not taken this contention when you have filed a suit? That is what that have you explained in that application.
Now, my lord, your lordship says, my lord, in the IA, your lordship says, my lord, annexure D, my lord, is the application filed.
Annexure. D.
Annexure D, my lord, page 32, at page 35.
Heard, issue notice. Stay of further proceedings in OS number 103 of 2014. Pending in the file of Principal Civil Judge JMFC Gauri Bidunur. Till next date of hearing.
Please.
Till number 16, Manjula T.
Suit for partition and suppression, separate possession filed by the petitioner hearing.
Yes.
Petitioner is the mother and the respondents are the children. In the said case, my lord, there is an interim injunction granted in favor not to alienate the same, my lord. In the meantime, after granting the interim injunction, we tried to enter the property. We have been restricted by the respondents not to.
No. What is that injunction order granted?
Not to alienate, my lord. Only
Not to
with,
alienate.
yes, my lord.
Hmm,
Only with,
that's-
but the thing is, it was only for not to alienate. There was no condition to enter or enjoy the property, my lord. When we tried to enter the property, we have been disturbed and we have been restricted to enter the property. On the same, we have filed the application seeking the police protection to enter in the property. The same was registered on the ground that as there was no earlier proper order in regarding the this point of entering the property, enjoying the property, same was dismissed, my lord. Hence, we.
You file an application separate there. You are in a partition suit. You are also in a plaintiff or a defendant. You can file an
Already
application
eligible
there.
86.
No application relief is only not to hereby restraining from alienating the suit.
Yes, ma'am.
Last time.
I agree, my lord.
Then
But
it-
the thing is, we not able to enter the property. One point, my other point, my lord, 86, my lord.
They are, if you are in the possession, they are trying to interfere or you are not allowed to interfere. You file necessary application there.
It's indirectly saying like, we need to fight out with the,
Or if they
mother
are
need to fight
taking
with
this
the children's, my
footage-
lord. It's a little bit disturbing fact, my lord.
Now, what is that order you are challenging? Annexure?
Annexure F, my lord, at
Annexure?
F, page number, annexure E, page number 56, my lord, on internal page number 23, my lord, orders on IA number 7.
56,
Yes, ma'am.
Yes.
Orders on IA number 7, connect,
Director defendant to give, not to give trouble to the plaintiff defendant to.
the conclusion part is at 25, my lord.
Yes, that's all.
Yes, my lord, and the same in the meantime, if may be permitted to enter the property without the restriction of the respondents, my lord.
Present application is not mandatory on the law, but.
Considering the senior citizens' age, my lord, maybe,
No, that you have to file application. Here we can't tell.
may be taken up for the early disposal if possible, early disposal, my lord. I'm also
Early
seeking for the
disposal
prayer
is
of
the
early
suit is
disposal.
in the preliminary stage, Mr. Kali.
Yes, my lord, it's on the 2020, my lord. It's already 4 years old, my lord.
Yes.
She is 86, she may live for further some very
No,
little
that-
time period, my lord. Hence maybe,
That latest Supreme Court directions. High Court should not give a direction to the trial court to dispose of the suit. Yes. In this petition is filed by plaintiff challenging order dated 24/11/2023 passed by senior civil judge JMFC Tiptur on IA number 7 filed in OS number 42 of 2020, whereby application filed by the petitioner plaintiff under section 151 of CPC has been dismissed. Plaintiff has filed in a suit for partition. Along with that client, he has filed application under order 39, rule 1 and 2. On his application, trial court has passed an order restraining the defendant from alienating the suit scheduled property till further order. During the pendency of the suit, plaintiff has filed this IA number 7 directing the jurisdiction police to give a protection to the plaintiff to enter suit scheduled property. Since direction, since order passed by this court is only directing, order passed by the trial court on application under order 39, rule 1 and 2 is only to not to directing that defendant not to alienate the suit scheduled property. There is no injunction order the plaintiff or the defendant shall take yield of the crop from the suit scheduled property. Neither the court has restrained anybody from doing so. Therefore, relief sought in that application filed, application number 7 filed under 151 of CPC cannot be granted. The trial court has rightly rejected that application. There is no error or illegalities in order passed by the trial court. Hence, it is dismissed.
maybe dispose of expeditiously, my lord.
Yes, trial court is directed to dispose of the suit as expeditiously as possible.
Much of it.
Yes.
Bill number 17, Karumbaya TA.
My lord, defendant's petition, my lord.
Yes.
The plaintiff had filed a suit for partition and separate possession of 2/9 share, my lord.
Yes.
After part cross-examination, the matter was posted for further examination, my lord.
Yes.
The defendants could not appear due to some health reasons, my lord. So now the case is posted for defendant evidence, my lord.
Yes.
We filed IA number 5 and 6 for recall and for recall of the order, my lord. That was rejected.
Very
Kindly look at page 42, my lord, which is annexure F.
42. Yes. Page 5, IA 5 and 6.
Yes, my lord. No, that is in annexure C, my lord.
Yes. Which is that IA?
One is for recall,
IA number
5, my lord.
5.
And IA number 6 is for reopening the case.
You read that order.
Annexure C, my lord.
Yes, yes.
ಈ ಕೂಡ ತಂದಿರುವ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಹೇಳಿ
Wait. There you are reading.
Annexure C, my lord.
That is the impugn order. Annexure C na. Page number?
Page number 28, my lord.
No, not that application. Order.
Order is at page 42
Yes, that you read.
from 2019, my lord.
No, which is that impugn order, madam? It is under page 37. Order on IA number 5 and 6. That is that order you are challenging.
My
25/9/2024. No, that is not that order. Which is that order you are challenging?
Page numbers might have been mixed up, my lord.
No, where is your order, madam? Impugn order. Which is-
Annexure E.
Annexure?
E, my lord.
Annexure E is that application.
My lord, I think the page numbers are, there were 2 writ petitions filed, my lord. One is for IA number 5 and the one is for IA number 6.
No, today it is posted on,
IA number,
which is that matter? You have to tell, madam.
my lord, I think 32361 is for IA number 5.
This is IA number 6. Where is that order? You verify and.
Yes, ma'am.
Yes. At the request, leave this matter next week.
Tomorrow, my lord.
Yes.
Bill number 18. Patil Bharati
I'm-
Tammanna Gowda.
I'm the petitioner in this case, my lord.
Yes.
In the original suit of the OS 13/17 in Davangere, the respondent has filed for the partition.
Hmm.
There is mentioned the schedule B, C, D, all these things.
Suit for partition.
Partition, my lord.
What is that order you are challenging?
That is IA number 40
What is that?
at the page number 13.
13. Yes, who has filed this IA? Plaintiff,
By the
amendment.
amendment
What
by
is that
the
amendment?
plaintiff
Now
of that.
they are seeking.
Further, some of the, after the cross-examination, at the stage of cross-examination,
Hmm.
he is coming with these E, F, G and H properties
Hmm.
and made an amendment,
To include that property.
include that.
Hmm.
It has been allowed now. In this case, what are the ancestral property? It has already been partitioned, this one, share is given to this respondent here. For all the 2 children, male childs and 1 female, all the 3 parts. 1/7 share what he got from the
No, that is not the issue here.
my lord.
Here he has filed an application for inclusion of other properties.
Yes, my lord.
What is wrong in that?
Those properties not the ancestral properties, my lord.
You file an objection and deny.
There
that-
we have filed and everything it is there.
No, after amendment, you can take in a contention that this is not in a joint family property. Is it if it is self-acquired property? That will be decided by that issue. He has to prove that it is a joint family property. You have to prove that no, it is your self-acquired property. But law is that all properties of the joint family properties has to be included in the
Yes, ma'am.
partition. That
I
is
agree
not-
for that.
By including itself, it's not that all property is a joint family.
Yes, ma'am.
It has to be proved.
Yes, ma'am.
Yes, what is wrong in that? Let him prove that.
But one thing, here what is that, this one, is the parted portion which I got, in the petitioner.
Hmm.
In his share, he has come and staying there and obstructing because he is the father at the age of 82. There is one writ petition 15373 of 21. It is pending in this High Court only. For vacating, in this OS, he has taken an order. He should not be evicted from that house.
No, in this case, what is you are challenging? What the
Challenging
amendment?
this unnecessary to drag the matters. It's been included one after another.
No, even at the stage of final degree proceedings, that property can be included.
Then kindly be permitted to early disposal of this case because of the 17
Now, what
and
is
the age
stage
of
now?
the petitioner is 82.
Now, what is the stage now?
It is for the cross it was there and there was a part of the crosses also they have done.
Petition is filed by defendant number 1, challenging order dated 6/8/2024, passed by First Additional Senior Civil Judge JMFC Davangere on IA number 40, filed under Order 6, Rule 17 in OS number 13 of 2017, whereby trial court has allowed that amendment application. Plaintiff has filed in a suit for partition and separate position. When the matter is posted for evidence,
Yes, ma'am.
the plaintiff-
Evidence is over only on the cross.
Yes,
When the evidence is over, then he is coming with this.
after the completion of the evidence, plaintiff has filed IA number 40, seeking amendment of plaint to inclusion of some of the properties as some of the properties in a suit schedule. In suit for a partition, all joint family properties has to be included in the suit. If the defendant has any grievance that it is not in a joint family property, he can take in a defense while filing in a written statement.
We have already filed the objections and also the return.
Now, after amendment, you can file. You have a right to file. Yes,
That also we have done, ma'am.
yes, yes.
And
Therefore,
one
by
submission, madam.
Allowing that amendment application, it will not cause any prejudice to the rights of the defendant petitioner. Therefore, there is no error or illegalities in the order passed by the trial court. Accordingly,
My lord, one submission. Early disposal get 2-3 times it has been ordered from this court that they have not obeyed in the lower court.
yes,
And now taking the advantage of that one,
ಇಲ್ಲಿ ನೋಡಿ ಇಲ್ಲಿ this is an IA number 40.
yes, my lord.
ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ ನೀವು ಒಬ್ರೊಬ್ರೆ ಹಿಂಗ್ ಐ
ಇಲ್ಲ ಅವ್ರು ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಎಲ್ಲ we are not filed anything, sir.
Yes.
He only has to drag that
No, that property is in whose possession?
possession. It is already, because it is of the, not the joint property, self-acquired, that has been sold. Their names are also included here.
It is property is in your possession or his possession?
No, nobody, sir. Either of this or this one.
Then who is cultivating this property now?
No, that is the, this one, houses, buildings, this
Who
one.
is there in that building?
The purchasers who are this one, for them, they have made a parties.
You are a purchaser or a?
No, I am the original, this one.
Yes,
I am the father of
Ultimately-
this petitioner who got 1/7 share
yes.
from my property in 1957 itself.
Yes.
Whatever I had, that has been parted to them, share. It is done.
By delaying, plaintiff will also not get any relief because enjoying by that purchaser. Therefore, you can't say that he is.
No, that we are not objecting, my lord. Our question is, only thing is,
Yes,
which,
hence dismissed. The trial court is directed to dispose of the suit as expeditiously as possible. Yes.
time, sometime within 3 months like that.
No, time
Kindly
can
have
be
it.
fixed. There is no such a direction to the trial court to fix. You are already, there is a 2 times direction has been given. Still they are not obeying. What to do? Because of this application. Let us see. Yes.
Much.
Office objection, first time matter, serial number 19, Somashekara ARP.
Yes.
Minor office objection, my lord, I will comply, my lord, because of urgency, my lord.
Nature of the representative of the
Okay,
respondent.
That's point number 2, my lord.
Original certificate of so and so. Yes, you comply that pass off.
My lord, no wonder I will comply, my lord, because of urgency, my lord, subject,
Pass over, you comply it, yes.
Serial number 20,
that is not the
Vishwanath.
nature ಬೇಕಾಗುತ್ತೆ ಈ ಹಾಕೋದಕ್ಕೆ.
Then you will have it,
ಅಲ್ಲ, the attachment of movables ಇದೆ.
no, only office objection is complied. Even if it is not complied, I will pass over and complying. If there is an urgency, I am taking the matter. Without compliance, if that required for that signature of the parties, can I take this, Mr.?
Tomorrow, my lord,
Yes. Please this matter tomorrow.
I may permitted to comply. with the-
Yes. In the meantime, petitioner is directed to comply that office objection.
Serial number 20, Vishwanath NS for petitioner.
May not kindly pass it over. I engage senior counsel.
You have to comply office objection, court fee.
Please to pass it over.
Please to pass over.
Serial number 21, Shauri HR.
Office objections are complied, my lords. Actually, court fee is also paid, jurisdiction is also stated. I think respond number 6, the pin code on ಬರ್ದಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ ಇದೆ. That
Supervisory jurisdictions to be stated.
yes,
Better copy of the annexure D, typed copy of the furnished all manuscripts.
that I have done.
Photocopy of annexure G is to be furnished. Copy of the objection IA to be filed before the court. Any objection has been filed.
Yes, my lord, that is all given.
Copy of the order of the FDP 36 of 2010 is.
No, 21, I don't think there is any FDP. my lord.
Copy of that order in that FDP. As
I don't know.
serial number. Serial number?
21.
Yesterday serial number. 21. 4. ಯಾವ್ದ್ರಿ ಇದು ಬೇರೆ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀರ ನಂಬರ್ ರಾಂಗ್ ಆಗಿ ಪುಟಪ್ ಮಾಡಿದಾರ್ರಿ 4880 ಆದ್ರೆ 4480 ಹಾಕಿದ್ದಾರೆ ರಾಂಗ್ ಫೈಲ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪುಟ್ ಅಪ್ ಮಿಸ್ಟರ್ ಅದ್ ನೋಡಿ 23 ಅಲ್ಲಿ ಅದಿದೆ ಮೋಸ್ಟ್ಲಿ ಹೆಚ್ಚು ಕಡಿಮೆ ಮುಂದೆ ಮೇಲೆ ಕೆಳಗೆ
Serial number 21, Shauri HR.
Only 3 of his objections were there, my lord. So that also have completed.
Proper
Only one pin code ಬರಿಬೇಕು ಅಂತ ಇದೆ ಅನ್ಸುತ್ತೆ. That is
court
only.
fee has been paid.
Yes, my lord, much before I have paid.
Yes. Yes, what is this? Serial number?
21, sir.
21, yes.
My lords, this petition is filed, my lords, assailing order at annexure A, my lords. In this, my lords, it's a suit filed by 4 strangers, my lords, seeking a declaration that the suit schedule property belongs to the Waqf. And Waqf has not come before the court.
Yes.
My lord, the masjid has not come before the court. No authorities have come before the court. They have given some representation. They have not acted upon. Hence, 4 individuals have filed this suit. There is an issue on maintainability also.
Where is that suit?
My lords, annexure, lordship will get the plaint. My lords, at page, my lords, 104. Annexure C. My lords, is the suit.
Yes.
5 individuals.
What is that prayer in the plaint?
The series of prayers, my lord, but the lordship will prayer at 114. Declare the suit schedule property, the Waqf property, directing different number 5 to change the entries in the revenue records pertaining to suit schedule property from so and so to so and so.
I think they have to go, if there is any dispute as to tribunal, they have to go to the tribunal.
They have. This is before Waqf tribunal only they have gone, but my
Oh,
only
this is a Waqf
Waqf
tribunal.
tribunal, my only concern is
Where is
Waqf
that
has
order?
not come.
Where is that order of, order which you are challenging?
Annexure A, my lord, so lordship. In that, lordship will get it at page 20. This is, my lords, I am the contesting respondent, defendant number 9. I had cross-examined PW1 in part. PW1, my lord, for everything I don't know, I don't know, is the answers given. I had to elicit because if the decree is passed, I will lose the land.
Yes.
I have been cross-examining. Yes, there are certain adjournments taken. Every adjournment below 5,000, 10,000 costs are imposed. In this, on this application, Lords, when we filed this application, the tribunal has suggested that you undertake that if the witness is present, you will cross-examine.
Yes.
I undertook. Then, to keep the witness present, the matter was adjourned. In the meanwhile, there's an objection, and the orally things have transpired. 2 dates were adjourned for keeping the witness present. Then the counsel for the plaintiff suggests that let there be an order, then we will keep present. Then the order comes rejecting my application, my 2 grievance, my lords. One is that the observations are made, if such applications are filed, complaints will be made to High Court and Bar Council. And secondly, my lords, we have genuinely stated reasons for our inability to come.
Rejected. 23 and 24 for what?
For recall and reopen.
Yes. Now that
That is
What is the
rejected,
notice of the
and I have to file now application even to lead my evidence because it is posted for argument.
Yes.
With that threat, sword hanging on my head, my lords, I have to make that application. So even now that witness partly cross-examined. And he says that in the cross-examination, he says that he has been set up by previous member of the.
Your application 23 and 24.
Yes, my lords. Lordship may kindly see annexure. My application, my lords.
Pray this honorable court please to reopen the stage of permitting the defendant number 9 to further cross. You want to further cross examination of defendant?
Yes, 133 is
Why
my
it is
application.
rejected?
My
Already
lords,
paid.
but that's what my only concern is this, my lord.
Yes.
Yes, there are last
you said
2
it
times I
after-
could not cross-examine. I was held up in High Court. I have made a request. When I was present, the witness was not there. All this has happened. There were
Yes.
costs imposed. I do concede, my lord. But my humble submission is,
Yes.
my lords,
Appearing for whom, madam?
for state.
For statement.
You will take notice to whom?
Yes, ma'am.
Government advocate is directed to take notice for.
I think 1 to 4 they can take.
1 to 4. Counsel for the petitioner is directed to serve 3 sets of copies on government advocate, issue emergent notice to 5 to
13.
5 to 13. Day of further proceedings. In OS number 10 of 2018, being in the file of Karnataka Work Tribunal till next date of hearing. In addition, petitioner is also permitted to serve a copy on the counsel appearing for. No, they're all. No, only
Those who
that-
are representing, my lord, I think.
only plaintiff is the necessary.
Yes,
Who are the plaintiff?
plaintiffs, my lords, starts from 9. 9 to 13 are the.
All other are the your defendant. That
All
you
others
can-
are-
You can dispense.
Yes,
Permitted to serve a copy on the counsel appearing for the plaintiff respondent before the work tribunal.
9 to 13.
Yes. 9 to
Much.
13. Yes, submission is accepted. Office objection is overruled. Yes.
Serial number 22, Sridhara K for petitioner, MH.
Okay, for petitioner, my lord.
Here for the caveat respondent for 20, madam.
Kindly have it 24th, meanwhile you serve the copies and comply the office objection.
Yes, pin code. In the meantime, he is directed to comply office objection. Other. Yes.
Kindly have it 24th, my lord. Trial court at 25th. is there.
Serial number?
22,
22, my lord.
Yes, you are, who is appearing for Sridhar K?
Yes, my lord.
You are appear, yes.
I appear
for the caveat respondent number 20. You want to, time to comply office objection?
Yes, my lord. Within 2 days we'll comply the office objection.
Yes.
Kindly post it for 24th.
2 days time is granted to comply office objection. Yes.
serial number 23, Manjunatha MH.
Lordship, appearing for the petitioner, your lordship.
Yes.
Minor office objections, your lordship. There is urgency because
Supervisory judicious to be stated.
Ah.
Better copy of the annexure
D is a Khata certificate issued by the BBMP, your
is
lordship.
to be furnished for all. Photocopy of the annexure. Copy of that objection IA. Any filed before the court below to be stated.
No objections has been filed.
Copy of the order in FDP 36 of 2010 has to be.
Your lordship, here that is not the question, your lordship. The question is with
Is
regard
that,
to,
36,
your lordship, a suit has been filed against me, your lordship, that is,
better copy of the annexure, supervisory jurisdiction. What is that you have stated?
Your lordship, suit for declaration challenging the judgment and decree has been filed by the petitioners, your lordship, in the trial court. Your lordship, for a moment, your lordship, CLD dated, your lordship, annexure C in page number 52 may be taken.
Suit- What is that suit for?
Declaration, your lordship, challenging the judgment and decree, your lordship.
You are the plaintiff.
Please, your lordship.
Yes, suit for declaration.
Declaration challenging the judgment and decree which has been passed against me in my absence, without my making me as a party in the suit. Among the respondent themselves, they have filed a suit for partition, your lordship, which has been challenged. Your lordship, the sale did, the date of,
Oh, what is that order you are challenging here?
your lordship, stay of the suit, your lordship. I'm challenging stay of the suit, your lordship.
What is that? What application you are
Oh,
filing?
your lordship, annexure B is the application I have filed, your lordship.
No, where is that impugn order?
Impugned order, annex 107, your lordship.
107.
Your lordship.
This is the suit filed by?
This is the suit
decreed.
filed by the petitioner, plaintiff.
It is decreed.
Your lordship, suit earlier for a moment, your lordship.
What is that you are challenging here? Mr.
Your lordship, judgment and decree,
That order passed in that second additional annexure K. What is that annexure K?
annexure K is the impugned order, your lordship. 151 application I have filed, your lordship. To say the
151,
suit.
Stay that operation and execution of the judgment and degree dated pending disposal of the suit. Pending disposal of the suit on the entry, suit dismissal.
Illa, for a moment, your lordship. Your lordship, annexure E is the judgment and decree for a moment, page number 70, your lordship.
Hmm.
Your lordship, the suit among the respondents filed, your lordship. Dated, your lordship, institution of suit is 11/6/2007. It is in page number 71, your lordship. Your lordship, prior to this, your lordship, I have purchased the property. My name has been referred in this suit, your lordship. In page number,
I to you are
my name as a, this
party madane suit degree ಆಯ್ತು.
decree ಆಯ್ತು, ನಾನು against ಗೆ. I filed a suit because immediately court commissioner ಬಂದ್ರು. I came to the knowledge about the suit. I challenged the judgment and decree
Where?
in the OSC, your lordship, in the very same court.
Which is your suit?
Your lordship, my suit is annexure A, your lordship, 6695 of 2022.
Where is that plaint?
Your lordship, annexure A is the plaint, your lordship.
What is that relief you have sought? Declare that.
Your lordship, to declare that in page number 32, your lordship, to declare that the judgment and preliminary decree passed by the Honorable City Civil Judge in OS number 4415 of 2000 dated 3/11/2009 is bad in eye of law and not binding on the plaintiff. In page number 32, your lordship, is the prayer.
Page number?
32, your lordship. Along with that, your lordship, I filed a application under order 39(1) and 2, also seeking the restraining for the respondent from interfering of the property, and also, your lordship, stay of the suit, because they are proceeding with the final degree proceedings, your lordship.
No, why you want to stay of the suit, mister? You
Your
have
lordship,
suit, stay of, you want to seek for a stay of execution.
no,
Or that,
judgment and decree or FDP, your lordship, N number it can be filed, your lordship. Unless this judgment and decree is in effect, your lordship, they can file FDP, your lordship. Therefore, your lordship, original decree which has been passed in my absence without making the party, as on the date of filing the suit, your lordship, I am the owner of the property. My name has been referred. The trial court is also admit the
you
same
can
thing.
seek a suit for injunction against them not to interfere or.
Your lordship, I have filed the application also, because decree is in respect of my property. They're processing with the, drawing the final decree proceedings, your lordship, against my property without making me as a party. I filed the application in that FDP also. But here the question, your lordship,
No, in that FTP, you could have seek for an stay of that.
ಇಲ್ಲ ಅವ್ರು ಮಾಡಕ್ ಬರಲ್ಲ, ಅದೇ FDP ಕೊಟ್ಟಲ್ಲಿ ಇದು ಮಾಡಕ್, unless judgment and decree is not stayed, they cannot proceed with the FDP. They have to proceed with the FDP, your lordship.
FTP in favor of appointment of already filed is unable to get the fruits of the degree. Suit vendor of the present plaintiff has contended that they have already sold the suit property, but this plaintiff has not made it included themselves in the suit vendors. So looking this material and hold that operation of executive judgment and degree in the said cannot be stayed. Degree can be stayed by the court which passed the degree till appeal period is over. On sufficient ground also. No, there is no power for that court to stay the degree, mister.
ಇಲ್ಲ, your lordship, that is the very court has a power to stay the decree. Here the question, what it has raised, is your lordship operative pressure para 9 your lord. So looking to this matter, I hold that operation and execution of judgment and decree passed in said suit cannot be stayed. The judgment and it can be stayed by the court which passed by decree till appeal period is over. And our appeal period ಆ court ಅಲ್ಲೇ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವ್ರು wrongly it has been taken into the contention. The very same court, your lordship, I have filed. Very same court has the power to stay the proceedings, and 41 rule, for a moment, your lordship, 41 rule 5 may be seen, your lordship. It is only within the parties which has been in the decree, your lordship, they have to come into the picture. We are not at all party in the original suit. So I have only option of staying a suit in the very same court or in the before the trial court.
Show me provision and judgment.
41 rule 5, your lordship.
Yes. This is appellate court.
Appellate court. It is only in respect of appellate court. Therefore, they are saying that.
No, this is not an appellate court. Same court you have filed. See, if you are challenged the degree in that appeal, appellate court can 41 rule 5 can be stayed.
Please, your
But
lordship.
this is before the same court. Where is that provision for same court to stay that?
Your
suit?
lordship, I do not have any other option other than filing under section 151 inherent power, your lordship.
Give me any judgment under 151, the trial court can stay that degree and judgment and degree. Show me that.
Your
Show me-
lordship.
Yes, you. show
One
me-
day, your lordship.
Yes,
Meantime, I'll comply. your lordship.
yes. Leave this matter. Monday, 24. In the
Much-
meantime, you comply after objection. Yes.
Much okay.
Office objection, second time matter, serial number 24, Manu Prabhakar Kulkarni for petitioner, B. Rupesha.
Office objections are only in respect of the index, that too in respect of the application, not in respect of the main writ petition.
Detail index with the page number, particulars of the each additional documents, IA to be. Yes,
Lord, the writ petition arises, I am the defendant in the suit.
yes.
39(1) and 2 application against me was allowed, my appeal was dismissed. Against that order of dismissal, I am before your lordships. Lord, 39(1) and 2 application, I am the sole defendant.
Yes.
Application against me was allowed. I filed an appeal, my appeal comes to be rejected. Therefore, my lords, I am before your lordships.
Yes.
Lord, I have filed a list of papers of the trial court. Will your lordship?
What is that injunction they have sought?
Lord, the injunction they have sought is that they should not be prevented from accessing some road. Lord, in one sentence, if I may submit, they claim they have easementary rights in respect of some road. Today, that road is part of an apartment complex. They have broken down the compound wall to access that road on the strength of the injunction order. Lord, my respectful submission shortly, in short, is 3 points. Avarig bere dari ide. They don't dispute that they have another road. Lord, whether that road exists, whether they should have access to that road at the interim stage, Lord, my respectful submission is I have submitted a plan to BDA. BDA has approved that plan. In that plan, no such road is shown. That road forms part of my premise. They rely on some previous sale deed to say there was some road and they say easement right. Today, my lords, balance of convenience. They have broken open my compound wall. They want to walk into my apartment complex even when they have an extra road. That in short is, and there is a FIR which I had to file during the pendency of the proceedings because as soon as they got ex parte order, on that basis they came and they broke down some part of my compound wall. And now they say, no, I did not break. None compound wall, nane murkotina.
Yes.
Lord, will your lordship, my lord, please kindly see the plaint. I have produced the entire record before the trial court along with a memo.
Actual suit for easementary right or declaration?
Suit for
Suit for declaration, your lordship may kindly come to,
Here is the plaint.
my lord, entire record of the trial court I have filed along with a memo. Sir.
Oh, you show me that plaint here.
ಅದರಲ್ಲಿ ಎಲ್ಲ ಹಾಕಿದ್ದೀನಿ my lords, along with,
ಇದ್ರಲ್ಲೇ ಇದೆಯಲ್ಲ plaint ಇರ್ಬೇಕಲ್ಲ.
please.
Page 148 is the prayer of the
148.
148.
In the plaint, my lords, lordship may please come to page 148. Declare that the suit schedule C and D properties. Declare that the suit schedule C and D properties as common road stroke passage, which is part and parcel of suit schedule B property for ingress and egress to suit schedule A property. This is the first prayer.
Yeah.
Then, my lord, second is permanent injunction.
Yes, now what is that order passed by the trial court?
Please, my lords. The order of the Honorable Trial Court is granting an injunction. Page 75, my lords, will your lordship please come to?
Yes.
In that, the finding your lordship will please find at page 94.
Yes.
IA1 is allowed. Defendants, opponents restraining them either through themselves agents are hereby temporarily restrained from interfering with suit schedule C and D property to reach suit schedule A property till disposal of the suit. Suit schedule A property is not the plaintiff's property. It does not give him access to any road. And your lordship may please see para 24, my lords.
Read that suit scheduled A property. Suit scheduled A property yardo?
Namde.
Lords,
It belongs to the plaintiff.
Lord, your lordship may please see a plaintiff avare hakiruva map. Plaintiff's map I will show, my lords, that in the trial court records, it is at document number 8 at page 66.
In which page, in which documents, Mr.?
My lord, along with the memo, I have filed the entire trial court records
Which is that memo, Mr.?
dated 10/2/2025, my lords.
Yes.
My lord, page 66 is the map. This is the map produced by the plaintiff along with the plaint.
Yes.
In this, my lords, your lordship may kindly first start from the bottom of the page. At the bottom of the page is the property of the plaintiff. It
Yes,
says
sir.
Schedule A property belonging to plaintiff.
Hmm.
Then in between, there are two other properties.
Yes.
Then at the top is Schedule B, C and D property. Your lordship may kindly see, my lords, both sides of the block say Schedule B property. Top aliddu.
Yes.
Madhya, they claim there is a Schedule C road and Schedule D road.
Yes.
Now, my lord, they are saying they have an easementary right to use Schedule C and Schedule D.
Now, what they are saying that in schedule B and C property,
Please, my lords.
top there is a road.
Please, my lords.
From there, they have to access through your property. That is what they are
My
claiming.
lords, they are here. Illi our property mugiyate.
ಗೊತ್ತಾಯ್ತು.
Illi ಎರಡು ಬೇರೆ ಇದೆ. They want access to this and this.
They want to access to that property belongs to that Sanjeevappa or
That they are the none other than my brothers. The entire property belongs to one Iranagaya, my lord. He had 4 children. Survey number 25, 11 acres.
Let me
38
finish. I am the
Yes.
my lord.
Ah, yes.
So they want access to this property, this road. Lord, they are right here. Now, my respectful submission, my lord, is ultimately, therefore, this is a claim for alleged easementary right.
Yes. Now, is there any other road other than this?
There
to
is a
access?
road. Your lordship may kindly come to my written statement. ನಾನು DC permission ತಗೊಂಡು ಬೇರೆ road ಮಾಡಿದ್ದೀನಿ. I have made a road by taking DC permission. They don't dispute that such a road is in existence. Will your lordship please come, my lord, to page number 193
In same
I-
document.
in the same booklet, my lords. Page 193 is the DC permission where a separate road has now been made.
Yes.
Page 193 is the order. Page 195, your lordship may please see the map. ಅಲ್ಲಿ ಮ್ಯಾಪ್ ಮೇಲೆ, my lords, at the very top it says ಈಗಿನಂತೆ.
Yes.
There, my lords, ಅಲ್ಲಿ ಕೆಳಗೆ ನೋಡಿದ್ರೆ a road starts and it goes around the property.
Yes.
This road, they don't dispute they have access to. But they say, no, my lord. In fact, in a previous round of writ petition before this honorable court, they say, yes, there may be a road, but that is not my case. My case is I have easementary right. May I show that order, my lords?
So that road is there. Now, you have purchased this property recently or it was there in that earlier?
In the
Lord,
2007.
I have purchased the property. I have purchased the property in 2011. Then I have made an apartment complex. When I submitted the plan for making the apartment complex, these roads are not shown.
No,
Lord.
you have not shown whether it was there.
Lord, my respectful submission as to how the road came is, survey number 25 was one single block. Survey number 25, my lords.
Yes.
If your lordship will please come back to page 66, I will use the plaintiff's map only.
Yes,
Survey number 25 was one single block.
yes,
Only 1 acre of survey number 25 was sold.
yes.
ಅವರಿಗೆ access ಕೊಡ್ಲಿಕ್ಕೆ between two neighbors, one internal road was made. That's there in the sale deed. Internal road. That internal road, once I acquire the entire property, I close it. Not survey number 25 ದೊಡ್ಡದಿದ್ರೆ ಮಧ್ಯ ಒಂದು ರಸ್ತೆ ಮಾಡಿ 1 acre is given. I have now purchased both left side and right side. That is east and west are both mine now.
No, if they are using from time immemorial, they can claim it
Lord,
as an easement.
I bow down, my lords. That is not his case at all. His case is, my lord, easements are of three kinds. As your lordship said, my lords, time immemorial, or easement of necessity, or easement by contract. He is claiming easement by contract. He is saying, Munchin sale deed alli ittu, nanage kodi. That is his claim.
Yes.
My answer to that is, easement by contract kelbekandre, you must be party to the sale deed. He is not party to that sale deed. It is somebody else's sale deed. ಬೇರೆಯವರು ಯಾರ್ದೋ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಹೋಗಿ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ರಸ್ತೆ ಬಿಟ್ಟಿದ್ದಾರೆ, ನನಗ್ ರಸ್ತೆ ಕೊಡಿ ಅಂದ್ರೆ.
No, is it easement by contract he is seeking, not that easement by.
Lord, your lordship may please see the order. ಯಾಕಂದ್ರೆ plaint ಅಲ್ಲಿ he does not very clearly say what his right is. Before this honorable court in the previous round of litigation, he makes his stance clear. My lord, in the IA for production of documents, I have produced this honorable court's order. That's also, my lords, on your lordship's file. Will your lordship please, my lord, in that kindly come to annexure S at page 281.
Next year,
My lords, S at page 281.
in that main paper book.
My lords, along with that, I have filed one IA, my lords. In that IA,
Yes. Yes.
ಇದು ex parte order ಮೇಲೆ I filed a writ petition, my lords. This is the final order in that writ petition.
What is that order passed by this court in that?
My lord, this honorable court granted me relief. It's a short order. If your lordship permits, may I just read the entire order?
No, you read the para 3.
Please, my lords.
What is-
Accordingly, the writ petition stands disposed of, directing the parties to maintain status quo in terms of the order passed by this honorable court on 5/6/2024. Trial court is directed to consider the interlocutory application filed by the plaintiff, and till consideration and disposal of the said interlocutory application, party shall maintain status quo and the respondent herein, that is the plaintiffs, shall not interfere in the suit schedule property till disposal of the interlocutory application. Trial court shall endeavor to dispose of the interlocutory application as expeditiously as possible.
No, that you have been directed not to interfere into that suit schedule property.
He has been directed.
Yes,
What was you doing in that period?
I was utilizing the other period. May I submit, my lord?
Till disposal of the suit.
No, my learned friend is suppressing the facts and is making. One year, may I submit, I may be permitted. In his sale deed, 2011 sale deed also, there is a 8 feet common passage road has been shown. In the very same, this thing, my lord, at page,
Rod, if your lordship will see. the
page
plain-
9, page, page 9 may be taken, my lord.
Let him complete, let him complete.
Please.
If your lordship will kindly see the plaint, I will just show my lords in that memo of paper book. Plaint alline 1987 ಅಲ್ಲಿ partition deed ಆಗತ್ತೆ. ಅವರೇ ಬರ್ಕೊಂಡಿದ್ದಾರೆ plaint ಅಲ್ಲಿ. That not page 1 is, page 4 is the plaint.
Page number?
Page number 4, my lords, is the plaint.
No, in which you are,
Lord, in this entire trial court record that I have produced.
page number 4, yes.
Page number 4, my lords, is the plaint. In that, your lordship may please kindly come, my lords, to para 4.
Yes.
The plaintiff submit that all the children of Veeranayagaya got divided the joint family properties under partition deed dated 15/5/1987 in the partition land bearing survey number so and so. So their ancestors partitioned all the land. Now, your lordship may please see the most important admission, page 7 of the plaint. Page 7 of the plaint, the bottom paragraph, your lordship may please see. My lords. The plaintiff submit that in the partition deed dated so and so, there was no description with regard to the road in the scheduled properties in respect of land bearing survey number 25, Hence, at the time of execution of the sale deed by Ir Nagappa in favor of Gurrajappa, the road has been shown in the scheduled properties.
Which paragraph you are reading?
My lord, page 7, Ali Chakbandi Kelagade, the paragraph right below Chakbandi.
Yes, yes.
The plaintiff submit that in the partition deed dated 15/5/1987, there was no description with regard to the road in the scheduled properties in respect of the land bearing survey number 25. Hence, at the time of execution of the sale deed by Ir Nagappa in favor of Gurrajappa, the road has been shown in the scheduled properties, that is for ingress and egress of other family members who own remaining land in the same survey number to reach properties of other shareholders. Therefore, my lord, my first submission is that in the partition deed, when the family properties were divided and plaintiff was allotted Schedule A property, no road was shown. I will show, my lords, provisions of the Easement Act which say when a partition takes place, if one wants to claim easementary right, then the partition deed must say it. Plaintiff admits partition deed is silent about it.
Description with regard to road in the scheduled properties in respect of the land survey number, hence at time of execution of the sale deed, has been shown. Yes.
Then, my lords, the plaintiff says, in the sale deed that he has referred to in Chakbandi, of course, my lords, a road is shown. But admittedly, he is not a party to any of those sale deeds. It is not between him. It is between somebody else. He is not even on the boundary. My lord, my respectful submission is,
Before sale deed, is there any document to show that there was in a road?
My lord, Ira Nagaya is my uncle. NCS left the road till this.
Council.
My lord, the entire 11 acre, 38 guntas is one block, my lord.
I understood that.
2 acre, 34.
His entire properties is belongs to your family.
Yes, my lord.
When your family together, you
At the time of partition, road has not been demarcated in the
There.
partition. Thereafter,
Then
at the time, yes, hence, my lord, thereafter, at the time of execution of sale deed by Ira Nagaya, in favor of Guru Rajappa, this road has been shown for ingress and egress of other family members is concerned. For that purpose, my lords may kindly see a memo has been filed by learned friend. In the sale deed of the petitioner himself, this road has been shown. In the year 2011 sale deed, my lords may kindly take a memo has been filed by my learned friend. In that document number 1, page 9, schedule is at page 20. 2011 sale deed, as on that date, yes, I purchased remaining 1 acre, 34 guntas also, as on 2011.
Where is that sale deed?
This is this petitioner sale deed.
Where is that?
Dated 9/11/2011.
How documents?
ಅಲ್ಲ ಅವ್ರು ಒಂದು ಮೆಮೊ ಹಾಕ್ಬಿಟ್ಟು ಹಾಕಿದ್ದಾರೆ.
IAL page 211.
IA
Page 211 in the IM.
211.
211. First document in the IM.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಪೇಜ್ 20 2 ನಂಬರ್ ಇದೆ 2318 2 ಶೆಡ್ಯೂಲ್ ಅಂತ
211.
ಹಾ ಅಲ್ಲ ಅದರಲ್ಲಿ ಪೇಜ್ 20 in the set up schedule all the piece and parcel of residentially converted property bearing survey number 25 ad measuring 1 acre.
No, you are referring to that which you have not supplied to that same copy.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲ ಇದ್ರಲ್ಲೇನೆ IA ಜೊತೆ ಇರೋದು
IAL page 215.
ಅಲ್ಲ ಇಲ್ಲಿ ನನಗೆ ಬೇರೆ ನಂಬರ್ ಇದೆ ಪೇಜ್ 9 307 ಅಂತ ಇದೆ ಶೆಡ್ಯೂಲ್ ಪೇಜ್ 2318 ಅಂತ ಇದೆ.
No, it is not telling. It is page number 200.
Not page 224, my learned friend may be referring.
224.
ನಿಮ್ದೆ ನನಗೆ ಪೇಜ್ ನಂಬರ್ ರಾಂಗ್ ಹಾಕಿದ್ದಾರೆ. ಶೆಡ್ಯೂಲ್ ಮೇ ಬಿ ಕೈಂಡ್ಲಿ ಸೀನ್ ಮೈ ಲಾರ್ಡ್. All the piece and parcel of residentially converted property bearing survey number 25 ad measuring 1 acre situated at Dodbele village, Kengeri Obli, Bangalore South Taluk, White so and so. Boundaries. East remaining land in same survey number owned by Ira Nagappa. This has been already purchased by petitioner himself under 2008 sale deed. Remaining land in same survey number owned by Ira Nagappa and common passage. This is what I am claiming. In 2011 sale deed, they themselves says there is a common passage for ingress and egress of other family members. Next, north land belongs to Babu and south land belongs to Guddappa in the property bearing survey number 25 and common passage. Guddappa is none other than my uncle. In the very sale deed sold by Ira Nagaya to Guru Rajappa, there was a road and common passage. Guru Rajappa sold in favor of Jayamma, there was a road and common passage. Jayamma sold in favor of petitioner, there was a road and passage.
My lord, now I will show.
Now
my lord,
suppressing that
direct case law, direct case law on the point. My lord, that therefore my learned friend has very.
No, see, that is the case. It has to be decided by the court later whether they are entitled or not.
Please.
Prima facie, there is
Prima
a road.
facie. Now, my lords, prima facie, I bow down, my lords. prima facie, I will show that three kinds of easements he has to claim. Lord, easement of necessity, he says it's not his case because he has an alternative road. He very fairly agrees. Then, my lords, it's only a question of easement by contract.
No, he is not saying that easement by contract.
That
Or
is-
documents, he's saying that is the documents to prove there is a road.
My lord, now my respectful,
Show me in the pleading that he is claiming on the basis of that, this thing. He's
Right.
saying that.
I have
it
not
was
made
there
a whisper
earlier.
with regard to that.
which is why, my lords, I am respectfully submitting
Yes.
that before this honorable court, please kindly see what submissions he made, because it is there that he says what his case is. Please come to page 283, my lords, of the same application. Page 283,
Yes,
please see his own submissions before this honorable court.
yes.
Learned senior counsel appearing for the respondent submits that petitioner had made a submission before this court regarding orders passed by the deputy commissioner in the year 2014, permitting the change of course of Kaludari in terms of the provisions of the Land Revenue Act. However, issue brought before the court is not regarding Kaludari. It is regarding the common passage left by way of private arrangement by the vendor of the petitioner, having regard to the access to be provided to the respondents to reach the road on the northern side. In that view of the matter, learned senior counsel submits that parties may be directed to maintain status quo. This, my lord, is the submission. Therefore, he says, our road BD, it is on the basis of a document. Now, my lords, I have multiple case law where courts have consistently taken the view that if somebody wants to take benefit of a road on the basis of a document, he must be party to that document. If he is not party to that document,
Show me under the plain pleading.
please, my lords. Now, your lordship may please come, my lords, to the plaint.
May I submit?
Plaint at para 4.
Wait, mister. Plain.
Please. Plaint, my lords, is at page 4.
Yes. Yes.
Then, my lords, in the plaint, your lordship may please come, my lords, to para 7, because very clearly what his case is, he does not say. The plaintiff submit that Ir Nagappa and his family members sold remaining 1 acre 34 guntas in favor of Priyadarshi, wife of so-and-so, under sale dated so-and-so, which is registered in the office of the sub-registrar Rajrajeshwari Nagar in document number so-and-so. Plaintiff submit that the said Ir Nagappa sold the entire 2 acres 34 guntas of land fallen under 2 registered deeds by leaving 8 feet width common road passage towards western side, which runs from north to south, survey number so-and-so, common passage road southern side, which runs from east to west, survey number 25 for ingress egress to the other remaining land, which is herein referred to as Schedule B property. The plaintiff submits that apart from Schedule B property, the remaining land in survey number 25 to an extent of 9 acres, 0.4 guntas, which includes suit Schedule A property. They don't correctly say what is their case in the plaint. They simply say there is a road mentioned in some sale deed. I am entitled to the road.
See, all that has to be decided by the trial court. Now, prima facie, in your sale deed itself shows that there is a road.
Right.
You leave it till the disposal of that.
Right.
Now you constructing that apartment, blocking the road which was there in that, in your agreement also.
ಈಗ್ಲೂ ರೋಡ್ ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes, after taking that property by the builders, the entire world will be changed.
Not my respectful submission is, your lordship may please see. Your lordship may please see, my lords.
Even now also this 8 feet common passage has been left block.
See,
Building has been
without
constructed in
claiming
other
any right,
places, not in this
if
place.
that road is there, leave in a common passage till the disposal of the suit, but
Not there. Your lordship may kindly see, my lords.
yes.
Just 2-3 judgments. My respectful submission is, first your
All that, no, all that is for see, now if I given a finding saying that it is on a contract, therefore is suit nothing but dismissing his suit itself.
Lord,
Then what
Yeah.
if I given a finding,
I
trial
bow
court
down.
cannot do
I
it?
bow down. My lord, your lordship may consider this. He already has a access road. It is not that he does not have access. Therefore, my lords, on balance of convenience, he does not need to use my road. If he gets a decree in his favor, he can use it. Lords, on balance of convenience.
Why can't you now you allow till that disposal of the suit?
Lord, he comes within my apartment complex. He does not need the road. Lord, I understand if he said, ನನಗೆ ಬೇರೆ access ಇಲ್ಲ. ಬೇರೆ access ಇದೆ. ಆ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ he is not a party.
You have already constructed that apartment.
I have constructed that apartment. I have put photographs, my lords. Please kindly see.
This road is in
Photo-
existence.
photographs.
Even till today, this road is in existence.
Now
They
the
have-
thing is that your access through that apartment, then security problem would arise. Where is
ಅಲ್ಲ,
that?
ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, including survey number 25, they have purchased adjacent properties. They have made an application before the revenue authorities. ನಂಗೆ ಸೀದಾ access ಇರೋದ್ನ 1.5 kilometer ಬಳಸ್ಕೊಂಡು ನಾನು ನನ್ನ ಜಾಗಕ್ಕೆ ಬರ್ಬೇಕು. ನನ್ನ ಅಣ್ಣ ಬಿಟ್ಟಿರೋ ಜಾಗ ನಾನು ಐ ಶುಡ್ ಬಿ ಈಸಿಲಿ ಆಕ್ಸೆಸ್ ಟು ಮೈ ಪ್ರಾಪರ್ಟಿ. ಇವ್ರ ಬೆನಿಫಿಟ್ಗೋಸ್ಕರ 1.5 ಕಿಲೋಮೀಟರ್ ಸುತ್ಕೊಂಡು ನನ್ನ ಪ್ರಾಪರ್ಟಿಗೆ ಬರಬೇಡ್ದು.
Yes, where is that?
My lord, page 125 onwards are pictures of apartment complex that is already built.
125
onwards. my lords.
in that documents which you have produced.
Please, my lords.
We are not obstructing the apartment, residents of the apartments. We are not making any trouble to the apartment at all. Our humble request and submission before this court to leave that road to reach our property.
Where is that road, Mr.?
My lord,
Ado,
at page 210, your lordship, page 210
I have
onwards,
produced a sketch, my lord. That is it.
at page 210,
Page
11, they are
124
the
as-
photographs.
One of them has to be asked.
Please.
Page
210, 11. That, my lord, they say is the road.
You can't see that, Mr.
Sketch ಇದೆ ಸ್ವಾಮಿ. I will.
Along with the IA, my lords, I have produced color photographs. Page.
To allow only the petitioner to access.
ನಾವ್ ಅಷ್ಟೇ ಕೇಳ್ತಾರೆ, ನಾವ್ ಬೇರೆ ಯಾರನ್ನೂ ಇದ್
My
ಮಾಡಿ.
only respectful submission is compound wall murdu they are accessing. There is a FIR.
Wall they cannot.
They have
See,
broken it already.
No, if you are allowed, why they will broken the
No, my
compound?
lords, what happened is I had put up the compound wall, they filed a suit, they got an interim order.
No, if you say will permit them to access using that gate, then otherwise you have to make them any way to go.
My lord, that road is there. They have a road. They are not
No,
disputing.
they have in a road, 1.5 kilometers has to be,
My lord,
just because you have constructed an apartments, they have to go that way.
my lord, they have not questioned that order.
Yes,
I am
they
not,
have
I am not on that one before
they have
this
not-
court at all.
There is a concurrent finding of two courts.
My lord, finding a if your lordship
If
will,
you take notice, we'll hear that matter.
Please.
Request for hearing. Yes.
Lord, until then, Lord, until then,
From
my
past
lords,
4
they
months
have,
an order.
they have an alternative road.
No, this is what that, you, once you build up this thing, you have to throw away these peoples to not to enter. See, when you have purchased that property, you are
Please.
aware that there is a road.
I bow down, my lords. I understand what your lordship is saying.
To accommodate that your, person who is purchasing that property, you are denying their, this thing.
Lord, ಅವ್ರಿಗೆ right ಇದ್ರೆ I can understand.
That is what that it is to be decided by the trial court.
Lord,
But prima facie.
Prima facie, some right has to be decided.
Agreement, your sale deed itself.
My lord,
shows that-
if he is party to my sale deed, I understand.
No, that is.
He is not party to my sale deed.
Council, that is for a legal aspect has to be decided by finally.
My lord,
Now to decide that interim application, now that your sale deed itself shows that there is
second
and
point
there
is,
two concurrent finding of the trial court.
my lord, second point is, on jurisdiction, he files the suit before Court of Civil Judge Junior Division. His valuation is 50 lakhs. Ex facie pecuniary jurisdiction. ಇಲ್ಲ.
File an ejectment.
That is not the
My lord,
count before trial
I
court.
took that point before the Honorable Appellate Court. The Appellate Court says, because you have not taken this point in 39(1) and 2, you can't take the point here.
No, you, even now you file an application for rejection of the plaint, I will say that, consider that.
Not that I have filed, your lordship, my lord. In the meanwhile, direct the Honorable Trial Court to consider that application. I have
Yes.
filed.
Will, who is that other? You are the only counsel.
My lords, I am the only one because
Respondents, for all
all
respondents.
respondents, my learned friend.
Yes. You take notice, we'll hear that matter. Yes. Cavator has undertaken to appear for. But you don't use that as an,
ನಾವೇನು ತೊಂದರೆನೆ ಮಾಡ್ತಾ ಇಲ್ಲ. ನಾವ್ ಅದ್ರಿಂದ on the other hand, my lord,
no, you can give a complaint if they have done it any other thing.
And
except
ಕೊಟ್ಟಿದ್ದೀನಿ, there is a FIR already.
except usage of road, ಬೇರೆ ಏನು I myself was undertaking.
Yes, leave this matter on 5th or 6th, when you are ready, we'll hear that.
Please, maybe taken on 6th.
6th, yes.
Sixth. Great.
Achu.
And finally, we'll hear anyhow that is.
Please,
Yes.
grateful.
Office objection, what is that?
Not I'll comply. ಅದು continuous page numbering ಮಾಡಿ index ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅಂತ I'll
Submission is
comply.
accepted. Office objection is complied. Leave this matter on. Yes.
Cell number 25, VB Siddaramaya for petitioner, Parvaya.
Submission, please, my lord.
Annexure K to be marked as annexure and series of
Lordship.
attested by the competent authority. Written statement should be filed. H will say.
Make one submission, please, my lord.
Yes.
I have not filed a caveat in this petition. Wrongly show my name as a caveator, please.
ಆಯ್ತು ನೀವು ಇದೀರಲ್ಲ ಈಗ ನೀವು
ಅಲ್ಲ,
file ಮಾಡಿಲ್ಲ.
without instruction, ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ಇಲ್ಲ.
ಇಲ್ಲ ಅಂದ್ರೆ ಒಳ್ಳೇದಾಯ್ತು ಬಿಡಿ. If you are, yes. Now you comply that password. Or you want time, week's time. Week's time is granted to comply after subjection. Office, ಅದ್ ನೋಡ್ರಿ ಕೇವೇಟರ್ ಅವ್ರು ಇಲ್ಲ ಅಂತ ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಅದು?
Sir, 25.
25. You are not there as a caveator.
No, madam.
ಅದ್ರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ?
Wrongly show my name as caveator.
Learned counsel appearing for the caveator or submits that he has not filed any caveat. If office has wrongly noted, office is directed to delete his name. Please. Yes, at the request of petitioner, week's time is granted to comply after subjection.
Serial number 26, Vishrut C for petitioner. Surya
The respondent in
Prasad
this
L.
case. Yes. Let me see. Preamble portions of the annexed G is to be filed. Objection to that IA. Court fee has to be paid 100 rupees, mister. Detail of annexures from when?
Right after the filing.
ಇದು ಯಾವಾಗ್ರಿ ರೀ? ಇದು ಏನ ಹೇಳ್ಬೇಕಲ್ಲ ಇದು ಕೋರ್ಟ್ ಫೀ ಹಳೇದು ಹೊಸ್ತು ಯಾವತ್ ಹಾಕ್ತಾರ್ರಿ? Copy has not been served. When you have paid the court fee?
It's an online payment, Your Honor, right? after the-
What is that? When ಯಾವತ್ ಕೊಟ್ಟಿರೋದು? ಇಲ್ಲ ಡೇಟ್ ಇಲ್ವಾ? No, after that again it has been raised for 100 rupees court fee. You pay that court fee. Yes.
Copy has not been served on me, my lord.
In the meantime, you serve a copy. Please. Yes. Yes, week's time is granted to complete. No, what is that urgency?
My lord, delivery warrant, my lord, not arrest warrant, delivery warrant.
Yes, password complied. Yes.
Please.
Be there. Yes.
Serial number 27, G Balakrishna Shastri for petitioner, A Nagarajappa. Respondent.
Pagination to be stated correctly at index and exercise. Yes. Yes. Ready? Yes. Hmm. Suit for? Yes.
The property consists of a side property in order. Entering, the house. Number 11. Entering the east to west 16 meter.
Hmm.
North 13 meters.
No, what is the defense of that defendant before the trial?
Denied.
Yes.
That was handed over the agreement, not initially, sale agreement, not six. At page 57, besides, at page not 7, last two sentences. ಸದಸ್ಯರುಗಳನ್ನು ಇದನ್ನೇ ನಿಮ್ಮ ಸ್ವಾಧೀನಕ್ಕೆ ಬಿಟ್ಟು ನಮ್ಮಗಳ ಬುದ್ಧಿರಾಜಿನಿಂದ ತಂದುಕೊಟ್ಟು ಮನೆ ಬಿಟ್ಟಾರೆ.
Who is that vendor?
The vendor is not the first defendant.
He is your vendor. Now he is denied that he has not executed that.
Yes.
Now is it a registered document?
No, no, it's not registered.
Hmm.
And we have taken a defense.
Hmm.
Personal to this, not Akaba stage in my favor. I have been paying the water bills, electricity bills, and land revenue taxes not for the site in question.
Hmm.
Then Lord, state Lord sanction, Lord money of rupees 5 lakh for construction. This whole thing will collapse.
You have not filed suit for specific performance.
No, my lord, in another proceedings, whether my management is aware or not, a writ petition was filed by the very person questioning, my lord, the executive officer's order regarding Kata is concerned.
Hmm.
In that writ petition, they have considered that we will modify, well, the suit into a one of my declaration. very recently, ಆ ಕಾಪಿ ನನಗೆ ಸಿಕ್ಕಿಲ್ಲ. ಇವರಿಲ್ಲ ಅದರಲ್ಲಿ ರಾಜಾರಾಮಪ್ಪ.
Yes, Mr. Gowda. Yes.
I don't know that aspect, but,
Hmm.
but, this five lakh rupees not state sanction, not, with,
No, all that is on the basis of this unregistered document. Hmm.
My client has constructed, not put up construction up to the roof level.
Yes.
Lord, when it is up to the roof level, not, they started obstructing my position.
Hmm.
I was constrained to five, not to so. Now, not if this, is just not a roof has to be laid.
Hmm.
Roof is not laid, not this, whatever construction is made, not will go.
Yes.
Investment will go. The loan not which I have taken from the state, I will not be able to repay. And, construction will not will get.
Let that be roofed if there not to claim any equity.
Nothing, my lord, that is nothing. Your lordships, my lord. In six, I am the, my lord, the owner of the property in question. That is the
No,
first
is it-
defendant.
is it
I have
true?
executed, my lord, gift deed in favor of my sister on 6/11/79 itself.
No, that is true.
He is taking shelter under the agreement.
No, is it true that he has constructed this?
No, my lord, that's,
What is that annexure H? 68.
my lord, but he has not put up, he is not in possession, my lord, my
No,
information.
that is, if it is, no, what is that annexure H? Is it that constructed
know,
in
my lord,
that
which
suit scheduled property?
I am not, my lord.
You
aware
get
of
that
this.
instruction.
Please, my lord, I'll find.
If it is there, it's already constructing without claiming any equity. Tomorrow, if it is failed, he has to be handed over as it is to that defendant. That let him.
I'll find
verify.
out, my lord, who has,
Yes, yes. When do you want?
my lord, on fifth, your lordships, my lord. Fifth or sixth, my lord, because
Yes.
I am out of.
At the request of counsel for respondent, leave this matter on fifth.
Fifth.
Yes. Sixth.
Sixth ಆಗ್ಬೋದು.
Yes, sixth, yes.
Office objection.
Yes, submission is accepted, office objection is overruled.
Serial number 28, Ajit Kalan for petitioner, Rupesh Kumar, yes.
Respondent number 2, man.
Week's time is granted to comply after subjection.
Hello, date may be fixed, man.
Interim order is there.
ಇಲ್ಲ
Ah,
ಇದ್ರಲ್ಲಿ
then-
ಇಲ್ಲ. ಇದ್ರಲ್ಲಿ- ಇದ್ರಲ್ಲಿ- ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ- There is no entry order in this case.
Next, devotee is responsible to seek verification. But you have not completed that office objection, Mr. No, it has been granted on 29/2/2024. One year is over, you have not completed. What is that office objection? Put it, office objection. Tell you the file, main file. Very good. IA details should be stated in the prior. Oath commissioner seal is not there. Still this court has granted. No, oath commissioner seal is there. Notary. Oath commissioner seal to be. No, 1 year you have, I will vacate that interim. This is not that, mister. See, court first of all cannot grant that any order without oath commissioners. There are 7, 8 office objections. Still, if some minor objection, legible copy and all, it's okay. Interim order taking after 1 year, you are not complied. Yes. Yes. Finally, week's time is granted to comply office objection. If office objection is not complied, the interim order granted by this court will automatically vacate. Yes.
ಇಲ್ಲ ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ಡ್ ಮೇಲೆ.
ಬರುತ್ತೆ ಅವ್ರು ಕಂಪ್ಲೈ ಮಾಡಿ. ಎಸ್.
Office objection.
ಕಂಪ್ಲೈ ಮಾಡಬಾರ್ದು ಅಂತೀರಿ ಒಂದ್ ವಾರ ಅಷ್ಟೊತ್ತಿಗೆ ಅದು ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಬೇಕಾಗ್ತದೆ.
ಇಲ್ಲ ದಿ ಆರ್ಡರ್ ಅಂಡರ್ ಚಾಲೆಂಜ್.
You file an application for vacating.
Yes, ma'am.
There is an, yes.
Office objection, third time matter, serial number 29, Parvati R. Nair for petitioner.
Yes, time, third time.
Sir.
ಇದಾಗಿತ್ತು. Submission is referred. Submitted to convert this revision petition into the writ petition. None appear. 2 weeks time is granted to comply officer.
For order serial number 30, Anandarama K.
Amendment of the plain copy after all the corrections. Additional page.
Same way that way of, but if you not there is one, small page attached. that
Yes.
amendment is attached to it.
Yes. What is this matter?
Separate copy.
Yes. Yes.
So this is, annexion K is the order, the impeding applicants will not file this petition.
Suit for?
Suit for declaration that not the plaintiffs are the mulligani tenants against the mud.
Yes.
Earlier not the Madhavipati who was the original district guy. Then different number 1A has been included. Now different number 1A has not, did not file even statement for about 7 years, not contesting at all. So then I filed this including application for including on the ground that there is collusion and there is no contest at all.
Now, what is your interest in this?
I am the follower of the devotee of the, and the but property is not involved. So therefore, I want to impede and not protect.
Where is the plain?
Plain. The plain is the connection here. All the plaintiffs claim to be not the legal heads of one Sanjeevi Bhai. Sanjeevi Bhai is claimed to be the mulligani tenant. And the plaintiffs are seeking not by way of succession that they are the mulligani tenants. That is the declaration that we saw.
No, Matt has been made as a party.
Yes, defendant number 1, page 21. The earlier Madhavipati was made as a party. Then the earlier Madhavipati expired. Then the present, your lordship may kindly see that slip Milord's
Yes.
the amendment. 1A, that is Sri Rudramani is forming. He has been included as the defendant number 1A. He was included in 2016. He does not file a written statement till 2024. After I filed his including application saying that there is a collusion, then he files a written statement. And the written statement will not even.
No, what is that your interest? How can you that all public? No, can you implead as in a party then? All that anybody can come and implead this when that mutt is there.
Defendant who is not supposed to not defend the interest of the mud, who is not defending it.
No, is there any judgment on that point? You can implead as in a party.
What is not naturally interested in the property of the mud.
Really, you give that judgment on that point, yes.
The lordship may have it, Monday or Tuesday.
No, on 27th.
27.
Yes.
27, 28.
28, yes.
It can be listed in preliminary hearing.
Yes. Submission is accepted, office objection is overruled.
Serial number
No,
31.
let it be like this only. Otherwise, it will go to that, it will come to that preliminary. Yes. Office objection is overruled. Yes.
Serial number 31, Satyanarayana.
Yes. Photocopy of that annexure B to be filed. All parties before the trial court to be made as in a party in the cast title. Why you have not made them as a party?
You are already deleted. Page number 28. Section A. Or 5 to 108 are deleted. In the proceedings they are deleted.
Yes. Yes, submission of learned counsel for petitioner is accepted. Office objection is overruled. Yes, 21. What is that urgency? Yes, what is this matter? Yes.
Proceedings.
Yes.
Commissioner of
Yes.
I am one of the owners. I entitled to 21.11%.
No, what is the suit for?
Suit for partition. Was declared in our FDP proceedings are going on. In the FDP proceedings, I have filed an application. Court commissioner is also appointed. To take note of the subsequent event of purchase of one of the co-sharers' property share, I have purchased. What has happened?
No, you are a purchaser or you are a co-sharer?
21.11% share
Hmm.
as a legatee of respondent for three.
Hmm.
And in addition to that,
You have purchased some of the properties from that, one of the,
four sharers, she has sold
Hmm.
one of the share of her share,
hmm.
2,320.3 square meters. Actually, what has happened?
No, how can she sold before partition? She has in a share, but property is not identified.
Here,
Now, what is that application you have filed?
big number. Big number 45. For the reasons what we have in here, on PA, please, take note of the subsequent event and in view of the same, further instruct the commissioner to take note of the enlargement of share of this respondent and to carry out the commission.
Why it is dismissed?
On the ground that I can claim equity and further
Where is that order, Mr.?
order. Page number 28.
Read that reasoning.
I'm hearing the arguments of both the parties and on perusal. of
Now,
the-
page 35.
Page number 35. Point number one, the respondent number 3A has filed the application requesting proof of the subsequent event and in view of the same instruct the court commission to take note of the endorsement of the share and carry out commission work accordingly.
No, ಏನಿದೆ page para 13 ಬನ್ನಿ.
Para 13, it is to be noted that entitlement of the share by the parties to the suit number 2905 of 83 is decided by the Honorable High Court in review petition 395 of 23. Under these circumstances, the said order and the share allotted by the Honorable High Court cannot be modified by this court. I am not seeking for any modification. Only thing is, I have under a decree, earlier there was a specific, I have filed a suit for that suit can be decreed. I have filed an application to consider that decree.
Yes.
Since the sale deed was not executed in my paper, that
Alright.
can be rejected. Subsequently, on 4/1/4/2024.
Issue notice. Stay of order dated 19/10/2024. Passed by 80 additional city civils and so on so. Judge in Court Bangalore, passed on IA number 11 till next date of hearing.
Serial number 32, Raj Aditya
Mr. Counsel.
Sadasivan.
You know what is that interim relief you have sought? How it will benefit it to you, Mr.? No, your application is rejected. You want to stay up that application I have granted. How you will get that relief, Mr.? What is the benefit you will get that if
Yes, and my application is considered.
your interim prayer should be stay of further proceedings? You have sought for stay of that order which is rejected. Yes, that stay of further proceedings. OS FTP number 107 of 2010, pending in the file of 65th Additional City Civil and Session Judge Bangalore till next date of hearing. See, if this order is stayed, then it goes. Then if the FDP is completed, what will you get, Mr.? When you are filing that, you should be, apply your mind, what is that relief you asked? Who is that fellow who is there? Why he has come? He is the, either he is engaged you or he wants to argue that case. Why he is come friend? Yes.
Serial number 32.
Don't allow that clients to be come inside. I have not noticed. You note the consequence, what is effect on that? I thought that only advocates have just given advice. It will reflect on you. Don't entertain that. They will start riding on you. Yeah.
Serial number 32, Raj Aditya Sadasivan.
Yes.
Corporation document is not published for the petition.
Nature of the petitioner to be stated in the cost.
As per different code as a limited company,
Yes,
I think income is not in dispute.
yes,
It will be rule.
yes, yes,
As far as the merits are concerned, suit is for, recovery of going side before the commercial court, I am
Yes.
first independent.
yes,
I have filed an application under 1226 for dismissal of the suit based on admitted document, admitted facts.
yes,
The application came to be rejected on the ground that the documents which I am relying upon are not admitted.
yes,
The facts in the case are that we are in pharmaceutical business.
yes,
I have placed certain purchase order on the plaintiff, he has supplied,
yes,
but there is a related supply. In pharmaceutical business, the time is of essence of the contract.
yes,
Because there was delay, I have rejected the goods.
yes,
It has been acknowledged by the plaintiff in the credit notes. Kindly, your honor, your lordship, kindly see the credit notes starting from page number 40, the annexure D. It is an email issued by the plaintiff
yes,
respondent, wherein they issue the credit note. This email has all the credit notes, following pages are all the credit notes, kindly see page 44. At the, this is the credit note, at the bottom, demand,
yes,
debit notes also, credit note issued for late supply, the bottommost.
now what is that you are challenging here?
Now, all these credit notes are admitted documents. When I rely upon this along with my written statement, the plaintiff is required to file a statement of denial. In the statement of denial, this document is not denied.
Yes,
They only say that subsequently we have resigned it. Subsequent resigning is of whether that resigning is valid in law or not is a matter of law. As far as facts are concerned, issuing of this document is admitted.
yes,
Now, when I file a 1226 application, it has been rejected on the ground that the documents are not admitted. There is a statement of denial. Your lordship, a kindly see statement of denial is page number 61. The denial that they say, your lordship, 61.
no, you are filed an application for dismissal of the suit
Based on
without,
1226.
yes,
Based on the admitted documents. The denial, statement of denial is at page number 61, my lord, filed by the plaintiff.
61,
61.
yes,
Similarly, a copy of email exposure, denied reasons. This document is disputed as the plaintiff has replied to this email. Copy of credit notes, the credit note is disputed due to subsequent error. The genuineness and issue of the document is not denied. They say that they have replied to the email. Replying to the email necessarily means that my email which I would like on
I
is a
could,
genuine document.
no, is it, this much is enough for dismissal of the suit? There should be a clear admission.
It amounts to a clear admission under provisions of commercial code act. If it was barely CPC, then I may not be able to succeed.
Yes.
As far as commercial code act is concerned, 11 rule 4.
Section,
Order 11 of
order 11, huh?
Commercial Code Act.
Yes.
Rule 4. Order 11 is regarding disclosure and discovery of document. And there is rule 4, my lord.
Yes,
Rule 4,
Hmm.
sub-rule 1. Each party shall submit a statement of admissions or
No,
denials of all
11, 11, 4, huh?
11-4, my lord.
4 is,
Order 11, rule 4
order 11,
of Commercial Code Act.
yes. In 4, in case of urgent filing, 3, 1,
Order 11, my lord. Order
Yes.
11, rule 4. In the schedule of.
yeah, that is disclosure or discovery and that inspection.
Other than rule 4.
Yes, rule 4 is, rule 2 is list of the documents. Is it?
Rule, you're not should be seeing the rule 1, sub-rule 4.
Rule 1,
That is not what I mean. I am relying upon rule 4. Admission and denial of document. Lordship has rule 4.
inspection, admission and denial of documents, yes.
Sub-rule 1, each party shall submit a statement of admissions or denials of all documents disclosed and of which inspection has been completed within 15 days of the completion of the inspection or in data as been particular. Two, the statement of admissions and denial shall set out explicitly whether such party was admitting or denying correctness of contents of a document.
No, you
Existence of-
see, he has not said that he is denied.
Correct.
Is it to be taken as in a denied or it's an admission?
It is a denial should be specifically under these 5 headings.
No,
There are
you,
only
no,
five-
not only denial, but both denial and admission, there should be specific.
The denial should be specific.
Each party shall submit a statement of admission or denial, all the documents, disclose each of the inspection completed within so and so. Statement of admission and denial shall be set out, both admission and denial shall be set out explicitly whether such a party was admitting or denying.
Admitting or denying, admission or denial should be specifically these 5. If it does not fall under these 5, then next sub-rule will apply. I will just read out the 5. Correctness of contents of document, existence of a document, execution of document, issue or receipt of a document, custody of it. None of these 5 are denied.
Yes.
If there is no denial specifically under any of these 5,
Yes. What is that next?
sub-rule 3 and 4.
Hmm.
Each party shall set out reasons for denying a document under any of the above grounds. And where an unsupported denial shall not be deemed to be denials of a document, and proof of such document may be dispensed with at the discretion of the court. If the denial is not specifically those 5, then it can be deemed to be admitted. It is not a denial.
No, it is
as-
not deemed to be admitted. It is a discretion of the court for,
It is a
discretion.
discretion of the court.
Hmm.
Now, the court says that it has been denied without giving any reasons how it amounts to denial under these 5.
Yes.
The reading of the statement of denial would categorically show that the issue of that email has been categorically admitted. We
Yes.
say that he has replied to
Or-
the email.
Issue notice. Stay of further proceedings in commercial OS number 179 of 2024, pending on the file of 89th additional city civil judge, Bangalore, till next date of hearing. Submission is accepted. After subjection is over. Yes.
Till number 33, Rukoji Rawat Chess.
Yes. Yes, week's time is granted to comply after subjection.
Till number 30,
No, you do even 1 day. I will grant maximum 3 days. Yes.
till number 34, Vandana PL for petitioner.
Hearing for the respondents in this matter, Milords. Was the
What is this?
So this is with respect to the transfer petition, Milords, which was heard in part, section 24, Milords.
Oh, that Vijay Jaikumar Spotila, sir.
Yes.
Yes.
No, Milords, the petitioners, Milords,
Yes, we will continue at 2:30.
230, yes. Milords.
Lord, serial number 82.
Serial number?
Ye-
56. Yes. 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 Hmm. Now only give, we will get it at 2:30. Refer. Without posting, I cannot refer. 2:30, I will say that refer this matter to the Lok Adalat. No, that's what, you give that connected matters right now. I will ask to post it at 2:30. Yes, give that number.
Seal number 36,
One
madam,
minute.
seal number 30. Seal number 36.
56, so 56 ಮತ್ತೆ 2:30 ಗೆ ಅವೆರಡು matter post ಮಾಡ್ಬೋದು.
Seal number
The
30.
request of the parties refer this matter to Lok Adalat. National Lok Adalat to be held on 8th March.
Lord, seal number 36, madam.
Serial number? 57, yes. They are appearing for respondent. Yes, at the request of counsel for the respondent. This matter next week. Interim order granted earlier is extended till next.
Seal number 30.
65 Rara, serial 65
168. Yes. You are appearing for? Yes, at the request of petitioner. Please this matter after 2 weeks.
65 Rara. 69
Have you informed other side, mister? Interim order extension, you have to inform other side, mister. They will object without. Then you will inform and mention at 2:30. Yes.
My lords, kindly.
55. Yes, 50. At the respondent, yes, at the request of counsel for the respondent. Lease this matter after 2 weeks. Interim order granted earlier is extended till next date.
65, my lord. 65.
Hmm.
2 weeks time may be granted, my lord. Same, my lord. Same.
No, they have an
I am for
objection.
respondent. He is for the petition.
No, is there any stay? Then he has an objection, Mr.
No, at least 1 week time I need.
They have an objection. We wait when the matter is.
Let's
started.
see.
Objection, my lord.
Yes, let us see when the matter is. reached.
Serial number.
Serial number 82, my lords.
Serial number?
82. I had informed the honorable court that the partition suitable, one of the parties is dead. FDP is pending reopen. 5 minutes back. Next week, any day at 2:30, I'll take only 5 minutes of your lordship's time.
No, where is that other side?
Other side, I'll inform the
Yes.
other side.
At the
25.
Counsel for the parties.
Dependents,
Defendant. In the RFA.
respondents.
Respondents. Use this matter. When do you want?
On next Thursday,
Next Thursday, agala. 4th, 5th.
5th.
Yes.
That's seal number 36, my lord. And for the petition, this is the correction of the judgment and decree, my lord. There is an arithmetical error. Notice tagondidivi sir. Sarvagil antida. Their counsel is already filed RFA. May be permitted to take out notice to the council.
Yes.
KG Sadasivaya.
In addition, 36 ali, counsel for the petitioner is permitted to serve a copy on the counsel appearing for the respondent before the trial court.
Right. Next week, any date, my lord. It's a 2010.
Serve and move that matter, yes. 49. Yes. No, there is an IFR vacating. Have you informed the other side? You informed and move that, Mr. Yes.
My
Serial
lord,
number?
serial number 45, my lords.
70. 71. Yes. At the request of counsel for the petitioner, leave this matter after 3 weeks.
My lord,
Have you
serial
informed-
number 45.
Yes. 2 weeks.
My lord, serial number 45, my lords.
Wait. Interim order granted earlier is extended till next date of hearing. Yes, serial number
45, my lords.
55.
And for the,
I'm for the petitioner, my lords.
Yes,
and for the
Respondent,
respondent, will oppose the adjournments because of 97 matter. OS 97 matter.
no, that some parties are dead.
Yes,
parties
some of
are-
the
respondent number
parties are
6 is
Then
dead,
they
my
have to
lord.
take steps. Wait, madam. They have to take steps in respect of that, reporting that respondent is dead.
Yes, but regarding the R2 is concerned, all the other respondents in the parties and their sons and daughters are the parties. I'll file the detailed memo in that.
What about R6?
R6 is concerned, they have to file the applications in 2024, more than 1 year they'll dead, they know very well.
Yes,
Still
madam.
then they're
My lord-
abated against the,
We'll dismiss that against that R6, it is
Yes.
abated. You have not taken
My lord-
steps.
My
I'm the
lord, sir.
plaintiff, I'll take the necessary
Wait,
steps.
wait, when the matter is
My-
called, they have an objection. Yes.
Yes,
Please.
Yes. You are for respondent. Yes, at the request of respondent, leaves this matter next week. What is that? Extra copy means, you asked that to petitioner counsel, mister. Why you want take? Then,
Serial number
then you wait, let them, why you want that quote?
Serial number 37.
No, that is for that quote, mister.
But serial number,
There is, it is not in a paper books to be provided. You have to be asked by that petitioner counsel.
but serial number 37, my lord. I'm for the petitioner, for the respondent. Next week, any date could be.
Dismissal against the fight for petitioner, steps to be taken for unclaimed or.
Unclaimed may be held as sufficient.
Yes, at the request of counsel for the petitioner,
Yes, ma'am. Respondent,
next week.
Monday or you will say,
Yes, next week.
any date convenient to the solve.
Next week, third, yes. 40. 48. Yes,
Serial number 48.
ನೀವು ಯಾರಿಗೆ? Petitioner ಗೆ. Wait when the matter is called, they will come.
then they will serve, yes.
List number 2 adjourn ಮಾಡದಾ? 4 adjourn ಮಾಡು. List number 2 4 adjourn ಮಾಡ್ಬಿಟ್ಟು. ಹೇಳಿದ್ದಾರೆ. ಅವರೇ ಹೇಳ್ತಾರೆ, ನಾವಲ್ಲ, ಅವರೇ ಹೇಳ್ತಾರೆ. ಅದನ್ನ ಅವರೇ ಹೇಳ್ತಾರೆ ಅಂತ ನಾನು ಕನ್ನಡದಲ್ಲಿ ಹೇಳಿದೆ ನಿಮ್ಗೆ. ಅವರೇ ಹೇಳ್ತಾರೆ ಯಾವಾಗ ತಗೋಬೇಕು ಅನ್ನೋದು ಅವರೇ ಹೇಳ್ತಾರೆ, ನಾವಲ್ಲ. ಹೇಳಿಲ್ಲ ಅಂದ್ರೂ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ, ಬ್ರೇಕಪ್ ಇಲ್ಲ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 70
ಅವ್ರು ಕೊಟ್ರೆ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ನಾನೇನ್ ಮಾಡ್ತೀನಿ?
ಸೀರಿಯಲ್ ನಂಬರ್ 70 adjournment
ಅಷ್ಟನ್ನ ಮಾತ್ರ ಹಾಕಿ ಅಷ್ಟೇ.
ಏನದು ಫೈಲ್
ಹಂಗೆ ಅದೇ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಗೊತ್ತಿಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೆ ಅಲ್ವಾ ನಿಮ್ಮ, ಅವರೇ ಹೇಳ್ತಾರೆ. ನಮ್ಮ ಕೋರ್ಟಲ್ಲಿ ಎಲ್ಲ ಡಿಸೈಡ್ ಮಾಡೋದು ಅವರೇ, ಜಡ್ಜ್ ಸಾಹೇಬ್ರೇ ಡಿಸೈಡ್ ಮಾಡೋದು ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ. ಅವ್ರು ಬಂದು ಅವ್ರು ಹೇಳ್ತಾರೆ. 34 ತಗೊಂಡ್ರೆ ನೋಡ್ಬೇಕು. ಸರಿ, ಅವರೇ ಹೇಳ್ತಾರೆ. ನಾನು ನೋಡಿ ಹೇಳ್ತೀನಿ ಯಾವ್ದು ಹೋಗ್ಬೇಕು ಯಾವ್ದು. ಎಲ್ಲ ನಿಂತಿದ್ದಾರೆ ಎಷ್ಟು ಜನ. ಸ್ಕೂಟನಿ ಬ್ರಾಂಚ್ ಇಂದ ಬರ್ಬೇಕು ಮೇಡಮ್, ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ಕೂಟನಿ ಬ್ರಾಂಚ್. ಇನ್ನೂ ಬರ್ಬೇಕು ಸ್ಕೂಟನಿ ಬ್ರಾಂಚ್ ಇಂದ. ಟೋಟಲ್ ಅದೇ ತರ ಕಂಪ್ಲೈನ್ಸ್ ಅಲ್ಲೇ ಕೊಡ್ತೀವಿ. ಹೌದಮ್ಮ, ಬೆಳಗ್ಗೆಯಿಂದನೂ ಸ್ಕೂಟನಿ ಬ್ರಾಂಚ್ ಹೋಗಿರುತ್ತೆ ಫೈಲ್, ಅದೆಲ್ಲ ಬರ್ಬೇಕು. ಈಗ ಒಂದ್ 2 ಇದೆ ಅಷ್ಟೇ.
Your lordship,
Yes. Yes. No, you place before that Loka Adalat only. Yeah.
File now, if you go along with it.
Along with the file too. I'm for the petitioner in this. 2 writ petitions are pending before this court, my lord. 2 matters are pending before the commercial court and 1 before the civil court. If all the files are called for before the Lok Adalat, on one day, everything can be settled, my lord. The
No, I
court-
said it is placed before the Loka Adalat. I think you have to produce there and parties have to be present, you have to sign there.
Yes.
If you want, it will be placed here.
Yes, my lord.
Instead of misplacing, you better you give it on that day itself. That is what the procedure.
With the file, my lords, because we have to now,
Co-
based on the orders.
Must
we have
hear.
to
Move the
other
matters.
courts also to send those matters also.
Yes.
Yes,
Before
my lord.
execution.
If an order may be passed, my lord.
Parties has filed in a
Memo along with the compromise.
memo along with the compromise and
My lord, ಇದರಲ್ಲಿ 2 documents have been filed, my lord. One is a settlement agreement.
transferring that. Refer this matter to Loka Adalat.
Please.
Memo is taken on record that matter is referred to Loka Adalat to be held on
8th of March.
8th of March. Yes. How connected matters put
My lord, if it may be transferred, commercial court, Lok Adalat, my lord.
Huh?
Commercial court, 8th of March.
ಎಲ್ಲಿ ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಲೋಕ ಅದಲ್ಲತ್ತ ಅಥವಾ ಇಲ್ಲ ಇಲ್ಲಿ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಲೋಕ ಅದಾಲತ್.
Oh, my lord.
Yes. How only one number. How many matters are there?
2 matters before this court.
Yes, now that this one and
12927, my lord. It's written in the memo.
Yes.
Yes, my lord. My lord, if the other suit, if the other proceedings pending before the commercial court and the civil court are mentioned in the order, we can move those matters as well to be sent to the commercial, to the Lok Adalat, my lord.
Oh, you have to request there.
We just make one small. These matters try to settle matters originally before the commercial court. We only request a small observation.
One
that
civil-
parties are liberty to move the relevant commercial court to have those matters also referred to. That
Yes.
And there is one
It is
civil-
also reserving liberty to the parties to move before the commercial court to
And the civil court, my lord. One civil court matters pending.
seek for transfer of that matter to
The Lok
refer
Adalat.
that matter to Loka Adalat.
Obliged.
This.
Yes.
This.
Refer to Loka Adalat, High Court of Karnataka. Yes.
Obliged.
Your lordship, there's an urgency in moving this matter. We are the petitioners. We've been in possession for 20 years. It was sold to us. Now the grandson suppressed, and it has gone all the way to Supreme Court and settled in our favor. Now the facts have been suppressed by the grandson saying there's a will, and he's got an ex parte temporary injunction order as well as ex parte police protection. So we filed a writ, and we've appeared before the trial court. We filed the written statement, and we're ready to make arguments, but it's being adjourned. We filed the writ petition this afternoon. If it may be kindly taken up tomorrow.
Yes, tomorrow. Yes. How many matters?
two matters, one for ex parte temporary injunction, one for ex parte police protection.
Yes.
My lord, one matter, my lord, the delivery warrant was issued on 15, my lord, and it is to be executed on 22. Therefore, it may be taken up tomorrow, my lord.
22.
Yes, tomorrow. Yes.
Tomorrow.
Yes.
Serial number 68, my lord.
70. 74, 75. Yes, at the request of counsel for the petitioner. Next week, Monday, I don't think, yes.
68, my lord. I have informed the other side.
68.
Yes.
At the request of counsel for petitioner. Read this matter next week.
Interim order by kindly
granted
placed.
earlier is extended till next date. Yes.
I'm sorry, my lord. One matter is passover matter, sir, serial number 20.
Yes,
Matter is little urgent. The reason is, my lord, there is an order of demolition.
yes.
This is university, deemed university.
No,
my lord.
we'll take that once you get the serial number.
Sir, ಇವಾಗ ನಾವು 34, sir.
No, one matter is on the middle. I will complete that.
Please,
Where is that?
I will-
Eಲ್ಲಿದ್ದಾರೆ ಅವ್ರ advocate? Huh? Yes, what is this, mister? Which is that matter? Krishnamurthy?
Serial number
What is that
20,
urgency?
Serial number 20.
Hmm.
There are certain office objection, but I am moving because the reason is not
Hmm.
the first, the petition.
No, why you are moving that? What is that matter?
Serial number 79.
Hmm.
Not accommodation.
79. You are appearing for?
Respondent.
Yes, at the request of counsel for the respondent, leaves this matter of 2 weeks. Yes, which is that?
This is the plaintiff petition, serial number 20.
Serial number?
20.
No, what is that urgency now?
No, urgency is not the Tahsildar has passed an order of eviction.
Hmm.
That not we challenged before this honorable court. This honorable court directed us to go to the civil court and file a civil. We filed a civil suit.
Wait,
And
wait.
also, my lord, we filed the injunction application before the Learned Civil Judge, district city civil court. The emergent notice has been issued. In the meanwhile, Tahsildar issued directed us to vacate the fort immediately.
Hmm.
Then we brought to the notice to the Learned Judge. He said, let the government file an objection. I'll consider it. No, my lord, today, just now, they have issued a letter. The Assistant Commissioner issued a letter to the Tahsildar to see that it is immediately demolished. My lord, there is a university and there is a school, colleges, my lord, thousands of students are studying there. And their claim is
No, that office objection has to be complied.
that we have to, my lord, we'll ask you till
No. No,
let
first-
them not precipitate government.
What are that office objection?
Office
It is
objection,
required
there
to
are
be
some
complied,
quite-
you have to be complied.
Come, not, the court fee we have already paid.
Then
We have paid other, we will.
jurisdiction to be stated in that
Other
cross
correct,
title.
my lord. There are certain objections are there.
Serial numbers to be indexed,
Well,
all that
correct.
which has to be complied. You comply it, I will pass over. Yes, we'll hear that. Yes.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ ಸ್ವಲ್ಪ ಅಬ್ಜೆಕ್ಟ್ ಇದ್ರ ಟೈಪ್ ಕೀಪರ್ ಸುಮಾರು ಮಾಡ್ಲಿಕ್ಕೆ.
No, typing, manuscript, all you are, I'm not, see, where there is an
Court
oath
fee is
commissioner
that-
signature, ಆಮೇಲೆ signature of the party, signature of a wakalat, court fee, without that,
ಅದು court fee has already paid.
no, all that which are relevant, otherwise I will
Paid
dispensing all that. Yes,
ಅದು
pass
court
over.
fee ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ, but we have already paid.
No, other office objection, you comply it, pass over, we'll see that.
Please.
Yes. Yes, continue.
Serial number, list number 1, serial number 34, Vandana PL for petitioner, connected matter, HK Srivastava.
Yes. 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 Where is that? Yes. This is Andhra Pradesh. Yes.
Read from paragraph number 21.
21. Yes. Wait, yes. Yes, read.
In principle, you have been further with the fact that what to transfer the case from the field of one district judge to the field of another district judge, we recognize the available district judge. The record principle of judicial hierarchy and providing in court will suffer severe loss. That is why the government will do a reference to section 3 of the law, which speaks about subordination of the court. Section 3 of the court reads as follows: subordination of the office of this court. The district court is subordinate to the high court in every civil court of the great individual to govern the district court, and every court of small purpose is subordinate to the high court. As per section B, a civil court is treated as subordinate to the district court only if that civil court happens to be of a great inferior to the district court. And since in terms of judicial powers, all district judges enjoy the same status, the learned law in municipal law that the presiding officer of the additional district court cannot be treated as a great inferior to the presiding officer of the district court. But in so far as the act is concerned, it was wanted to either about the adoption of the judges or about the subordination of another board judges. Then it's only about subordination of court and not subordination of judges.
Which section 3? Section 3, section 3 of the CPC. Subordinate court. The purpose of this court, district court is subordinate to the high court. Every civil court of a direct inferior to the district court and every court of a small purpose. Court of, yes. Yes. Yes.
24(1)(a) of CPC.
Yes.
Empowers the district court to transfer case pending issue to any court subordinate, provided such a court has jurisdiction to right and dispose of the state. If the interpretation of the municipal law is correct, the principal district court cannot transfer any case pending on its file to the court of an additional district judge, because the additional district judge cannot be treated as subordinate to the principal district judge. The principal district judge cannot also transfer a regular pending before the court of the senior district judge. Since such a judge, no subordinate to the principal district judge will have no jurisdiction and right to dispose of the case. These consequences arising out of such an interpretation would make the provision dead. To put it in differently, two conditions are to be satisfied for the exercise of the power, unless given 24(1)(a). First is that the court of which the case is to be transferred to be subordinate to the court ordering the law. Second is that the transferring court will also be competent to have the both the conditions made on 24(1)(a) will and satisfy only when the transfer is made from the principal district court to any one of the additional district courts. Therefore, section 24(1)(a) itself contains a clue as to how we should resolve the problem in hand. Petition driven administrative power and interestingly, the learned counsel for the respondent can more often than the principal district court upon receipt of the case. You have the power to distribute, allocate, or assign these two appeal or other proceedings to any of the additional district court. But this contention was that the distribution and allocation of work on the administrative side by the principal district judge stands on a different footing from the excess of the federal power of the court and transfer of judicial side. In other words, his contention is that what a principal district judge can do in excess of an administrative powers not be done by the excess of the judicial powers as the court of additional district judges are not subordinate to the court of district judges. The answer to the above condition is that it only because the court of additional district judges are not mutually subordinate to the court of district judges. So the dealing picture is created by section 24. The second is that an order transferring the suit or other proceedings from one court to another court cannot be treated as a judgment. Order of transfer is not. Section 18 of the court defines petition. Defines the word judgment to be the statement goes to the central account of the decree or order. The three segments of judgment according to the Supreme Court in most of the state of Andhra Pradesh or reasons for decision, final order and judgment. The declaration of final declaration of the rights of the parties in the matter before the court is what is agreed. And order of transfer of the case from one court to another does not bring to any dispute between the parties. Order is also not a decision of the case. The fact of the principal district that cannot say judgment or appeal over the judgment of different issues is not a one to word, but the principal district judge will not even have a power to transfer the case pending on the file of condemnation judge for it. While ordering the transfer of the case, the condemnation district judge neither pronounce a judgment on the merits of the case, nor exercise the power of judicial over any decision related to the additional issue. Therefore, the expression subordinate will not be possible. In for instance, the Supreme Court held that a lot of transfer of school, but on the top part of the case, not a judgment. Meaning of part of
ಇಲ್ಲೇ ಮಾಡ್ತಾ ಕುಂತವನು ಸ್ಪೂಟ್ನಿಕ್ ಕಳಿಸ್ಬೇಕು.
It must also be noted that in the decision for transfer case from one court to another, no order or decision of the subordinate court is found. It is only on the decision of order of the court is not a former to be subordinate to the title in terms of legal hierarchy. This is why section 3 of the court clearly uses the expression of the great superior. Therefore, in light of the foregoing decision, you have to consider that the principal district judge would have the power to require suit or other proceedings pending on the file of one additional district and transfer the same to the file of another district. As a cover, you are also considered with the decision of the one single judge in the municipal intervention does not affect the two spirit of section 24 clause 3A of the court and does not reflect that law of fact.
Yes, that is, High Court is exercising the power having, yes. Yes.
There is one more incidentally in the same before the third arbitration, where the federal council are saying no.
No, where is that? It is not with this. No, why you are giving peace? You have to give along with that one memo.
Up to the same point.
Yes.
Have already considered to this question of law.
Where is that? In respect of same parties,
Same parties. And same advocate.
they are more interest in litigation to than that more litigating that power of the district judge. Well, it can be transferred or not. Yes. Yes. What is that issue involved in this?
Right, same issue. Where the
That-
decision of the principal district judge whether he has the power to transfer or not.
Here also, there is an order of transfer.
Yes.
Yes, where is the facts? What is the facts? Yes. Hmm. Where you are reading? Paragraph 2. Yes, yes. Issue appropriate writ or direction quashing the notification under challenge notification dated. What is that notification? No, that is an order. Notification means what? Is it a notification or an order?
In this also we have section 24.
Yes, let us. Yes. Read. Has transferred the 2S suit, additional city civil judge Bangalore to additional. Yes. Writ petitions are. Yes. In such application, second divisional interlocutory application filed a plaintiff grant of temporary injunction. Where is that issue? Power of the judges. Para 6. Para 6. Yes.
And sought a passage to the over. This court without expressing any opinion on the matter of the order with the and there are the reasons for the meaning of the among the issues of the provider of the and group of and anyway, in an order we have in fact party will also handle to go and for government advancement of the not to enable the before the the application was heard and it was before the further the principal instituted regular issue the issue of the transfer of the issue from CH 38 to CH 5 by virtue of power vested in under section 5 of the language issue section 5 of the language and transfer the same for being imposed of any other arrangement. The power of principal citizen is to affect the transfer of two. Form part of the power to arrange the distribution of among the coordinate of this court by the power and ambit of principal decision section 5 of the language act. And section 24 of this is the case of Turkish was already published.
No, this is Justice this is KL Manjunath. No, that one more judgment. Justice. Another judgment which you have produced that has been reversed in Hyderabad. This is Tilari. No, this is Justice Tilari's judgment or KL Manjunath judgment. Tilari's, that's what I am asking. Justice Tilari, not Manjunath. Yes. This is what it is referred in. Yes, yes. Satyashree is the judgment of Justice Tilari, not KL Manjunath. Yes. Yes, read. Whenever the. Yes.
Whenever the expression district court has been used in the court of civil procedure, it means in reference to the principal civil court of other jurisdiction. Hierarchy of the court of administration of the justice has been created with the conflict of the court and as well as by the language state of language, Karnataka state legislative for the language for the city of language. Specifically, court under the section of the language.
That judgment has been extracted. Yes. Yes, now that para 9.
Examining as to whether the secret of the court of language considering the problem issue is second by the language now opinion the petition for the ability to each of the data report is about to extend all or any of the power to decide the against the order of the under the rules Therefore, if the judge of small claims court had not been appointed as a judge, who had no duty to do it, so number of vacancies in the office of utility is another feature of active of an officer belonging to care of a notification issued by the High Court is read as.
Yes.
The wording of the notification is good. The chief judge of the court of small persons is appointed as a therefore, there is nothing of the importance of chief judge of small persons of also the and therefore, by virtue of section 5(1) of the language was completing the public interest in the of the authorization and the answer the public report as well. The chief judge of the court of small persons language having been appointed as a judge of the as a jurisdiction of the court of the
Yes.
as in the light of the aforesaid discussion, neither of the parties can be heard to contain that there is no power available to the principal under section 5 of the require particular case from one court and allot it to or distribute it to another entity on doubt submitted in relation to decision making process adopted in the instance that the insurer cannot be distributed to other matters as ought to be done. As seen from the argument made in the petition, the petitioners are only expressing that a doubtful situation arises on account of sequential events that has unfolded or obtained the fact in the light of such apprehension, it cannot be gainsayed by the petitioner the principal decision error in section 5 or the decision of principal decision between the parties. However, the technical itself will be asked to state that any case for the litigant of it to permit the scheme of justice will not be allowed in support of on and on such either the with respect to
Yes.
but the principal decision as the power to allocate the matters of transfer the matters to the other master of the decision with the conversation was very clear.
Yes.
That it's not a judgment there is the principal decision is not sitting as an appeal.
Yes.
There is only a order there with respect to the regular business.
Yes, Mr.
Jayakumar is in Harvard bench, my lord, may kindly be passed over at 3:30 or tomorrow, my lord.
He's the no other he wants to argue. Another senior counsel, Mr. Sham.
He's also in Harvard.
Where is he? He could have
In Harvard bench, physically in Harvard. May I request this?
tomorrow 2:30.
Yes, ma'am.
You have to conclude
Yes,
tomorrow,
ma'am.
both of them. Tomorrow 2:30.
Interim order, my lord.
First or second 2:30. Interim order granted, release this matter tomorrow at 2:30. Interim order granted earlier, till next date of it.
Right.
Yes.
Serial number 35, Hari Krishna Pramod for petitioner.
Yes. What do you want? One time?
In fact, I saw them on the last date itself.
What is this matter, Mr.?
This is a writ petition arising out of a summary suit in the commercial court.
Yes.
I am for the plaintiff in the commercial suit where I filed a summary suit. The defendant 1 and 2, there were initially 3 defendants, 1 defendant has been deleted. Defendant number 1 is a partnership firm, defendant number 2 is a partner in the said partnership firm. They appeared before the commercial court and sought for leave to defend. The order under challenge today is an unconditional leave to defend. So my writ is restricted to the unconditional leave that has been granted. I am saying that it should have been a conditional leave. I am not questioning the fact that the leave should have been granted. I am merely saying that it should have been a conditional leave subject to deposit.
Where is that order?
Kindly see the impugned order. The impugned order is at page 40. Annexure A.
Yes,
The reasons your lordship will find at page 43.
yes,
It's a short order.
yes, read.
I will read the relevant portion where the leave to defend has been referenced. Kindly see para 11 at page 44. This is the reason that has been given by defendant 1 and 2.
Yes,
Para 11, in the affidavit filed by defendants number 1 and 2 seeking leave to defend, the defense which is sought to be disclosed is that the sum of rupees 1 crore was paid by the plaintiff to defendant number 1 in pursuance of agreement under which the plaintiff intended to purchase the said property belonging to defendant number 1. In pursuance of the said agreement, the sum of rupees 1 crore was paid as part consideration in order to enable the defendant number 1 to seek 3 approvals from KIDB for transfer of ownership rights to the plaintiff. And it was in pursuance of the said agreement that the plaintiff was put in possession of the property. After defendant number 2 incurred substantial expenses and secured permissions from KIDB for transfer of ownership rights to the plaintiff backed out from the transaction. It is contended that the plaintiff had gotten executed a lease deed produced in the present suit behind the back of defendant number 1 and 2 by colluding with defendant number 3. I will just pause here. It is admitted that defendant number 3 is a partner in defendant number 1 firm. They are not denying it. There appears to be some inter se dispute between defendant number 2 and 3, which is why defendant number 2 and defendant number 1 being the partnership firm have distanced themselves from the conduct of defendant number 3. But they don't say that defendant number 3 is not a partner of the firm. Kindly.
No, all the partners is not necessary for executing.
Because the lease deed has been executed by the partnership firm in the name of the partnership firm.
No, by the authorized person.
All partners are in a partnership firm are authorized to engage
Any person can do anything under that partnership act, or it should be certain procedure.
Under the partnership act, if they are working partners of the firm, they can inter se act as agents for the firm. That is the principle. The partnership act itself provides for.
Let us see what. Yes.
Kindly look at the order.
Yes.
I will continue. It is contended that I'm reading at page 45 on the top.
Yes.
It is contended that the check pleaded in the plaint was given by defendant number 2 as security towards the payment of advance sale consideration of rupees 1 crore, which has been misused as if the check was issued for repayment of security deposit amount of rupees 1 crore. Again, so this is
Transaction, what is the lease?
the transaction was there was a lease deed that was entered into between the plaintiff and the defendant number 1.
Lease of what?
Lease of a industrial plot.
Industrial.
Plot.
Yes.
Under that lease deed, the plaintiff had paid rupees 1 crore to the defendant. The lease was for a period of 3 years.
Yes.
At the end of the 3-year period, I said, please give me back my security deposit. They said, no, this money was given by you pursuant to a transfer of leasehold rights with KIDB. And in fact, it is admitted by them that the transfer never happened. So today, as far as my security deposit is concerned, we are saying that it is liable to be refunded to us. For that purpose, a check has been issued. So while defendant number 2 distances himself from the lease executed by defendant number,
given a check.
the check has been signed by him as well. In fact, it has been signed by both defendant number 2 and 3.
Yes.
My entire suit is based on the check. It is not based on the lease deed. The lease deed is a collateral document to establish why the check was given.
Yes.
But today what happens is when the check has been issued by them, the learned trial court does not go into the fact that the check has been issued at all. What the trial court goes into, kindly see at para 12.
What is the prior in that your suit?
In my suit, it is for a refund of rupees 1 crore
That's all.
along with interest. That is all I have sought for. Kindly see para 12 at the bottom of page 45.
Yes.
At this stage, I am of the view that defendant number 1 and 2 have a substantial defense and therefore should be given leave to defend for 2 reasons. I have no difficulties as far as the leave to defense is concerned. Firstly, it is pointed out by defendants number 1 and 2 in their affidavit that the lease deed on the basis of which the plaintiff is seeking refund of rupees 1 crore on the ground that it was paid a security deposit amount is dated 1/8/2019, whereas the stamp paper itself was purchased much later on 28/8/2019.
Yeah.
Thereby, it is contended that it is a manipulated document. And then the learned trial court extracts a judgment. And para 13 at the bottom of that page. Therefore, the genuineness of the said lease deed has to be considered in the trial. Since on the very face, it appears that the document is antedated, since document is dated even earlier than the date of purchase of the stamp paper, it is to be noted that the said lease deed is the basis of the suit claim in the present case. And at this stage, doubt is attached to the genuineness of the same for reason noted above. And therefore, it follows that the suit cannot be decreed without the matter having to gone into trial.
Yes.
The entire order is based on the genuineness of the lease deed. Now, it is not a case where the lease deed was antedated by about 15 days. What has happened was the possession was given to me on the 1st of August 2019. Kindly look at the lease deed as well. I have produced the document as well at page 70 of my petition.
Yes.
This is the lease deed. Your lordships will see on the top, the stamp paper was purchased on the 28th of August. Now, what has happened is this property was given, the possession of the property under this lease deed was given to me on the 1st of August 2019.
Yes.
So inadvertently, what the parties have done is instead of saying that the property was given on the 1st of August 2019, they've dated the document also as 1st of August. It
No,
is a
but that
difference
has
of
to be-
about 27 days.
No, that has to be decided by the trial.
I understand. If they're challenging the genuineness of the document, it is their prerogative. I'm not on that point.
Yes.
I am only on the point that there is a check that has been issued. There is no contention with respect to the check except to say that it has been given as a security check. It is not their contention that the check has not been given. It is not their contention that I have not signed this check. Defendant number 2, who is a contesting party, has signed the check. Their contention is not, it has nothing to do with any of these defenses that they have raised. In fact, kindly look at their leave to defend as well, which is at page 140. That their entire leave to defend rests on the fact that there was a transaction which was contemplated between the parties for transfer of these leasehold rights.
140.
140, yes.
Yes.
Para 3 on the bottom of page 141. Your lordships will see there are 3 sub headings in Roman.
Yes.
These are the 3 contentions that they have taken. The first is that the sum of rupees 1 crore was paid as part consideration towards enabling the first defendant to seek necessary approvals from KIDB for transfer of ownership rights from the first defendant to the plaintiff. So which means that they were supposed to transfer their leasehold rights to me and therefore the 1 crore was given. Kindly look at the next one. Simultaneously, the plaintiff was put in possession of the property as it was assumed that in the due course of time, they would own the property.
No, ultimately they said that it is not in a security deposit.
They are saying it is not a security deposit.
Yes.
But today the position is that they have already filed a written statement. They have not produced a single document which demonstrates that such a transaction ever was contemplated between the parties. The contention is present in the leave to defend, but especially in the commercial code, they're required to produce every single document in their possession in defense of their case.
No, that may be advantage for you to get.
It is an advantage. It is also, in fact, an advantage because
this is a case for granting in a leave.
It is a case for granting of conditional.
Where is that you say that they have to be deposited that amount?
I will point out the legal provision as far as that is concerned. Kindly look at order 37. CPC.
CPC. Order
37. Order 37, Rule 3.
Yes.
This is order 37, rule 3, sub rule 5.
Yes.
There is a proviso to sub rule 5.
Yes.
I will read the proviso, the second proviso, in fact. Provided further that where a part of the amount claimed by the plaintiff is admitted by the defendant to be due from him, leave to defend the suit shall not be granted unless the amount so admitted to be due is deposited by the defendant in court.
Yes.
This is what the second proviso says.
Yes.
Now, my contention before this court is the check which has been given for rupees 1 crore is after the entire transaction that the defendant claims to have happened with respect to the transfer of leasehold rights. Because the letter from KIDB admittedly was received in Jan of 2020. Thereafter, I gave a letter in March of 2020 saying that I am no longer interested in taking this property.
Yes.
A check admittedly by their own admission in their leave to defend was given in September of 2020, which is 6 months after this entire transaction of wanting to transfer the leasehold rights, and their subsequent cancellation happened. So once the check has been issued, there are several decisions which say a summary suit which is based on a check that has been given by the defendant in favor of the plaintiff has to be, the defense that has to be put up by the defendant to seek the leave to defend must be on a higher pedestal. Because there is a statutory presumption under the Negotiable Instruments Act. While that is not directly applicable as a presumption in a summary suit, that statutory presumption should be given certain effect in considering whether the defense put up by the defendant is of nature which is triable or a plausible defense in the first place.
What is that answer? Trial court has not discussed that point.
Trial court has not discussed it at all. In fact, there is no reference to the check. The entire order is based on the fact that the genuineness of the lease is contested. That is all. There is no discussion on the check. Why? Their contention is that it has been given for a security purpose. It is not a denial of issuance of the check at all. So in that situation, I am saying that let that amount be deposited in court. I am not seeking for it to be paid to me. In fact, today in the written statement, they say I am still agreeable to settle the entire amount for a sum of rupees 55 lakhs. It is a categorical admission, their written statement. So my submission,
The written statement.
in the written statement in the suit today, in fact, it's not part of the petition because it was filed subsequently. I will just hand over copies.
Yes, what is that?
Tell me the written statement. I will just point. You don't need copies. I will just point out the relevant portion. So today, what has happened is, while my colleague is assisting me on that, there are two admissions that I am relying on. One is their admission while in the written statement, they say 55 lakhs as a full and final settlement. So my learned friend may take a contention that, look, if we are settling it once and for all, I will pay you 55 lakhs. Otherwise, I am not admitting anything. It is an alternate argument that he may say that he is making. But today there are two admissions. One is their admission in the written statement to say 55 lakhs is an amount that I'm willing to pay. The second is a check for rupees 1 crore that they have given me. So I am saying I am not on whether it has to be an amount of 55 lakhs or 1 crore or somewhere in between.
What they are saying 55 lakhs for what?
As a full and final settlement towards the refund of security deposit. Para? Your lordships will find it in para 10 of the written statement.
Where is it stated?
In the written statement, kindly see para 10.
Para 10.
Around the fifth line. The fact that rupees 1 crore may have earned some interest and the fact that second defendant had expended time, energy and money towards KIDB related work was all considered, and a sum of rupees 55 lakhs was offered towards closure, but the plaintiff did not agree. Even to date, the second defendant is willing to remit rupees 55 lakhs to the plaintiff towards full closure of all claims of the plaintiff. It is a categorical admission that even today he says 55 lakhs is due and payable.
Where is that regarding check?
In the written statement?
Yes.
In fact, as far as the check is concerned, they say it's a security check that was handed over. In para 4, your lordships will see that in the third line,
Yes.
the entire transaction was negotiated by Mr. Vivek Shah with the second defendant. Vivek Shah is the representative of the petitioner.
Para 4.
Para 4 of the written statement.
Yes. In pursuance of aforesaid.
In pursuance of the aforesaid understanding, the plaintiff remitted a sum of rupees 1 crore over a period of time from so and so to so and so in favor of the first defendant. Even prior to receipt of the entire aforesaid amount, the plaintiff was put in possession of the premises on 1/8/2019. The entire transaction was negotiated by Mr. Vivek Shah with the second defendant.
No, where is that? They have issued a check.
The next line. Around the same time, as a measure of security, the first defendant handed over a check bearing number so and so in the year 2020 itself towards the amount in question. In their leave to defend, they have produced a check slip to say that this check was handed over in September of 2020.
What is that security?
The security is the security that I have given them. Their contention is that they are securing my 1 crore which I have paid to them. I mean, my learned friend seems to have a different perspective, but that is the security that they're giving. That is the reason that the 1 crore tallies between my amount and their amount. So today, all I'm asking for is there is an admission to say 55 lakhs is still payable as per the written statement. There is a check for rupees 1 crore admittedly signed by the contesting defendant today.
Yes.
They should be put to terms as far as defending the suit is concerned. The proviso to sub-rule 5 that your lordships read, there is an admission, there is a categorical admission. Whether the admission is of 55 lakhs or 1 crore becomes immaterial. I am merely saying that it should have been a conditional leave to defend that the trial court had imposed on them.
No, that it is not that entire amount. If the defendant is permitted to defend as to that whole or any part of the claim,
court or the judge may directed him to give such security and within such time as may be fixed by the court or the judge, failure to give within that. It is for the court to fix.
Correct, but kindly see proviso 5, the second proviso to sub rule 5. The second proviso says where a part of the amount claimed by the plaintiff is admitted to be due from him, leave to defend shall not be granted. It is a mandatory provision. Shall not be granted unless the amount so admitted to be due is deposited by the defendant in court. As far as the admission is concerned, there is no discretion.
What is that 6?
6 is subsequently, once a leave to defend has been filed, sub rule B is what would be applicable in this case. If the defendant is permitted to defend as the whole or part, as to the whole or any part of the claim, the court or the judge may direct him to give such security and within such time as may be fixed by the court or judge, and that on failure to give such security, the court may proceed to pass a judgment.
Yes.
That is in cases where there is no admission. But so what happens in a leave to defend is they are required to put up a triable or a plausible defense with respect to the suit. If they do that and there is no admission in the fact matrix of that case, this provision would apply. But insofar as an admission is concerned, sub rule 5, the second proviso would strictly apply. I have in fact several judgments. There is one judgment of the Supreme Court and other judgments of
No,
the...
that is provision is very clear.
No, this is in fact on the provision that the... Give me the one on the check. I know, I have to give them one.
No, if there is an admission.
These are all of these are the citations which specifically say that when the summary suit is based on a check that has been dishonored, it is placed on a higher pedestal with respect to the defense that has to be mounted by the defendant. Kindly see the first one. It's a Supreme Court judgment. I will only refer to that one and the second judgment. This is VK Enterprises. This is a decision of 2010. Kindly look at para 8. This, your lordships will find it at page 3.
Para 8.
Para 8, page 3.
Yes.
Around the 6th line from the top.
Yes.
What is required, Anta Shura?
Yes.
What is required to be examined for grant of leave is whether the defense taken in an application under Order 37, Rule 3 makes out a case which, if established, would be a plausible defense in a regular suit. In matters relating to dishonor of checks, the aforesaid principle becomes more relevant as the checks are issued normally for liquidation of dues which are admitted. In the instant case, the defense would have been plausible had it not been for the fact that the allegations relating to the interpolation of the check is without substance and the ledger accounts relating to the dues clearly demonstrated that such dues had been settled between the parties. Moreover, the issuance of the check had never been disputed on behalf of the petitioner, whose case was that the same had been given on account of security and not for presentation, but an attempt had been made to misuse the same by dishonest means. It is on identical factual matrix. Now kindly look at the next decision. This is a decision of the High Court of Bombay, which has been subsequently relied on by several other courts as well. The judgment starts at page 4. Kindly look at para 14, which is at page 8 of my compilation. Paras 14 and 15, in fact, have been extracted in several subsequent judgments as well.
Yes.
Para 14. When a summary suit instituted is based on a check which is dishonored, effect of sections 138 and 139 of the Negotiable Instruments Act, raising statutory presumption that the check was issued in discharge for liability, is a relevant consideration to be kept in mind. The said sections cast a burden upon the defendant to rebut the presumption. Summary suits instituted on checks which are dishonored will therefore stand on a higher footing than summary suits instituted on a basis of other documents. In such cases, the court will have to take into consideration the statutory presumption which is raised when the checks are dishonored. The object behind providing a statutory presumption under the Negotiable Instruments Act has to be kept in mind while judging the credibility of a defense raised by the defendant in a summary suit. Thus, the test of more than shadowy and less than probable, as adverted to the apex court, cannot apply in cases where the law requires a person to explain certain state of affairs. The judgments which are relied upon by the Learned Counsel do not consider the effect of a statutory presumption raised under the Negotiable Instruments Act where a check is dishonored. In our opinion, when a check is dishonored, the court is enjoined with the duty to scrutinize the defense put up by the defendant with a much higher degree of care and circumspection. Such summary suits cannot be treated as on par with cases instituted on contracts or invoices, where such statutory presumption does not operate. Then subsequently in para 15, they talk about what the legislative intent of section 138 and 139 of the Negotiable Instruments Act were. My entire writ petition is just this. I am saying that there is a statutory presumption under 139 of the Negotiable Instruments Act. There is an admission by issuance of the check. The check is admittedly dishonored. I have in fact produced the dishonor memo before this court as well. In fact,
Initiated any proceedings?
we chose to initiate a summary suit. In fact, a 138 notice was issued to them. At that point of time, the plaintiff decided to institute a commercial suit rather than institute 138 proceedings. That was the only difference. And as far as the summary suit was concerned, it was based on the check and not on the lease deed. Unfortunately, the learned trial judge is gone on the presumption that the entire suit is hinged on the lease deed. But the actual admission that we are referring to as far as the admission for a summary suit is the issuance of the check. It is not the lease deed at all.
This is your plaint.
My plaint,
Leading is 123.
yes. Plaint is at Annexure C 51.
51. Yes.
Kindly see para 14 at page 56.
Yes.
It is submitted that after multiple requests, the defendants finally issued a check bearing number so-and-so towards their repayment obligation. As such, the issuance of the said check by the defendant also evidences the acknowledgement of their liability to repay the security deposit as per the terms of the lease agreement dated so-and-so. However, despite admitting their liability to the plaintiff to refund the amount of rupees 1 crore, the defendants have failed to make the payment and clear their dues. The issuance of the check in favor of the plaintiff, the corresponding agreement between the parties and the bank records clearly demonstrate that the defendants admitted the liability to the plaintiff and hence issued a check in favor of the plaintiff. My suit is based on the check. It is not based on the lease deed. That has not been considered by the learned trial judge at all in deciding whether unconditional leave or conditional leave had to be granted to the defendants. So my prayer before this court is, let them be put to terms as far as deposit is concerned. In fact, the trial has reached the stage of evidence as of now. So while there is no stay on the trial court proceedings, that is proceeding. But today, as far as the leave to defend is concerned, my only prayer is that they should be put to terms. Whatever this court determines, I'm perfectly fine with whatever this court determines based on their admissions. But it should have been a conditional leave to defend is what we are seeking.
Yes, Mr. No, anyhow, you are agreed for 55 lakhs. Some amount you deposit subject to the.
In the meantime, the plaintiff comes and says, I'm willing to buy out your property. You please get whatever is required to be done. If AID, because if AID has to change,
Yes.
they have to execute the AID. There is going to be some expenditure, there's also going to be some process that has to be carried out and also get a transfer fee.
Yes.
In the meantime, the plaintiff also negotiated with me the value of the property, because the entire industrial estate has been, which I'm given to understand was the rate of 5-6 crore was the negotiated number. In pursuance of that, 1 crore was given as advance sale consideration. And that 1 crore I was going to use, 1 crore all the KID to repay work. This is the 1 crore I was given. And then after they pay me 1 crore, they ask me what is the security for this, what is the other repay 1 crore. So which a check is given to cover that 1 crore advance sale consideration. Not as if they are going to 1 crore towards lease deed. So never going to pay lease deed. And then this lease deed, which they say that the form has signed, very conveniently reflected where the form has signed. It is signed by the third person who is the third defendant.
Yes.
Who is also a partner. There are interstate disputes between the second defendant and third defendant.
Yes.
Plaintiff conveniently believes the third defendant from the area parties. He does not want the third defendant to come before the court. He is happy that only I come before the court. I have not even signed that lease deed. So if your lordship kindly take up that lease deed again, like page number 70. The doubt that is arisen in the mind of the commercial court is the veracity of this document. Page 70, your lordship will see.
70?
7-0 of the petition.
Yes. Yes.
This stamp paper is purchased on the 28th of August 2019. Right on top, you will see the second line there, it's an account reference certificate issue date.
Yes,
This is on 28th of August 2019.
yes.
This lease deed is supposed to have been in force from first day of August 2019, which will say the water.
Yes, yes, yes.
Then you will also see that this lease deed is signed by this person called Raghavendra Swami,
Yes,
who holding out as partner of the first defendant,
yes.
who today he created deletes from the arrangement of parties. He said, I don't want this party, I'm happy to move these people. The entire negotiation, the entire transaction is with the second defendant. The people know that such a deal has been executed. They get it signed on the side without my knowledge, I third defendant who is deleted from the arrangement of parties. Therefore, I will take the conviction that the plaintiff and the third defendant are handing law, therefore they have deleted the third defendant from the arrangement of parties. And then it is told to the court that the entire case is based only on that check. Two aspects when it comes to the check. From the claim, I will request the court to kindly take the claim. My friend said that my full case is only the check and nothing else.
Yes, yes.
Because the lease it may got registered. Other than for ancillary purposes, cannot be considered. Tenancy gave the stamp duty paid for. I will again go back to the legal issue. The circumstances of the stamp duty paid on the lease. The first to the claim. Please look at item from prior to create a case. Item from five. It did not reflect that. So given in proceedings of the lease. Item five is not this. In proceedings of the lease agreement, it was agreed that the plaintiff will deposit the sum of rupees 1 crore to a deed in the scheduled property without any rent or the duration of lease of 36 months. Security deposit was paid to the defendants by the plaintiff in the following manner.
No, whatever may be the reason, if you check you have given, if it is bounced, then he has a remedy to file in a summary suit.
Happy with check also. So my friend also read para 14 of the claim. Para 10 of the claim.
I read 40.
Read 10 and 14.
No, I read only 40.
14.
I will read 10 as well. I will read 9 and 10. Just to show the circumstances in which he claims
No,
that the check
that
was
will
given.
come to that later. Whatever may be the reason.
What he tries to say is that we entered into the lease, they paid you 1 crore rupees, you were supposed to return the money to me, I handed over possession to you, then you gave me 1 crore rupees check. It's the case that is made out in the claim. But the fact remains, and I will for now stick to my leave to defend, I have given some proof to show that this check was given in 2020 itself.
Yes.
Why will I give the refund of the security deposit? He claimed it as a security deposit, he claimed it as a lease amount. Why would I refund the
No,
amount?
no, one thing, you answer. See, whatever may be the reason, you have given a check. If the check is bounced, then Negotiable Instrument Act Section 138 is start attracting. If that suit is filed for recovery, that check amount is given for whatever the purpose, once you have admitted that it is your signature, you have given a check, then this provision will not applicable, that you have to be deposited that amount. Then you can argue after that saying that check is for this purpose, this is not the check. The thing is that check is given to you, it has been bounced, then he has a remedy to file 138 or that suit. If it is suit, check is an admission, therefore you have to be deposit. That is what that simple. All that you may be argued it is for any merit, it's correct. But now that prima facie is saying that check is bounced, filed in a suit for recovery, that check which has been given this bonds, therefore that provision is applicable before granting the leave deposit.
Presumption and would be available in the negotiable instruments and would not be available for the summary suit for the reason that I am given a chance to show, like in a check bounce case in a negotiable instruments act, there's a statutory presumption that I have given a check for this kind of a legal responsibility. Then the onus is on me to prove before the magistrate that I have not given the check for a legal responsibility. Now, a similar opportunity to me is available in the leave to defend that I filed before the court. And there are two things that I've stated in my leave to defend, because that is my first right that I get to rebut the presumption.
No,
If you are
therefore,
going on a presumption that
if you have any make out in a case that there is a ground for defense,
that's the reason
no,
for-
that's why that is granted. When you are granting the issue in respect of admission, the provision
Absolutely.
says you have to be deposit.
Not just deposit. my lord also read there, and I will just, without going into provision, learned friend also referred to this judgment in his own petition. It's not as if I have to only deposit the money. There are many things that can happen. So also purpose based on the degree of defense that I set up before the court. My lord could kindly take para 17 of the judgment where they summarize the principles with respect to the summary suit.
Yes.
Page 596. According to principles stated in para
596.
596 of that.
Yes. Paragraph 16.
Para 17.
17. Yes.
According to principles stated in para 8 of McLeod case, will now stand in consideration. Given the amendment of authorization, will get widely visible to the court that is in Vikram case as follows. If the defendant satisfies the court that he has a substantial defense, the defense is likely to succeed. The plaintiff is not entitled to leave to sign judgment, and the defendant is entitled to unconditional leave to defend the suit. That is point 4. And then, if the defendant raises triable issues indicating that he has a fair or reasonable defense, although not a positively good defense, plaintiff is not entitled to sign judgment, and the defendant is ordinarily entitled to unconditional leave to defend, even if I make out a fair or reasonable defense.
Yes.
And then point number, if the defendant raises triable issues, if the doubt is left with the trial judge about the defendant's good faith or the genuineness of the trial issue, the trial judge may impose conditions both as to time or mode of trial as well as payment into court or furnishing security. Here it will be taken to see that the object of the provision to assist expeditious disposal of commercial causes is not defeated. Care must also be taken to see that such trial issues are not shut out by unduly severe orders as to deposit or security. I will stop. Now, the points number 1 and 2 that I read out. The first instance where I make a fabulous defense and the court gives me an unconditional defense. The second instance where I say it's either a fair or a reasonable defense also need not even be that same threshold as the point number 1. The fair or reasonable defense is also sufficient to give me an unconditional defense. And the court also says that it is not just a deposit of money. It also says conditions both as to time or mode of trial. In fact, when I argued this application before the commercial court, I said, put me on terms in terms of time. I will not take a date. You please fix a calendar and we go ahead with the matter. And as it stands today, tomorrow the case is posted for cross-examination of defendant's witness. If that is concluded tomorrow, probably 2 or 3 days away from closure of the matter. I have not delayed the matter in any terms whatsoever before the trial court.
Yes.
And my learned friend tries to today place a written statement on record. If that be so, then I would want to place even the cross-examination of PW on record. We have not transferred the trial to the High Court today. This court does not have to look into written statement or the cross-examination of PW1.
Yes.
Those are all matters which the trial judge will look into. All I am saying is, even in the claim, what they try to make out is that I have given the 1 crore check only after they handed over possession to me, only after they followed up with me. That is what they say in paragraph number 9, 10, and 14. My friend had only 14, where they say it's only the check. But where did the check come about? In the claim, they say after I followed up, he gave me the check. But the fact remains that in my leave to defend, I have shown that the check was given in September 2020. Fact also remains, which I won't trouble this court with. In the cross-examination, the witness has admitted that the check was given much prior as security. Therefore, where is the question? Therefore, I would say that I have discharged that first threshold of presumption that the check has been given for a legally enforceable date through my leave to defend, where I have also given the check details to say that this is when the check series was given in 2020. And why would I give money to him when he's not even handed over? In his case, the lease amount that is given to me for 3 years, would I return the money to him within 3 months of the lease starting? August is when the lease started. According to August 1st, would I in September 2020 give him the lease amount back? Check for the lease amount? I would not do that. We still have possession of my property. All of these raise the doubt in the mind of the commercial court that this is a fit case. And there is a good enough 17.1 or 17.2 to give unconditional leave to defend. And the case has proceeded, but my friend will agree that I have already cross-examined this witness. He is cross-examined
In
my
fact,
witness.
Your Lordship may read 17.6. My learned friend very conveniently stopped it on 17.3.
Yes.
Kindly see 17.6. If any part of the amount claimed by the plaintiff is admitted by the defendant to be due from him, leave to defend, even if tribal issues or a substantial defense is raised. Whatever my learned friend is saying today is a substantial defense as per his case. But the Supreme Court itself says that even if there is a substantial or a tribal issue that is raised by them as a defense, if an amount is admitted, it shall be deposited.
Yes.
Leave to defend cannot be granted unless the said amount is deposited. I am only on this provision, and this is pari passu as far as the proviso to sub-rule 5 is concerned. I am merely seeking for deposit. My learned friend is behaving like I am asking for the money to be paid to me. I am saying, let me be secured before this court. That is all I am
Now
seeking
that
for.
It is the end of the trial. Now it is the end of the trial. What the purpose will serve?
I understand. The question is, in fact, this petition was filed much before. It's come up before your lordship, unfortunately, when
No, that,
the trial is proceeded.
then by the time it would have been,
It will become a.
we could have argued from the reverse. I could have urgent it because I could have saved the time and I could have heard some other matter. There is no urgency and important thing is there in this case. At this stage, in the beginning, it was
I
there.
understand. In fact, the urgency today is, in fact, I will capture what the urgency is also. Like my learned friend said, there is an inter-se dispute between defendant
No,
number 2
in
and
the
3.
Day one you have filed. Actually, yes, you have in a case and think that matter may be dragged. If the amount is deposited, then it is a security for. Now it is a fag end of that case.
No, there is in fact another factor. The reason we are actually pressing on the conditional or the deposit is today there is an inter-se dispute, as my learned friend said, between defendant number 2 and 3.
Yes.
The defendant number 1 partnership firm is largely defunct. There is no revenue as far as we are aware, and because they have no other functioning. This was the only property that they owned. That property has been disposed of today to a third party. So today what happens is I will have a decree in my favor without any possibility of executing it, for which I have to run behind them again. So the reason of securing me is to ensure that I am secured in case I have a favorable outcome in the suit. That is the reason I am pursuing this.
Rule 5 is available. If we felt that he is not secured enough.
This is an option that is still available to me. If I have multiple options, I can exercise whichever is available to me.
And preliminary option available for him.
There are several options available to me, but I am exercising one that I am legally entitled to.
Did not have case to make. Maybe a 6 full 12, maybe a 13 full 5. All of
No,
them
that's,
are-
see,
If we say
now if you say trial court has not applied his mind, he has to reconsider. It is not possible.
It is not possible. That is the reason I am saying I am not seeking for the leave to defend to be set aside. I am merely saying that based on
In view
the
of that
facts.
case has been went to that stage, I don't think any necessary order, or I can say that
7 memo. Not as if the court did not exercise its jurisdiction or exceeded its jurisdiction or there is an error apparent on the face. This is not a case where we can now substitute.
then thing is that he is also not taking that adjournment to drag that matter and all. Now it is a fact.
That is owing to my learned friend's conduct. It is not the intention of his party. His party would like to drag it on, but my learned friend is not dragging it.
I can put it. I can put the term and close it.
He's saying that he's being cooperative.
I mean, I can't make any allegations against my learned friend as far as the case is concerned.
Or we will have it after 2 weeks. Let us see what will happen in the.
In all likelihood, in another 2 weeks, the judgment would have been passed in the matter.
Yes, instead of I am giving any finding here.
For us, it was also because as of today, there is no other decision from the Karnataka High Court on this point. So for both me and my learned friend, it was also an
Provision
interesting.
is very clear.
The provision is clear, but there are no decisions on this point from our High Court.
Rightly you have pointed out, he has read only that condition.
17.1 and 2.
That that provision has been taken care of by that 17.6.
Absolutely.
If it is an admission, then it has to be. If there is no admission, then these are all the options.
Absolutely.
Yes, we'll have it after 2 weeks. Let us see that.
Please.
Yes. There is no need of any judgment. I don't think the provision is very clear.
Please.
Yes. And this judgment is also, I think it's clear.
It is the latest judgment which has been relied upon by all the other
Yes.
subsequent decisions.
Clear. Otherwise, you could have written a judgment to helpful for the trial court, but all
No.
this is clear. I don't
It
think
becomes an academic exercise more than a
Yes, yes.
much.
No, that both of them has assisted well. That's what that we needed, yes. Yes, call this matter of 2 weeks. Serial number?
61, my lord. The matter is at the stage of compromise, my lord, of settlement.
That compromise petition.
Yes, my lord.
Yes, 230.
Is a suit for partition, my lord. FDP Aki, FDP Nalli. There is an order that
Parties have come.
parties have come. It is my learned friend has to, their party have to sign it. My parties, all of them have signed the the joint memo also.
Where is your party, mister? Parties, let them have a signature and produce that.
Free to sell the property to the prospective purchaser.
No, if both are agreed and settled, then only.
Milord,
Then in the
Milord.
settlement, more responsibilities on the councils to see that it is proper. We will trust that council and we will accept it.
right, Milord.
You know that.
The
Therefore,
the
compromise.
previous order, just let me just bring to the notice of this Honorable Court.
Yes.
What has happened is, Milord, way back in the year 2018, they said that they will purchase the property, my share. I have 2/3 share in the property. They have only 1/3 share. 2018, they said that at 14,000 per square feet, they are going to purchase it. We said, all right, we will give it to you. From 2018, they did not purchase it. In 2024, also April, we have made the submission before this Honorable Court saying that for the same rate, we are ready to give even in 2014. They did not take it. Then, Milord, before this Honorable Court, I have said that I am ready to take it at 15,000 rupees. Now they say that you make it 15,500, I am ready to take it. Then when I come with before this Honorable Court saying that 15,500 rupees, now they say that 16,000 rupees. So third party is going to purchase. Division bench has said that I have the right to purchase the property.
Order that 15,500 per square feet.
Per square feet, Milord. I have filed the affidavit to that effect. I have filed the affidavit to that effect.
On that, I requested several times, parties and as well as PCC convinced parties, you buy it. It is your property, you buy it. But on that day, they don't want to purchase it. The prospective purchaser is there.
Very day.
When they have come forward to buy the property for 15,500 rupees, he has voluntarily said that I am paying 60,000. Same words as.
No, that's, see, there should be some. See, if that once we have negotiated with that some persons, immediately somebody says that I will give more.
Yes,
It
that
is
is
not
what
the-
is happening, Milord. We are not in the, and Milord, it is our family property. We have,
Otherwise, I will say, post this matter before the same judge where that this has all this happening, because after seeing that, learned judge has noted this. Both
Yes,
the
madam.
parties submitted that GR Ashok Kumar is ready to purchase the property 15,500 per square feet. Both the parties have no objection to sell the property to him.
yes, Milord.
Now that you.
Now
want to-
I say that I am ready to take it for the, ultimately for him, he is getting the same money.
Instead of Ashok Kumar, he is saying that I am purchasing.
Yeah, I will purchase it, I will pay it.
Also present, he said that I am ready to pay 16,000 rupees.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಅಲ್ಲಿ?
ಅದರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವತ್ತು
ನೀವು-
ಅಲ್ಲಿ ಹೊರಗಡೆ ದಿವಸ ಎವ್ರಿ ಡೇ ದೇರ್ ಇಸ್.
ಅಶೋಕ್ ಕುಮಾರ್ ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲ ನಾನು 14,000 ಅಂತಾರೆ. Can you, will you reduce that? We cannot force that if they are not settling.
We cannot force it, but the division bench has said in the earlier RFA, and the preliminary decree was challenged by me.
Yes.
Court has said that I have got the right to purchase it, being the major shareholder.
State of bearing mat was.
And retain the property. ಅದಕ್ಕಾಗಿ ನಾನು 14,000 ಇಂದ I only came up to 15,500. My client is about 87 years old.
To sell his share of the property to the petitioner at 15,500 per square feet.
Yes.
ಅದು 4/2/25
ಹೌದು.
ಆಮೇಲೆ 7/2/25 ಅಶೋಕ್ ಅವರು ಹೇಳ್ತಾ ಇದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅದಕ್ಕೂ yes.
ಅದಕ್ಕೂ ನಾನು ಬಂದೆ ಐ ಆಮ್ ರೆಡಿ ಟು ಪೇ ದಟ್ ಅಂತಂದು. ಈಗ ದೇ ಸೇ ದಟ್ 16,000. ದೇರ್ ಕೆನಾಟ್ ಬಿ ಎನಿ.
ದಿನ by that time he was.
Then will go before the same judge.
ನಾನು ಇಷ್ಟಕ್ಕೆ ತಗೊಳ್ಳಿ, ದಟ್ ಈಸ್ ವಾಟ್ ಐ ಆಮ್ ಸೇಯಿಂಗ್. ವಿ ಆರ್ ರೆಡಿ ಟು all terms and everything we have filed before this Honorable Court. All other terms we have.
ಅಲ್ಲ ಆಯ್ತು, ನೀವು ಅಲ್ಲಿ ಮಾತಾಡ್ಕೊಂಡು ಸೈನ್ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ.
ಆಯ್ತು ಸರ್.
You both
ನಮ್ದೆಲ್ಲ
of them
signature
agreed and signed it, then come to that.
Please hold. ಇಲ್ಲ
Yes, pass over, mister, but we'll take that, yes.
ಎಲ್ಲ ಸಿಗ್ನೇಚರ್ ಆಗೋಗಿದೆ ಸರ್.
ಅವ್ರು ನೋಡ್ಕೊಂಡ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊ ಬರ್ಲಿ. There is no any force, let them. Yes, Mr. Counsel, you go outside, discuss the parties and sign that, then come inside. Yes, it is for the, party has to decide. There is no force and after that. Yes. Yes, pass out. You can continue.
Serial number 36,
Yes.
serial number 36, 37 adjourned, serial number 38, Hari Krishna K.A. Serial number 38.
Alerts. The petitioner is challenging the order passed by the senior civil judge Gauri Bidnor, dated 27/4/2020. My lords, the petitioner has filed a suit for specific performance of a contract which came to be decreed. My lords, as per the decree has been passed on 21/12/2023, my lords. The decree has been signed on 5/1/2024. The trial court has said that within 3 months we have to deposit the amount, balance sale consideration amount in the court. Accordingly, we have filed a execution petition before the court within time, and we filed a memo along with the DD for deposit that amount. But the trial court says that 21/12/2023 ಇಂದ ಕೌಂಟಿಂಗ್ ಮಾಡ್ಬಿಟ್ಟು 21/3
Serial number ಎಷ್ಟಿದೆ?
38, sir.
38. Yes, steps to be taken in respect of refused R1 to R6.
refused ಆಗಿದೆ.
Notice. Yes, only 1 to 6, yes, yes, now submit.
My lord, may kindly peruse the annexure.
Now, what is that order you are challenging?
My lord, we are challenging we have requested the court in the execution petition for deposit amount, but the execution court declined to accept the same and told that you have to approach the civil court in OS.
Yes.
Thereafter, we made an application for advancement along with the permission application.
Yes.
The same has been the application for advancement has been considered, but declined that to consider the permission application. May kindly peruse at page number 19 and 20 of the impugned order, my lords.
90.
19, annexure A may.
Yes.
My lords, idರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರಂದ್ರೆ ಲಾಸ್ಟ್ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ ಈ ತರ however plaintiff is at liberty to approach the appropriate forum for his redressal ಅಂತ ಅಂದ್ಬಿಟ್ರು. ಅಂದ್ರೆ ಅಲ್ಲಿ ನಮಗೆ ಅಪ್ಲಿಕೇಶನ್ ನ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಬೇರೆ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗಿ ಅನ್ನೋ ರೀತಿಯಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ.
ಹೌದಲ್ಲ, ನೀವೆಲ್ಲ ಹಾಕಿದ್ರ?
ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ. The very same court has passed the decree. Before the very same court we have filed execution petition.
ಎಲ್ಲ ಹಾಕಿದ್ರೆ execution petition?
May kindly peruse at pay annexure F may kindly peruse. ಅಲ್ಲಿರೋದು ಒಂದೇ ಕೋರ್ಟ್ ಸ್ವಾಮಿ, senior civil judge Gauri Bidnor.
ಆಯ್ತು, have you filed it
Yes, sir.
execution petition?
Yes, my lord. Annexure F.
Page?
Page number 125, my lord. My lords, 1/4/2024 we filed. Thereafter, the case has taken on board and trial court made its opinion that you have not followed the condition of judgment and decree. My lord, judgment was passed on 21/12/2023, my lords. Decree signed on 5/1/2024. We have applied for certified copy on 22/12/2023 itself.
No, now that, where is that order sheet of that execution petition?
My lords, may kindly peruse.
They
We
are
have
showing
we
that-
have also filed that order sheet at page number 143, may kindly peruse. Annexure L, my. This is the order sheet, my lord. May kindly page number 144, may kindly peruse now. Starting ಅಲ್ಲಿ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ, typed copy is annexure is produced at 147.
Issue notice to so and so, that since that degree holder has not complied in terms of the degree, this court can't go beyond the scope of the degree. As such, execution petition is dismissed. No, execution petition itself is dismissed.
Dismissed. ಎರಡು ಒಂದೇ ದಿನ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಇವರು ಇದು ಏನ್ ಮಾಡ್ತಾರೆ, 2/4 ಗೆ ನಮ್ಗೆ ಹೇಳ್ತಾರೆ ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂತ. ಇಮಿಡಿಯೇಟ್ಲಿ 3/4 ಗೆ ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಿವಿ ಸೂಟ್ ಅಲ್ಲಿ.
ಏನಕ್ಕೆ?
ಫಾರ್ ಪರ್ಮಿಷನ್ ಟು ಡೆಪಾಸಿಟ್ ದ ಅಮೌಂಟ್. We are challenging regarding suit order only. We are not challenging the execution order.
Where is that suit?
May kindly peruse, we have filed application at annexure.
Where is the degree?
decree, may kindly peruse at page number 114, may kindly peruse, ma'am.
Yes.
My lords, may kindly peruse, this was signed on 5/1/2024, my lord.
What is the decree? Mr.
Decree is for specific performance of a contract. It is the page number 116, my lord, operation portion.
Yes, read.
The plaintiff is directed to deposit the balance sale consideration amount of rupees 3 lakhs in the court within 3 months from this day with notice to the defendants. The defendants are at liberty to withdraw the amount deposited by the plaintiff in the court. The defendants are hereby directed to execute a regular sale deed in respect of suit property within 90 days there from and get it registered and hand over the suit property to the plaintiff. Failing which the plaintiff is at liberty to get it done through the process of court. My lord, this decree has been signed on 5/1/2024, my lord. Page number 118 may kindly peruse. Bottom. 118. 5/1/2024, my lord. My lord, we have applied for certified copy of judgment and decree immediately next day, 21st day of December 2023 is the judgment and decree date. 22nd day of December 2023, may kindly peruse that.
No, suit is filed. Suit is, when the suit is decreed?
Decreed on 21/12/2023, my lord.
21/12/2023.
Just one day before vacation.
21/12/23 or 24?
23.
From that day, time will start.
Starts, my lord. But decree signed on 5.
Degrees. See what they said, 3 lakhs in the court within 3 months from this day.
Yes, my lord.
Not from the date of the degree. From this day, when the degree is, when the judgment is passed, from that day it is started.
Therefore, we have filed an application for granting permission to deposit the amount along with the DD, my lord.
No, it cannot be deposited after 3 months.
No, my lord, the Honorable Supreme Court says that even time can also be extended.
Yes.
My lord, ಇದರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಫಸ್ಟ್ ಇನಿಷಿಯಲಿ ಸೂಟ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ ಪಾರ್ಷಿಯಲಿ ಅರ್ನೆಸ್ಟ್ ಮನಿ ಕೊಡಿ ಅಂತ. ದೇರ್ ಆಫ್ಟರ್ ದೇ ಫೈಲ್ಡ್ ಅಪೀಲ್. Appeal came to be allowed and directed the defendants to execute the sale deed ಅಂತ ಹೇಳ್ಬಿಟ್ಟು within 2 months ಅಲ್ಲಿ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದ್ರಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಆಗೋದಿಲ್ಲ. There after they filed a execution petition. In the execution petition, the judgment debtors has filed an application under section 28 to rescind the contract in view of non-deposit of amount within time. The said application came to be rejected. They approached the High Court. High Court also rejected. Then they approached the Honorable Supreme Court. Honorable Supreme Court held that permission as well as extension of time can be granted by the very same court. May kindly peruse, my lord, at
Which is that?
my lord, para 8 of para 8, page number 4.
Yes.
This is the latest judgment, my lord. Upon dismissal of the second appeal, the respondent filed an application before the execution court on 24/3/2024 seeking permission to deposit the balance consideration in court. Opposing this prayer of the decree holder, in the execution proceedings itself, the appellants submitted an application under section 28 of the specific relief act, so and so, to rescind the contract on the ground that decree holders had failed to make deposit within 2 months as directed by the first appellate court. The execution court, however, rejected the application of the judgment debtors for rescission of the contract void order dated 3/11/2016 and simultaneously permitted the decree holders to make deposit of the balance consideration. Aggrieved by the aforesaid order of the execution court, the appellants filed a civil revision before the High Court, which came to be dismissed by the impugned order. We have heard so and so ಅಂತ ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು my lords, ಇದರಲ್ಲಿ ಪ್ಯಾರಾ 13 ನಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಪ್ಯಾರಾ 13 ನಲ್ಲಿ
30.
13 ಸ್ವಾಮಿ 13 ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 6 ಪ್ಯಾರಾ 13 ಇಂದ ಸಬ್ಮಿಷನ್ಸ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಎಲ್ಲ ಹೇಳ್ಕೊಂಡು the execution application was filed in the same court where the original suit was instituted.
ಇಶ್ಯೂ ಬನ್ನಿ, ಏನಿದೆ ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡಿದ್ದಾರೆ
ಸ್ವಾಮಿ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಪ್ಯಾರಾ 14
ಅನಾಲಿಸಿಸ್ ಅಲ್ಲಿ ತಾವು ಗಮನಿಸಬಹುದು ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೋದಾ ಇಲ್ವಾ ಅನ್ನೋ ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಅನಾಲಿಸಿಸ್ ಅಲ್ಲಿ ಪ್ಯಾರಾ 15 ನಲ್ಲಿ ಈ ತರ ಹೇಳ್ತಾರೆ, ಎ ಬೇರ್ ರೀಡಿಂಗ್ ಆಫ್ ಸೆಕ್ಷನ್ 20.
Those application ought to have been decided on in time if yes, then whether in the facts of the case ground alone that impugn order warrant interference so on. So. Yes, where is that discussion?
My lord, this discussion ಅನಾಲಿಸಿಸ್ ಅಲ್ಲೇ ಪ್ಯಾರಾ 15 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
ಎಲ್ಲ ಬಿಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಆಯ್ತು.
ಪ್ಯಾರಾ 16 ಇದರಲ್ಲಿ ರಾಮನ್ ಪುಟ್ಟಿ ಗುಪ್ತನ್, ದಿಸ್ ಇಸ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಕನ್ಸಿಡರ್ಡ್ ಬೈ ದ ಹಾನರಬಲ್. ಪ್ಯಾರಾ 16
18 ಗೆ ಬನ್ನಿ.
My lord, having regard to the aforesaid decision, in our view, express may apply in the same suit in which the decree is made as usually in section 28 of the 1963 Act must be accorded in expensive meaning so as to include the court of first instance, even though the decree under execution is passed by the appellate court. This is so because the decree is in the same suit and according to section 37 of the CPC, the expression, the court which passed the decree are words to that effect in relation to the execution of decrees, unless there is nothing, anything repugnant in the subject or context would include. The court of first instance, even though the decree to be executed has been passed in the exercise of appellate jurisdiction, where the court of first instance has ceased to exist or to have jurisdiction to execute it, the court which, if the suit wherein the decree was passed was instituted at the time of the making the application for the execution of the decree, would have jurisdiction to try such suit. Thus, an application under section 28 of the 1963 Act, either for rescission of contract or for extension of time, can be entertained and decided by the execution court, provided it is the court which passed the decree in terms of section 37. So ಇಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ ಪರ್ಮಿಷನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಇದೆ ಅಂತ.
ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಯು ಹ್ಯಾವ್ ಟು ಚಾಲೆಂಜ್ ಸೆಟ್ ಅಸೈಡಿಂಗ್ ದಟ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆರ್ಡರ್ ಅಂಡ್ ದೇರ್ ಯು ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಎನ್.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರಂದ್ರೆ ಎರಡು
ಸೂಟ್
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರಂದ್ರೆ ಡಿಕ್ರಿ ಮಾಡಿರೋದು ಸೇಮ್ ಕೋರ್ಟ್, ಯಾವ ಕೋರ್ಟ್ ಡಿಕ್ರಿ ಮಾಡೈತೆ ಅದೇ ಕೋರ್ಟ್ ಮುಂದೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಇರೋದ್ರಿಂದ ಎರಡು ಇದ್ರಲ್ಲೂ ಎರಡರ ಒಂದೊಂದು ಚಾಯ್ಸ್ ಮಾಡ್ತಾರೆ.
ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಅಲ್ಲಿ ಆ ಜಡ್ಜ್ ಮಾಡಬೇಕು, ನಾಟ್ ಇನ್ ದ ಡಿಗ್ರಿ ಮಿಸ್ಟರ್.
ಬಟ್ ಇದರಲ್ಲಿ ಸೂಟ್ ಅಲ್ಲೂ ಮಾಡ್ಬೇಕಂತ ಪ್ರಾವಿಷನ್ ಇದೆ. ಪ್ರಾವಿಷನ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್, ಮೇ ಕೈಂಡ್, ದಟ್ಸ್ ವೈ ಪ್ಯಾರಾ 15 ಅನಾಲಿಸಿಸ್ ಅಲ್ಲಿ ನೋಡ್ಬೋದು. ಪ್ಯಾರಾ 15.
See, section 35 of CPC is related to that execution.
Yes, ma'am. ಇದರಲ್ಲಿ ಪ್ಯಾರಾ 15 ನಲ್ಲಿ ರಿಗಾರ್ಡಿಂಗ್ ಸೆಕ್ಷನ್ 28 ಬಗ್ಗೆ ಹೇಳುತ್ತೆ ಸ್ವಾಮಿ, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್. ಅನಾಲಿಸಿಸ್ ಅಲ್ಲಿ a bare reading of section 28(1) of the 1963 Act gives an impression that power to extend time to deposit or to rescind the contract in failure of deposit vests in the court which passed the decree, in as much as the words used under section 28(1). The vendor or lessor may apply in the same suit in which the decree is made.
To have the contract rescinded on such application, the court may by order rescind the contract either so far as the party default or together as the justice of the same case. You are not brought to this notice to the court.
ಎರಡು ಒಂದೇ ಸಾರಿನೇ ಎರಡು ಕೋರ್ಟ್ ಮುಂದೆ ಕರೀತಾರೆ ಸ್ವಾಮಿ. ನಾವು 3-4 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಿವಿ ವಿತೌಟ್ ಟೇಕಿಂಗ್ ಮೈ ಅಪ್ಲಿಕೇಶನ್.
This judgment has.
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ಗೆ ಇವಾಗ ಇದು ಆಫ್ಟರ್ this judgment came into force.
So I will direct it to reconsider.
Yes.
Place that judgment.
Yes, ma'am.
Which is that order? Now you are.
My lord, ಅನೆಕ್ಷರ್ ಎ ಮೇ ಕೈಂಡ್ಲಿ ಇದ್ರಲ್ಲಿ ಹೇಳೋದೇನಂದ್ರೆ ನಮ್ಗೆ ಕಾಂಪಿಟೆಂಟ್ ಇಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
Place this judgment, let us
Ask.
all the content. Where is that order?
Order at page number 19 may kindly per.
Advocate filed an application to make a matter on board. IA road makes so and so. Advocate filed one more application permitted balance sale consideration amount as directed. No, you should have asked for extension, mister, not that.
ಅಲ್ಲ, ಅವತ್ತೇ ಅಪ್ಲಿಕೇಶನ್ ದಿನನೇ DDs ರೆಡಿ ಇದೆ ಸ್ವಾಮಿ. ಅಂದ್ರೆ ನಾವು ಎಕ್ಸ್ಚೇಂಜ್ ಪರ್ಮಿಷನ್ ಕೇಳ್ತಾ ಇದ್ವಿ, ಅವತ್ತಿಗೆ DD ರೆಡಿ ಇದೆ.
Correct. No. First, you have to seek for an extension of the time. Time has been extended, then you have to be deposit. Directed deposit ಮಾಡಲ್ಲ,
ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಸಹ ಕನ್ಸಿಡರ್ ಮಾಡಿದಿದ್ರೆ.
ಎಲ್ಲಿದೆ ಅಪ್ಲಿಕೇಶನ್?
ಅಪ್ಲಿಕೇಶನ್ we have produced at annexure G may kindly per. Annexure G is the application.
Please to permit him to deposit the balance consideration without extension, how can the permit, Mister? As on the date, time is expired, how the court can consider that? You have to seek an application for extension.
This honorable court permits me to reconsider the application with a liberty to.
You file an application, I will give that.
Yes, yes.
In this writ petition, petitioner called in question. Order dated 27/4/2024 passed by Senior Civil Judge JMFC Gauri Bidunur in OS number 114 of 2019. Filed under section 151 of CPC. Seeking permission to deposit the balance sale consideration amount as per the judgment and degree. Plaintiff has filed a suit for specific performance of the contract. The suit has been decreed by judgment and degree dated
21/12/2023, my lord.
as per the
21/12/2023.
2023. Agreed that plaintiff is directed to deposit the balance sale consideration amount of rupees 3 lakhs in the court within 3 months from this day, the day judgment has been pronounced, with notice to the defendant. After that expiry of that 3 months, the plaintiff has filed an application IA number 1 under section 151 of CPC, seeking for remittance of 3 lakhs rupees as per the degree. Sale consideration amount of 3 lakhs rupees as per the degree. The trial court has rejected the same since 3 months is over. There is no error or illegalities in the order passed by the trial court. Unless plaintiff file an application for seeking an extension, if the court granted an extension of time, then he can remit it that matter. He has also relied on a judgment of Apex Court in Civil Appeal number 10193 of 2024, contending that the court passed the degree has power to extend the time if application is filed and if court satisfied. If that would be the case, liberty is reserved to the petitioner plaintiff to file such a application before competent court of law. If such a application is filed, same may be considered in accordance with it. With that observation, writ petition is dismissed. Yes, notice issued to that respondent written with postal server refused, hence held sufficient.
Serial number 39, Sridhara K for petitioner.
Serial number 61, my lord.
Yes, ready.
65 signed.
Yes, both of them signed, agreed. Yes. What do you have come?
How to submit when they are.
Now, whatever that, have you written everything in that compromise, Mr.
My lord, in the joint memo, it is not mentioned. In the earlier joint affidavit, we have mentioned, my lord,
Now,
in that,
what is the suit for?
suit for partition, separate possession between the family members, my lord. 3 brothers,
They are all family members.
family members, my lord. In that, my lord, the petitioners, their first petitioner is one brother and the second petitioner's in-laws are there.
Suit
They
for
are the other
partition.
brother.
Partition.
Partition.
Hmm.
Partition of only 55 feet into 44 feet, or 54 feet into 44 feet, a residential house site.
No,
The
What is that relationship between that petitioner and the
The
respondent?
first petitioner is the brother. Second petitioner, LRs have come up. The second petitioner is the other brother who during the pendency of the writ petition died. And the only surviving respondent is the sister,
Sister
the
is there.
second respondent.
What about that first defendant LRs?
There is no LRs, Miller.
ಅಲ್ಲ ಇಲ್ಲಿ ಯಾರು ಬರ್ತಿದಾರಲ್ಲ ಟೂ ಎ ಟೂ ಸಿ ಯಾರದು?
ಅವರು ಸತ್ತೋಗ್ಬಿಟ್ರು. ದೇ have no issues. ಅದಕ್ಕೆ ಮೆಮೊ ಹಾಕಿದೀವಿ.
Srinivasan has no LR. Now that
Yes.
Sriranga
Sriranga Iyengar.
and
Sriranga Iyengar is present.
the sister is P. Sujata.
Yeah, P. Sujata.
Only these two are this thing.
Yes.
Now that share has been, half of share has been divided.
No. 1/3 share of the respondent is being purchased by the petitioners.
1/3.
Yes, at the rate of rupees 15,500.
Third is for
Yes,
this thing.
the two petitioners.
Which is decided in the suit.
Yes, it has already been decided in the suit.
So that has attained finality.
Yes, my lord, that has attained finality.
No, 1/3 share for her.
Yes.
Innandu 1/3.
Brother Parsati. Parsati died long back. His wife is Goptiam and the son is Srinivasa. Both are dead.
What?
Only daughter is alive.
Only the
She is only entitled for his father.
the remaining 1/3 share of payable to Parsarthi.
Is also died. His in-laws are also brought on record.
They are totally together entitled for 1/3 share.
They are
That-
first.
Yes.
Yes. Now that what is that matter is coming before this court in this
My lord, an application came to be filed in the final degree proceedings.
final degree proceedings.
Yes, final degree proceedings ಅಲ್ಲಿ public auction ಗೆ ಕೋರ್ಟ್ನವರು ಆರ್ಡರ್ ಮಾಡಿದ್ರು. It ought to have been first as per section 2 and 3 of the Partition Act. It ought to have been between the parties first, thereafter public auction ಅಂತ ಹೇಳ್ಕೊಂಡು we have challenges before this Arma court in this writ petition. In the earlier round of writ petition, the first appeal in against the preliminary decree itself, I have
Why is
produced the
that they went for an action without giving any options for the others to buy it?
blood.
Is that
They
procedure?
have, in fact, they did approach, they did offer some amount, which we have not agreed for it.
Therefore,
which-
then
yes.
ultimately he went for an
Then,
action.
yes,
Yes.
blood, in the earlier round of litigation, that is the challenging
is
the
that,
preliminary decree.
1/3 you have to purchase.
Yes, my lord, at the rate of rupees
terms of
15,500, my lord. We are ready to purchase at the rate of
them in
15,500.
RFA And the respondent had no objection for the same. What is that RFA still pending?
No, RFA is over, my lord.
Yes, petitioners has filed an affidavit giving details of the papers, documents required to be registration. What is the time limit and all, Mr.
My lord, I have filed one joint affidavit of the petitioners, my lord, earlier. That is on record. Same may be, the same terms may be incorporated here, my lord.
What is that?
And there, I have specifically stated that, my lord, now, because of the, during the pendency of this suit, many of these parties died.
Yes.
The kata in respect to the property, my lord, was originally standing in the name of only 3 brothers. Now, out of that, 2 brothers died. His LRs have come. We will have to get the kata changed. ಪೌತಿ ಖಾತಾ ಲೆಕ್ಕದಲ್ಲಿ ಅವ್ರದ್ದು ಹೆಸರು ಸೇರಿಸ್ಕೊಂಡು ಆಮೇಲೆ ಈ ಖಾತಾ ಆಗ್ಬಿಟ್ಟು ಆಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬೇಕಾಗತ್ತೆ. ರಿಲೀಸ್ ಡೀಡ್ ಅಂಡ್ ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಡೀಡ್ ಹೆಸ್ ಟು ಬಿ ಶೋರ್. That it may take.
The amount is agreed. We will receive the amount. We will relinquish our right in FDP proceedings. They will definitely, they will obtain.
No, here you are only agreeing for that 15,500 per square feet.
Yes.
All other will be decided in that FDP proceedings.
ಅಲ್ಲ ಅಲ್ಲೂ ಅದನ್ನು ಟರ್ಮ್ಸ್ ಕೂಡ ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಏನ್ ಟರ್ಮ್ಸ್ ಹಾಕಿದ್ರಾ?
ಅದರೊಳಗೆ ಹಾಕಿದ್ದೀನಿ. ಅದರೊಳಗೆ ಟರ್ಮ್ಸ್ ಅನ್ನ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 5-6 ಪ್ರೀವಿಯಸ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ನಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಈ ಕೊಟ್ಟಿರೋ ಜಾಯಿಂಟ್ ಮೆಂಬರ್ದಲ್ಲಿ only para 4.
ಹೌದು, ಅದರೊಳಗೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಲಿಲ್ಲ. ನಾನು ಐ ಹ್ಯಾವ್ ಸೆಡ್ ದಟ್ ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಟರ್ಮ್ಸ್ ಮೇ ಬಿ ರೆಡ್ ಆಸ್ ಅದು ಇಟ್ ವಾಸ್ ಫೈಲ್ಡ್ ಆನ್
court ಒಳಗೆ ಅವರು ಬೇಕಾದ್ರೆ they will get the final decree proceeding.
No, I can say in terms of the joint memo, she has agreed to sell that property for 15,500 per square feet.
Yes, my lord.
Joint memo will be taken on record. In terms of that, FDP can be disposed of.
It can be disposed of.
I can
What I am
direct it
trying to say
dispose of.
is, what I am trying to say is, the other terms regarding payment, etc.
Their
because-
FDP, they'll be decided.
That also I have mentioned in the affidavit.
Ultimately, FDP degree has to be passed.
Yes,
In terms of that,
yes.
one these securities, they should not change their stand. That is confirm here. They have
Please,
filed in a joint memo, they have agreed to
Please, my lord.
sell this property to you,
Please, madam. Please, madam.
15,500. On that terms, executing court can proceed.
Yes.
Yes, yes, ತಗೊಳ್ಳಿ. This petition is filed by respondent in FDP proceedings
184 of 2010,
challenging
order on IA number 8. Annexure K, page 85.
order dated second, 3rd April to 3rd February
February.
2018. Passed on IA number 8 in FDP 184 of 2010 by First Additional City Civil and Session Judge Bangalore, whereby the court commissioner has taken a decision to action that
Court commissioner has filed a report to the effect that property cannot be divided by meets and
Yes,
bounds
but-
equally. And pursuant to, it
That
is
took-
thereafter the court has passed the order for public sale.
yes, whereby court has ordered for public action of the suit scheduled property.
Yes.
After service of notice in this case, the parties has agreed for a settlement and they have filed a joint memo before this court. The same is taken on record. Joint memo is extracted below. As per the joint memo, the second respondent herein, that is Srimati P. Sujata, has agreed to sell her share in favor of petitioner Sriranga Iyengar for sum of rupees 15,500 per square feet.
Sriranga Iyengar and LRs of second petitioner.
LRs
Yeah.
of petitioner,
Okay.
yes, in favor of petitioner and his LRs,
No, first petitioner and LRs of the second petitioner.
in favor of first petitioner and LRs of second petitioner for sum of rupees 15,500 per square feet. In view of the above, the writ petition is allowed. Order passed by the executing court is set aside. The executing court is directed to dispose of that. All executing court alla. FDP court is directed to dispose of that FDP on the basis of the joint memo filed by the parties and pass a final degree proceedings. Can time limit sakbaka? Yes, Mr. Bhatt.
Within 30 days, only FDP may be,
Yes,
an
yeah.
order may be passed in the FDP,
FDP.
but
ಅಲ್ಲಿ ಕಂಡೀಷನ್ ಹಾಕ್ತಾರೆ.
all condition ಹಾಕ್ಲಿ.
ಅಲ್ಲ ಅದೇ ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಇಫ್ ಯು ಗಿವನ್ ಎ
ಹೌದು, ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಡೀಡ್ ಬರೆಯೋದಕ್ಕೇನೆ ಈ ಖಾತಾ ಬೇಕು. ಅವ್ರ ಹೆಸರು ಇಲ್ಲದೆ ಈ ಖಾತಾ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಬೇಕೇ ಬೇಕು.
ಕೋರ್ಟ್ ಮುಂದೆ ಇದೀವಿ ನಾವು, ನಮ್ಮ ರೈಟ್ ಅಲ್ಲಿ ನಾವು ಬಿಟ್ಕೊಡ್ತಾ ಇದೀವಿ.
ರಿಲೀಸ್ ಡೀಡ್ ಆಗ್ಬೇಕು ಅದಕ್ಕೆ.
ಆಯ್ತು, ಅವ್ರಲ್ಲಿ
Relinquishment deed.
ಬರ್ಕೊಡ್ಲಿ ಅಲ್ಲಿ ಇಫ್ ದೇ ಬರ್ಕೋಡ್ ದೆನ್ FDP court satisfied they can final degree FDP court is directed to dispose of that final degree proceedings within 1 month from date of copy of this order. All pending applications are disposed.
The last sentence was, repeat one. Last sentence of dictation.
No, FDP court is directed to dispose of that final degree proceedings within 30 days from date of
Please,
receipt of
madam,
copy.
please.
And allot the shares equal to petitioners.
Huh?
Petitioners ಗೆ equal share allot ಮಾಡ್ಬೋದು sir.
ಇಲ್ಲಿ ಇಲ್ಲಿ ನಿಮ್ ಕಮಿಟ್ಮೆಂಟ್ ಒಂದೇ ಏನು ಅಂತ ಅಂದ್ರೆ ನಿಮ್ಮ ಶೇರ್ನ ಅವರಿಗೆ ಸೇಲ್ ಮಾಡ್ತೀರಾ, ಅದ್ರ ರೇಟ್ 15,500 ರೂಪಾಯಿ. ಅದನ್ನ ಹೆಂಗ್ ಸೇಲ್ ಮಾಡ್ಬೇಕು, ಅವ್ರು ಹೆಂಗ್ ಇದ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅಲ್ಲಿ ಇಲ್ಲಿ ಏನ್ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತಂದ್ರೆ ನೀವು ದುಡ್ಡು ಚೇಂಜ್ ಮಾಡಂಗಿಲ್ಲ, ಇನ್ನ ನಾವು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಂಗಿಲ್ಲ, ಎರಡೇ ಇಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿರೋದು.
ಹೌದು.
ಬಾಕಿದೆಲ್ಲ ನೀವು ಅಲ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಒಬ್ರಿಗೆ ಕೊಡೋದ ಇಬ್ರಿಗೆ ಕೊಡೋದ ಅಲ್ಲಿ ಮಾಡ್ಕೋಬಹುದು. FDP ಕೋರ್ಟ್
ಅಲ್ಲ, ಅದು ಆಟೋಮೆಟಿಕ್ ಆಗಿ effect of she selling 1/3 share jointly to the petitioners will have the effect of,
between you two.
yes, half of share ಇಬ್ರಿಗೂ ಬರುತ್ತೆ.
ನಿಮ್ ಶೇರ್ ಇಂದು ಅಮೌಂಟ್ ಬರ್ಬೇಕು ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
ಅವ್ರು ಯಾರ ಕೊಡ್ಲಿ, ಅವ್ರಿಬ್ರು ಏನಾರ ಮಾಡ್ಕೊಂಡ್ಲಿ ಅಷ್ಟೇ.
ಸರಿ. ಹೌದು, ರಿಕ್ವೆಸ್ಟ್ಮೆಂಟ್ ಡೀಡ್ ಬೇಕೇ ಬೇಕು.
No, ಅಲ್ಲಿ no FDP, no, you satisfy that FDP court. If the court satisfied that it is not necessary, they will pass an order.
Correct.
Yes.
ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಇದು report decree ಸಿಕ್ಕಿದೆ ಅದನ್ನ ಮಾಡೋದು ಇಷ್ಟ.
Yes. If court will decide, yes, can be done it without the T kata, let them do it. Otherwise, they will
Right.
insist for that.
Right, we will be happy
Yes,
if
let
it
the
can
court
be done
decide.
so that you can avoid
Yes.
time.
Signature. Serial number 39, Sridhar K for petitioner.
Appear for petitioner, my lord.
Yes.
The petitioner is a defendant. The respondent number 1 filed the suit for partition and separate portion, my lord.
Hmm.
Now in the year 2024, they have filed the IA number 1/2024,
Hmm.
restraining the petitioner not to put up any further construction.
Number
39.
39 service ಏನಾಗಿದೆ? Service is not completed. Furnishing a P of.
The very same address, plaintiff ಕೊಟ್ಟಿರೋ address ಗೆ ಕೊಟ್ಟಿದ್ದೇವೆ.
No such persons, then you.
ಹಾಗೆ
have to
ಬಂದ್
take
ವಾಪಸ್,
one more time you have to take service.
yes, on 2 days time, the trial court.
Weeks time is granted.
The meanwhile, my lord, meanwhile,
Hmm.
the IA passed on 1 year back, 27/4/2024. After obtain the status quo order, the construction ಏನಾಗಿದೆ mold ಆಗಿ ಅದಕ್ಕೆ ಸ್ಟಾಪ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು. Because of the status quo, the plaintiff has not cooperated to dispose of the IA. Main ಮೇಲೆ IA number 1/2, kindly peruse the order sheet, please, sir.
No, what is that you are challenging here?
The order of status quo, instead of passing the detail order, my lord. Now kindly peruse the page number 12, 25/3/2024, we filed the objections.
You take hand summons and will close it. Instead of that, you will take hand summons to that.
Date may be fixed.
Yes. Weeks time is granted to pay the.
Permit me to serve the copy to the trial court advocate.
In addition, he is permitted to take out hand summons to that respondent number 1. After service, you move that matter.
Advocate serve ಮಾಡೋದಕ್ಕೆ.
Advocate serve ಮಾಡಿದ್ರೆ ಬರಲ್ಲ
ಅಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ ಸೇಮ್, ಹಾಗಾಗಿ ಅವರು ಮತ್ತೆ ಅದೇ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇದ್ದು ವಾಪಸ್ ಕಳಿಸ್ತಾ ಇದ್ದಾರೆ. ದೇರ್ ಇಸ್ ಅ ರೈವಲ್ ಕಂಡು ಇವ್ರಿಗೆ ಇರ್ತಕ್ಕಂಥದ್ದು.
ನೀವು ಮನೆಗೆ ಹೋಗ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡ್ಬೇಕು, ಅವಾಗ ಸರ್ವಿಸ್.
ಇವ್ರಿಬ್ಬರಿಗೆ ಹೇಗಾಗಿದೆ ಅಂದ್ರೆ
Suppose if you serve an advocate, if he is not appeared, then again it is not in a service at all.
ಪರ್ಸನಲ್ ತಗೊಂಡು ಹೋಗಿದ್ರೆ ಪರ್ಸನಲ್ ರೈವಲ್ರಿ ಇದೆ, ಹಾಗಾಗಿ
Weeks time to pay the process. In addition, petitioner is permitted to serve a copy to the council appearing for respondent number 1 before the trial court.
ಪ್ಲೀಸ್.
Serial number 40, Saurabh RK for petitioner, BS Aravinda Babu.
Yes, sir. Office objection is related to vacating, application for vacating stay. That's that, I'm ready to argue in the main petition itself, so that may not be, compliance may be not necessary, my lords. And with regard to process, my lords, 1, 2 and 4, my lords, no such person, such charges have come back, but the only defendant number 3 had contested, and they are on record now, my lords.
What is that order you are challenging?
It's order 3 rule 2 application is rejected on the ground that the JPA holder has given another, has appointed another attorney, which is not permissible, citing MIT judgment, my lords.
No.
Which I agree, but my lords, power of attorney holder specifically had the power which I had referred to in my.
No,
which
where
is-
is the plaint? Where is your plaint?
Plaint is at page 35 minutes,
Page?
35.
Yes. Who are you? You are the plaintiff.
I am the plaintiff.
Then what about that defendant number 1, 2, 3, suit for
Injunction, my lords.
injunction? You have filed an application for general authority to.
Please, order 3 rule 2.
Hmm.
Originally, at the time of filing plaint, it was allowed.
Hmm.
Now, it's because of his old age and he was also becoming a bit hostile, the owner,
the actual plaintiffs are residents of Singapore. So they asked him to give one more GPA, my lords, which under clause 3, there was specific power saying to appoint advocate or any other authorized agents.
Now that all defendants are necessary party.
But it's only respondent number 3 contested, and this, and the issue relates to, my lords, who should represent the plaintiff. That in my
No, suppose if that it is your petition is allowed, tomorrow they may say that I have not been served.
it's only on order.
House on that property.
Oh, what is that other defendants are doing?
They are the agents of respondent number 3.
They are sold. Now that you are the purchaser. Then- Yes, yes.
But I have not sold it. They have set up a defense saying that they have bought it from some other person, and my property is completely different. However, my lord, the issue is different number
Defendant number 4.
Defendant number
4,
4. You are the defendant number
3.
3. Who is that 1 and 2?
Then they are the persons who actually had the property rights. And defendant number.
My lords,
No, they
respondent-
have not, they have no interest at all. Only
R1 is the husband of R3.
why your application is.
R1 is husband of R3, and R2 is the agent of R1, my lords.
No, why your application is rejected?
It's on the ground that the GPA holder did not have permission to give another GPA. The learned trial judge has quoted on judgment which says, which I have no quarrel about. But my submission is, my lords, my power of attorney holder or the GPA specifically gave power to appoint another attorney.
No, it can be done. GPA holder can give a general of power.
If he has authority in GPA, he can give. Otherwise, he cannot
Do
give.
you have any authority on that point?
Please, my lords, the trial judge themselves had referred to. But relying on the same judgment, they have rejected my application.
GPA holder can not delegate his power to another person unless there is a specific class permitting. the
ಎರಡು ಬಂತು ನೋಡಿ,
delegation.
ಎರಡು ಬಂದಿದೆ.
No, there is a specific class in that.
Please, my lords.
Then it can be, Mr.
It is a specific clause. My submission is that.
So, just one more submission, my lords. Subsequent to filing of the writ petition, the actual plaintiffs had come down to India, and now they have executed directly also. So formally, that order may be set aside. I'll pass on the memo, my lords, with the other GPA. The copy of the GPA.
What is that? I'm not objecting. It is only construction of the clause. What has to be seen here? See the
Where is that
reason for.
GPA? Where is the GPA?
It's at page 30, my lords, the clause is there.
Page?
Page 30, clause is there, my lords, to appoint advocates or other authorized agents, clause 3.
Page 30. Yes, read.
To appoint advocates or other authorized agents to represent us in any legal proceedings
To
pertaining.
appoint the advocate or other authorized agent to represent us in any legal proceedings. You have not given authorization to advocate, so authorized, Mr.
Allah, that is also answered in the same judgment.
To appoint advocate or authorize.
Who is authorized agent, Your Honor? This has to be construction.
The words used in order 3 is also agents.
He can,
The words used in order 3 is also recognized agents.
see, to appoint advocates or other authorized agent. to
Order 3,
represent
rule
us.
2 starts with the words recognized agents.
No, he cannot delegate. It is not that his power is delegated to,
That is not.
he has given a power to do all these things. He can engage that advocate or he can go and ask somebody for you go and alienate that property.
Even in case the plaintiffs had given any authority to others, he can authorize those persons. And
Whereas the issue is this, if I did not have power,
He can appoint an advocate or he can appoint his agent ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಬಂದ್ರೆ
or any other agents to represent us, my lords, to represent us.
no,
Not him.
here he has to represent him. GPA holder has to be represented by other GPA holder.
That is not the case, my lord. There are two kinds of delegation. One,
Now
GP
they
holder
have
can,
directly given a GPA. Now this will not survive further.
therefore,
even other ways or minutes, I can answer my lord's question, my lords, I still have. Because there are two kinds of delegation. When GP holder has the power, then such an,
Wait, Mr. Now that they have that GPA now. what
if
is
I may
that
pass
doing?
on a memo, my lords, with the copy of the new GP.
putting this petition on two grounds. One is that a person who has been appointed as a GPA of a, by a person who has already been appointed as a GPA for the plaintiff that has been rejected by the court. One Lakshman Gowda was appointed as GPA in the first instance. That Lakshman Gowda executes power of attorney in favor of Amalnath. That power of attorney has not been accepted by the court. It has been rejected. Now the same person is before this honorable court. My humble submission is that technically it is not possible. He doesn't have any locus standi to come before this lordship, your lordship.
No.
When
See,
he had not been recognized by the trial court in the first instance.
no, that is, he is coming before this court, that is wrong. His case is that as per the GPA, still I am an, agent, I can do it
And-
unless we decide.
And one more submission, my lords, I don't know why respondent number 3.
No, if that trial court order is, if it is final, then he can't. He has a right to
It has been rejected ಅಂತ ಹೇಳಿರೋದ್ರಿಂದ
rejected ಹೇಳಿರೋದು correct ಹೌದು ಅಲ್ಲೋ ಅಂತ now it is before this court.
therefore, that
And
was
the-
my humble submission is that on technical ground, so since he has not been his power of attorney has not been recognized, he cannot for any purpose come before this court.
No,
It's my
no.
Submission.
This court has to decide whether he has a right to, represent that GPA. If I said yes,
Yes, that is enough.
now that all that instead of considering all these things, now he has given that, I will say that in view of that, it will not.
ಹೇಳ್ಬೋದು. That is one. Second submission, your lordship, I kindly look into. There is, see, the first instance, the petition has to come to this honorable court with clean hand. That is another technical issue what I.
Yes.
I'll come to merits on the second. Your lordship, I kindly look into paragraph number 20 of the petition. Paragraph number 20 at page number 17.
No, if you are agreeing for that, I will-
Since it has been taken up now, it is my duty to bring it to your lordship.
no, that is true. You also
Just
know
one
my
more
problem.
submission.
My list is 90. I am still in 44, therefore.
One more
I'm
submission.
Starting that all argument to see that.
One more submission, my lords. Who should represent?
They are badly needed. That is why that, otherwise there is no.
One more sub,
I will give you a fair hearing.
Allah, my lords, why, I don't know why respondent is contesting who plaintiff should be represented, my lords.
See, I am worrying about that other cases. Otherwise, I can leisurely sit and hear, Mr.
Please.
Why I am opposing ಅಂತ ಹೇಳಿದ್ರೆ, for the
Yes.
only reason that
Yes.
tomorrow there should not be multiplicity of proceedings. Suppose this person who comes, who doesn't have personal knowledge of the facts of the case, if he gives evidence and based on that any order is passed, that will be again challenged.
No, that you can do it.
ಮಾಡೋ powers ಇದೆ, ಅದನ್ನೆಲ್ಲಾರು
No, I will say, in view of that, the original plaintiff has executed a GPA. Now this petition will not survive for consideration. Let that GPA will be produced. All contention, it is left to open. If they have no knowledge, there is law that it cannot be.
Like, if I may request, my lords, this GPA may be considered. I'll produce the original before the court. But in view of the facts, my lords, the order may be formally set aside. I may be permitted to go on with the matter, my lords.
You want
the
that,
trial
you want to press this matter itself has to be.
Allah, hagala. In view of the new
Then
GPA
you-
being
you
produced.
Take that notice to that other persons also. Let them serve. Tomorrow they cannot be said.
He is the only contesting party, my lords. I can-
Application of interim order.
Where is you? Yes.
Application of interim order ಅಲ್ಲಿ,
Hmm.
the only ground what I have sought is that paragraph number 20 ನಲ್ಲಿ he has made some allegation against the present GPA holder.
Hmm.
Paragraph number 20 at page number 17 of the petition may kindly be looked into.
No, let that,
Let them not make
All
contradictory
that-
statements and.
all that will be here. Now that suit is,
Allah, just for procuring one order, he should not make contradictory statement before this honorable court when they are invoking the extraordinary jurisdiction, another third point.
yes.
Vacation ಗೆ,
Now what is that order? Order is that,
ಅಲ್ಲ ಇಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಇವರು, they have made allegation against the
yes.
existing power of attorney holder. He has actually, he is not, attorney holder has become hostile and he is not leading evidence ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಅವ್ರಿಗೆ ಹೆಲ್ತ್ ಸರಿ ಇಲ್ಲ, ಹಾಗಾಗಿ ಬರ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇದನ್ನ ಹೇಗೆ ಒಂದು ಆರ್ಡರ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಸ್ಟೇ ಮಾಡಿಸ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ ಇಟ್ ಇಸ್ ನಾಟ್ ಪ್ರಾಪರ್.
No, no, what is the state? State is his suit is state. Why do you worry then?
Well, that is my worry, my lords. Like,
Dependent.
Why do I work at it is my duty to point out.
Yes, that is,
Yes.
now that for vacating, there is no urgency because his suit is stayed.
Minutes, if
You
I may
take-
request, it may be taken up tomorrow. I'll take instruction from party to withdraw minutes
No,
instead of
that
pressing
you
it.
want to argue, I will hear you.
ಇಲ್ಲ ಇಲ್ಲ ಅದಕ್ಕೆ ನಾಳೆ ಹಾಕೊಳ್ಳಿ. I'll take instructions and withdraw the matter. minutes.
Yes, place this matter tomorrow. No, I want to dispose, but he said that I will argue, I will hear.
ಅಲ್ಲ ಅಲ್ಲ argue
I
ಅಂತ
will hear
ಹೇಳಿದ್ರೆ
when I get in a free. Yes. See, when you have agreed, I want to dispose of, it is actually helpful for him. He said that, no, I will argue, this has to be allowed.
minutes,
Then
I didn't
will
say
hear.
minutes, I didn't say I'll argue on merits, my lords. I requested based on the memo, it may be closed. That
Yes,
is all, my
yes,
lords.
yes, I will hear that, yes. Yes, he said tomorrow he will withdraw.
Tomorrow
that
I'll
order.
infructures.
Allah, if he is going to
Yeah,
withdraw that, then I will permit. If he wants to argue, then I will. fix
Because
the other
next
day.
week there is a date in trial court matters because I want to go ahead with the matter.
Yes, if he wants to withdraw, what is your objection? We'll have it tomorrow, yes. Yes, if you want to argue, I will grant time. Yes. Yes.
Serial number 41, Sampath A for petitioner.
Yes, we will take the signature, yes.
Serial number 41, Sampath A.
For petitioners, respond 9 and 10, my lord, former defendants, my lord, may be dispensed, my lord, memo.
Yes. Where is that client, mister? Who is that?
No, sir, respond 9 and 10 are, my lord, defendant number 1 and 2, I am the defendant number 3. The plaintiff filed an application to amend their prayer, my lord. I oppose for that amendment.
Yes.
That amendment was allowed, my lord, that's
No, you want to dispense notice
No,
to 9 and 10.
9 and 10, who are the different, who's
Yes.
sailing with me?
Memo is
my lord?
taken on record. Notice to respondent number 9 and 10 is dispensed. Who is other side?
It's Mr. Omkar.
Saramurthy ji.
None appear for the respondent. Leaves this matter after 2 weeks. Interim order granted earlier
Yes.
is extended to next week of April.
Obliged.
Yes,
Serial number 42, H. Suresh for petitioner, Binu M.
yes.
Yes, I am for the petitioner, my lord.
Hmm.
The petitioner has filed a suit for recovery before the commercial court
Yes. Ready?
for,
Yes,
for recovery of amount rupees
yes,
23,06,321
yes,
for the work that he has been conducted as a subcontract between the respondent.
yes,
He is the number one contractor under the Tata Groups.
yes,
So he has been appointed the respondent, I mean petitioner, to carry out the educational
yes.
essay competitions
Hmm.
in 30 districts of 3 states. That is Karnataka, Andhra, Telangana.
Yes, now his application for reopening that PWD evidence has been challenged.
No, we have filed the application under order 11 rule 5
Hmm.
to produce the documents pertaining to the income tax that is in the custody of the respondent.
Yes, where is that order?
Finally come to annexer D, my lord. C.
Yes. P or D, mister?
D.
Yes.
Annexer D, my lord.
Why it is rejected?
Page, kindly come to page number 34, my lord.
Hmm.
Having considered the facts and circumstances of the case,
Hmm.
I am of the view that the documents whose production is sought for under present IA number 15 are totally irrelevant to the present case for the following reasons. So these documents are very much necessary to take just a decision by the court, my lord, to
Yes.
pass a suitable order.
What are the documents?
Documents, my lord,
Where is
kindly
your
come to
application?
annexer.
Where is your application?
Page number, annexer B, my lord, 22.
Yes.
The first one is, my lord, books of account for the financial year of 2018-19 and 19-20. Balance sheet with schedules for the financial year of 2018-19 and 19-20. Statement of profits and loss account with schedules.
Yes.
Copy of application filed under 3CD for the financial year of 2018-19 and 19-20. Copy of income tax returns filed for the financial year of 2018-19 and 19-20. Copy of GST returns filed by the plaintiff company, Bengaluru in favor of defendant company. My lord, nearly 3,60,000 rupees GST has been paid by the petitioner. And 39,000 rupees has been deducted as TDS by the respondent.
Where is your plaint? Yes, mister, these are all relevant. What is that objection for you?
Here, contract has been entered between two parties. They are not complied with the contractual obligation. Let them produce the proof which they have completed as per the terms and conditions of the contract. We will settle the amount. Here they are asking my personal documents. I work for multi-million companies, my lord.
Yes.
I have a lot of documents to produce.
Book of account of the finance. No, book of account of the financial year, why do you want?
No. During the filing of my,
No, you come to that plaint.
my lord, during filing of my invoices, they have not raised any dispute regarding the payment.
You come to that plaint.
Please, my lord.
Where is your plaint?
Number 9.
Page number?
9.
Yes.
We have completed the work. We have submitted the invoices. During the time of submitting the invoices, no single objection has been raised by them. They have accepted the,
To prove that you have completed your work, why you want that book of account for a financial year, mister?
my lord, the amount that has been paid by the Tata is also being entered in that particular books.
No, that,
The balance amount that has to be paid to me,
no. See, whether balance is there or they have to full amount, it is different. The thing is that you have to prove that you have completed that work, then only he is entitled. To completed that work,
For
why
that
that income tax returns and all?
my lord, for that purpose, we have filed the invoices. Based, during the time of submitting the invoices, he has not raised even a single objections. He has accepted. He
You
has
have-
released a sum of rupees 11 lakhs 19,000 rupees.
Yes.
The remaining balance amount of 11 lakhs 47,000 has to be released.
If you have
Previously, he has released.
invoices, if you have any documents to prove that it is completed, yes, it is good. Why do you want the defendant has to be produced the document?
My
which
lord,
is not-
invoices itself is the documents.
What is that document shows that to how you have completed in a work?
Yes, please, my lord.
Invoice is how it will establish that you have completed the
No,
work.
for the work that have been completed is the invoice only we have to submit to the court. I mean, respondent, company. By way of invoices only we have to submit.
You have the copy of the invoices which is
Please,
submitted by,
please.
you have produced that.
We have not produced here, my lord.
Why?
We have
No, you have
produced
not
there in-
produced with the suit.
Alla suit will produce money the way. We have produced
And
before
then
the
why do you
suit.
want from them?
To know the truth, my lord, whether they have been, we have paid the GST, they have enjoyed the GST. Out of the 39,000 rupees has been deducted by a 2% TDS.
Yes,
So these aspects has to be known by me.
yes.
During the time of me filing the invoices, they have not raised any objections at all.
Then
They have
that is-
accepted.
then-
They, no. Now they are denying. Kindly come to the return statement so filed, my lord.
No, have they denied that this invoices is not submitted to them?
No, they have accepted it.
Then why do you want, then again they have to be produced? If it is with-
After 2 years, when we went there to their office and to raise the funds, I mean the balance amount, then they denied not to pay. That has been stated in the return statement, my lord.
Is that-
Kindly come to.
You have denied that, this thing, Mr. Invoices.
No, my lord, I'm not dealing with invoices, but they have not completed their contract, my lord. They had to produce the photographs, videographs, and the permission received from the school.
No, this invoice is for what?
Invoice is for the work they have completed. They have not completed their work, they have not paid their amount.
No, have they submitted that invoices to you?
It is there.
No, have you submitted? Then,
They have admitted, my lord.
then why do you want to produce?
Allala,
Mr.?
now they are not ready to pay the payment. Kindly come to page number 18 of their objections. Return statement.
No, payment will be after degree, suit is degreed. Now, see, now the document is produced to prove that you have completed that. Now, in that middle, they will not pass an order for payment, mister. Who will pass an order payment without degrees passed? and that completed that you have,
My lord, initially they have accepted, they have concluded, they have paid rupees 11,19,000 rupees. And now for remaining balance amount of rupees 11,47,000,
for that only you have filed in a suit.
yes,
That is your prayer.
yes.
After the trial only that has to be passed. Now why can, how they will pass an order, mister?
Now the case has been set down for cross-examination of the
Let them
defendant.
complete.
So if those documents have been confronted in the court through him, so I will have a good case to prove my case.
No, you have produced the documents as confronted.
Yes, we have produced. These documents are necessary to show that I have paid 3,60,000 rupees GST.
You have produced the documents already in the court.
We have produced invoices only, not this particular documents
Which documents?
pertaining to income tax.
No, why do you want that income tax documents?
We have paid GST. They have deducted TDS of 39,000 rupees. So these things they are denying.
No, that,
Even we
GST
cannot file application through RTI also.
no, that is only related to the income tax returns filed by that financial year.
Yes.
Why do you want that book of account for the financial year 2018 and 19?
In that particular account, they will enter my name, what are the amount that has to be
Okay.
paid to me.
If that deducted the TDS, that will be reflected in that income tax returns. That is
Yes.
enough. Why do you want other records, mister? Only income tax returns, there they will reflect that these are all the amount deducted from so and so, that they have to be remitted to that income tax department. That's all.
Yes, my lord, those documents are necessary for
Those are
me to
only
confront,
this documents is enough.
to show that I have paid the GST.
That is what that, why do you want that book of account, mister? Yes, we'll hear that.
In that particular book.
Yes, leave this matter next week.
Interim order may be extended.
Yes, interim order granted earlier is extended till next week.
Acknowledgement, CA number 40 also interim order may be extended.
Yes, interim order is there.
Serial number 43, George Joseph for petitioner, Subramani MA.
Week's time is granted to do the next.
I've already served the counsel before the trial court. In fact, the address which says vacated is nothing but the plaintiff's address in the plaint. And that's my another submission is that respondent number 3 may not be a relevant party to the dispute in the writ, my lords. I've already served the counsel, the acknowledgement is before court. The dispute, my lords, is extremely short, if my lords may just hear me.
No, see, serving a counsel is not in a service of notice.
I understand, my lords, but the address through which I've served, if my lords sees the endorsement, it says vacated. This is the address given by the plaintiff under 6 Rule 14A. I do not have an alternate under this address, my lords.
That is the duty of that party who has approached the court to see that notice has to be served.
My lords, I
It is neither
understand.
the court duty or the defendant.
My lords, if I make submission on the merits, you'll understand that
No, without serving the notice, what is that use in
I've
hearing?
served the advocate of the trial court.
No,
my lords.
madam, you show on that law. Is it,
But I'm permitted to serve handsomely.
that's what that you have to be doing. Yes.
And a
If the
shortest
parties
date
is
to
not
appeal.
available, I can't serve. That is not the purpose of filing a petition.
The
Yes.
shortest way.
Week's time is granted to do the needful. In addition, petitioner is permitted to serve hand summons to that respondent number 3.
Three, my lords. One
Yes.
Serial number 44, KV Narasimhan for petitioner, connected matter, Sharath S. Gowda.
Yes.
For petitioner.
Memo for?
Sir.
Memo for retirement. Yes, what is this matter? It requires hearing.
My lord,
We'll have it next week. Yes, leave this matter next week.
there's an interim order, my lord, in all three matters may be extended.
Interim order granted earlier is extended till next date of hearing. A passed over matter, sir. Passed over, huh? Yeah, the 40.
Serial number 45, Lakshmi G. Srinivasamurthy D.
My lords, appearing for petty,
Oh, yes, yes.
appearing for petitioner, my lord.
Hmm.
My lords, the respondent, they have not served the memo to us, my lords. Reporting, that is reporting of respondent number 6 death, my lords.
Hmm.
When the matter is listed today, it came to our knowledge, my lords, that the
Who is
respondent
dead?
number 6 is dead.
Memo for retirement. Respondent number 6 is dead.
The
Yes,
copy is also not served to us, my lords.
have you served the copy to them? No, if you file it in that counter, it is different. Have you served the copy? Now they are saying that they have noticed that by cost list. Yes, learned counsel for. No, that is true. But unless it is brought to the notice of the parties to death. Where, whom? The council, where is that notice, acknowledgement? Oh, they are saying that it is not served. Then you have to prove. No, today you need not serve, mister. Because in the cost list, it is noticed that now they are aware that there is a death. You are saying that last 2 years, because there is no notice to them.
Because of what they lately, they are very well aware that the respondent is dead. There is not the strangers.
But you have to prove that they are aware of that. They are saying that they are not aware of that.
Okay, so the memos will be there.
Yes, yes.
But I've heard of-
They have to take steps.
We'll take the steps, my lords. At least now it came to our knowledge, my
How
lords.
can that do it within the week, mister? Notice has to go to the TLRs. Hmm.
There are also legal aids of record. It is not necessary to state some.
Who are that legal air R2? You are appearing for whom?
My lords, I'm appearing for,
No, you are appearing for all respondent. Now that R2 is dead. Who are their LRs?
The R4, 5, 6, 7 are the.
You file in a memo.
Yes, how will
Yes.
you?
Yes. ಎಲ್ಲಿದೆ ಇದ್ರಲ್ಲೇ ಮೆಮೋ ರಿಪೋರ್ಟಿಂಗ್ ಎಲ್ಲಿದೆ ರೀ?
28/3/2024 is very now.
Yes, learned council appearing for respondent number 2, respondent number 3 na?
Respondent number 3 to 7.
Yes, respondent number 3 is filed in a memo reporting death of respondent number 3 and submitted that. 3 anta ತೋರಿಸಿದಾರ್ರಿ. You see that cost list, mister? Who is that? 3 or 2? Agree, mister. 3 anta ತೋರಿಸ್ತಾರಲ್ರಿ. 45. ಎಲ್ಲಿದೆ? Memo for retirement 2. 45. 2 ಅಲ್ಲ? 2 and 6. Yes, respondent council appearing for respondent number 2 has filed in a memo stating that respondent number 2 is dead, leaving behind
6 and 7.
4, 5, 6
8.
and 8 are the LRs. The memo is taken on record. Respondent number 3, 4, 5, 6 and 8 are treated as an LRs of deceased. Respondent number 2. Then what about respondent number 6? ನೀವು ಇದನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕ್ಬೇಕು ಯಾಕಂದ್ರೆ ಅವ್ರ ಹೆಸರು ಬರ್ಬೇಕಲ್ಲ. ನೀವೇ ಹಾಕಿದ್ರೆ ಆಯ್ತು, ಮುಗ್ದೋಯ್ತಲ್ಲ. Yes. Yes, leave this matter next week. In the
my
meantime,
lords,
you amend
interim
the
order may
cost
be
settlement.
extended.
Madam, you have to amend the cost title.
Please, my lords, please. Interim order may be extended, my lords.
Yes. Interim order granted earlier is extended till next date, huh? Yes, leave this matter on 5th. Yes. In the meantime, you
Much
file an
grateful.
application. Yes.
Fast over matter, serial number 3, Geeta Devi MP for petitioner.
Yes.
But in this matter, the petitioner is challenging the order of the, at annexure A. Lord, the application for prosecuting the case of an ordinary rule 2 has been allowed.
Suit for
Partition.
Yes.
Partition, we have taken up the contention, there was a prior partition.
Yes.
And PW1, that's the plaintiff has examined himself.
Yes.
I've also produced the cross-examination, examination in chief.
Yes.
And the cross-examination. In the cross-examination is admitted many of the contention which we have taken up in the by way of defense, my lord, the prior partition, them having received a compensation when the KIDB had acquired the land.
Yes.
All
What is
this-
that order you are challenging here?
Or annexure A, wherein page 14, internal, I mean, page 24 is the final order, my lord, the order, impugn
24.
order.
Yes.
Now, while permitting the prosecuting the suit through the special power of attorney, the evidence led by the PW1 has been discarded. All the admissions which are made has also stand discarded. In any event, my lord, this honorable court, the Supreme Court has very clearly held that power of attorney cannot step into the role of the plaintiff. He can lead an independent evidence, but not that of an independent
Defendant counsel filed a common objection to the above.
Perusing the IA filed by that SPA holder, defendant number 5.
To appear and
seeking a
prosecute the
permission
case
to
on behalf
appear
of
and
the plaintiff.
prosecute the case on behalf of the plaintiff.
Is
What
allowed. The grounds urged to move the application is satisfactory, therefore they were-
GPA holder can be, if he has any knowledge, he can be. Where is that?
that is not the case. Now, my lord, if I take your lordships to the cross-examination where is admitted the entire case, the last sentence, the operative portion, my lord, IA so-and-so has been allowed, resultant SPA holder is required to appear and prosecute the case on behalf of the plaintiff. Evidence of the PW1 is discarded. Now, all the admissions made by PW1 is
Evidence is discarded.
completely discarded.
Yes, yes.
If he leads additional evidence as PW2, there's no harm in that, my lord. Why should the?
He can continue that. He can't, the evidence which has been given cannot be discarded.
Discarded. All the admissions can't be discarded now.
Yes,
If kindly permit me take your lordships to the admissions that have been made, my lord.
yes, heard. Issue notice. Stay of further proceedings in OS number 198 of 2016. Pending in the file of first additional senior civil judge JMFC, Ramnagara, till next date of hearing. Yes,
Seal number 12, Irremated Maheshaya.
yes. Office of Justice complaint.
Yeah.
Yes, mister, what is this? You facts.
In this case, yes, my lord, in this case, my lord, the petitioner is a defendant, my lord. The respondent filed a suit for eviction against the petitioner, my lord. The respondent, the plaintiff is neither owner nor way concerned to the society, my lord. Property belongs to the trust, my lord. The dispute is pending between the real trust with the respondent, my lord. Two criminal cases, two civil suits pending before the competent court between the original trust and present respondent, my lord. Now, the respondent filed a suit for ejectment against the present petitioner, my lord. Petitioner is tenant under the original trust, my lord. Thereafter, my lord, in commercial suit, the petitioner filed a written statement, my lord. The written statement can be rejected on the ground that the time is beyond the
No,
prescribed.
that, you said that period of.
Yes, yes, my lord, yes, my lord.
Yes, where is that?
Sir, kindly come to the page number 6, my lord. This is a question before the court, my lord.
Page number?
6, my lord. Para number 13.
Page 6, yes.
This is latest judgment. By discussing several judgments, my lord, and the short question that arises for consideration is whether the clerk for calculating the time period of a file written statement would stop running in the parties are in mediation or not. The time period for calculating the limitation.
Time period for calculation, the time filing the return is done by so and so. Considering that written statement stop running when the parties are in mediation or not. Time period of calculation, the limitation filing returns and. Yes, what is that answer?
Please come to the page number, my lord. Last page, 17, my lord, para number 26.
Para number?
26, my lord. 25 and 26, my lord.
Yes. This court is therefore inclined to exclude the time period. Yes, so and so for calculating. The only question therefore, whether the delay in filing the return statement was being filed within the period of 120 prescribed under the original site rules, but beyond the period of 30 days filing explained that. Document is state that he has written for 1 month, so and so he is working in Mumbai, so and so. Mediation, so and so, 120 days to come in filing the return statement again that. Through the time spent in the mediation. Yes. When that mediation?
No, kindly come to the page number 6 of my petition.
Yes.
Para number 18, my lord.
Page 6,
Yes. Para number 18, my lord.
Suit filed.
Suit filed, my lord. I have mentioned in table, my lord. Date for 2023 suit filed, my lord. 10 for 24 notice issued, my lord. 24 notice.
Notice served on 29/5/24.
And 7/8/24 sent the file for pre-conciliation, my lord.
7/8/24,
my lord.
ಆಮೇಲೆ ಬಂದಿದ್ದು?
Return 17/9/24, my lord.
No, defendant filed an ala 28 ಗೆ. Conciliation filed returned to the court 28/7.
But the matter posted before the court on 17/9/2024, my lord.
Whether that has to be excluded?
Yes, ma'am.
ಅದ್ಯಾಕೆ ನಿಮಗೆ ಅಲ್ಲಿ time spent for that this thing has to be excluded ಅಷ್ಟೇ?
No, my lord. The 28/8/24 is conciliation day, my lord.
No, held pre-conciliation filed returned to the court on 28/8/2024.
No, my lord. No, my lord.
The
Defendant-
matter posted before the court on 79, kindly come to the order sheet, my lord. I have produced the order sheet also, my lord.
ಅಲ್ಲಲ್ಲ ಪೋಸ್ಟ್ ಆಗ್ಬೇಕಾಗಿಲ್ಲ ನಿಮಗೆ ಕನ್ಸಿಲೇಷನ್ ಫೇಲ್ಯೂರ್ ಆದ ತಕ್ಷಣ ಲಿಮಿಟೇಷನ್ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು.
Yes, my lord. But unless the matter posted before the court, I can't file the.
No, you can file it in the counter. ಆ ತರ ಕೇಸ್ ಪೋಸ್ಟ್ ಆಗ್ಬೇಕಂತ ಸಿವಿಲ್ ಕೋರ್ಟ್ ತರ ಕಾಯಂಗಿಲ್ಲ ಅಲ್ಲಿ.
Civil court ಅಲ್ಲಿ.
No, this is commercial court, mister. ಮತ್ತೆ commercial court limitation is different, mister.
However, my lord, my case is within the.
ಆಯ್ತು,
limitation
ಈಗ
of-
ಇಶ್ಯೂ ನೋಟಿಸ್ ಸಮನ್ಸ್ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿರೋದು ಇಲ್ಲಿ ಎಷ್ಟು ದಿನ ಆಯ್ತು? 7ರಿಂದ 28 ಅಂತ ಅಂದ್ರೆ 20 days. 7 9 10 20 28 7 17 27 12 days. 12 days ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ರೆ 120 days ಎಷ್ಟಕ್ಕೆ ಯಾವತ್ತಿಗೆ ಆಗುತ್ತೆ?
My lord, my application came to be rejected on the ground that my lord, 147 days.
147 days.
47 days ಅಂತ ಹೇಳಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ, my lord.
147 days ಅಂತಂದ್ರೆ ನಿಮಗೆ ಅಲ್ಲಿ ಸಿಗದೆ ಎಷ್ಟು 22 days.
ಅಲ್ಲಿ 22 days ಲೆಸ್ ಆಗಿದೆ. 22 days, 7/8/24 ಇಂದ
147 ಅಂತ ಅಂದ್ರೆ 120 days. 20 short of 3-4 days. Let us see. Yes.
23 days ಲೆಸ್ ಆಗಿದೆ.
23 days ಲೆಸ್ ಆದ್ರೂ ಕೂಡ ಇನ್ನು 2 ದಿನ ಕಡಿಮೆ ಆಗುತ್ತೆ. Let us, yes, or issue notice. Stay of further proceedings in commercial OS number 45 of 2024 pending in the file of Principal District and Session Judge Davangere till next date of hearing.
Till number 20, Vishwanath, witness for petitioner.
Date of the events to be stated, age proof of the petitioner to be furnished, photocopy, letter copy, typed copy. Yes. Yes, Mr. What is?
Plaintiff petition.
Hmm.
Plaintiff has challenged the emergent notice issued by the trial court. Not the facts are like this, but the petitioner is the society.
Hmm.
But they have established several education institutions, including certain universities under the Amity Universities Act. They have purchased about 45 acres of land.
Yes.
But out of 45 acres of land, not 3 acres, in 3 acres, 39 guntas of land, they have constructed the school.
Yes.
There is that school, my lord, you will actually kindly come to the, in this, my lord, please come to page 73. In page 73, my lord, is the grant, my lord, this is the original grantee. When Mr. Bachappa was a grantee. My lord, from him you have purchased the land. Then, my lord, this is the, my lord, on 33/1963 was the grant. And when 1966, Annexure K, page 75, but in the grant are, and page 76, Annexure K. But there was a car track running through this property. But now that is 163. Earlier it was survey number 15. Please come to page 76, my lord.
Yes.
There was a car track. Let me kindly see, there are 3 roads, car track.
Now 76 is that.
Yes, my lord.
Annexure J.
Annexure, my lord, this is K, my lord, Annexure K, that
Annexure J is
next.
46.
the page, the
Official memorandum.
official memorandum ಅಂತ ಒಂದಿದೆ. Official memorandum ಆದ ತಕ್ಷಣ annexure, now they have changed. some-
Official memorandum, Annexure K,
Yes,
47.
Annexure K, next page you will ask me kindly turn.
78.
Yes, my lord. This Annexure K is the date, my lord, in this, my lord, the government, the 17 guntas land was car track. And after my lord, very inspection and other following the procedure, they felt that this is of no use. Then, my lord, they have all allotted this land to Mr. Bachappa.
Dotted line ಇದೆಯಲ್ಲ ಅದ?
ಅದು dotted line ನಲ್ಲಿ ಎರಡು dotted line ಇದೆ.
ಹೌದು.
First dotted line, my lord, it was cancelled
Yes.
and it was allotted to Bachappa. We purchased this land. Now, my lord, please come to next sketch. This dotted land cancelled and shifted to other portion. Lordship got it, my lord, that another road they have formed.
Yes, yes,
And first one is cancelled, second one is formed.
yes.
Then please come to again next document, is another sketch is there. Annexure, history, Annexure L. Annexure L, you will ask me kindly, there is a clear road is formed.
Yes.
Now, my lord, what they have done is, we have established the school. Now, my lord, they have issued a notice, Tashildar is issued a notice
stating that you have encroached the car track. The
But
car
this-
track has already been shifted.
Yes, now, where is that your property?
My property is the 15, 163 ಇದೆಯಲ್ಲ number.
63.
163. This car track is shifted to this ರಸ್ತೆ ಅಂತ ಬರ್ತಿದೆ ನೋಡಿ ತಾವು.
ಹೌದು.
ಆ ರಸ್ತೆಗೆ ಶಿಫ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Now this car track they are supposed to remove from the village map. They have not removed it. Then we give a representation to them saying that this has already been shifted to other place. There you cannot do.
At all these things.
Pardon me.
Who has made that shifting of car track?
That is the deputy commissioner, competent authority deputy. Yes, my lord. He has passed the order
Order,
and
yes.
they have already shifted it. Now, my lord, we have constructed the building, school is running, university is running. Now, my lord, all of a sudden issued a notice of eviction. Then we challenged that before this Honorable Court. This Honorable Court, as my lord, unfortunately, what happened was this sketch was not available when the writ petition was filed. Then, my lord, this Honorable Court asked us to approach the civil court. We approached the civil court
Where is
seeking
that?
mandamus.
Where is that order?
But please see page Annexure N, my lord.
Measure N.
Annexure N,
Yes.
page 88.
Hmm.
Last paragraph may kindly be.
Yes, now that you have filed in a suit for?
Suit for a mandatory injunction directing them to shift, my lord, show the shifted load, the shifted road in the village map and permit us to carry on our the activities.
Yes, now what is that?
Now, my lord, the Learned Judge has issued emergent notice. But we had no, this, now, my lord, yesterday, they sent a note, just, that is why we have moved it. Now, my lord, the assistant commissioner directed the Tahsildar to demolish the building and take possession and farm the road. This is the latest, this thing, my lord, yesterday, 19/2. That's why, my lord, we moved it because,
Yes. maintain
now
status
what I am
regarding the-
saying, my only request is, let them not precipitate the matter. We'll maintain the status quo. Then let the trial court decide the matter. This, if
Yes,
the government
no.
appears, it can be disposed of.
Issue notice. Parties are directed to maintain status quo in respect of possession of petition scheduled property till
Yes.
next date of.
Please. But hand him,
Yes.
hand
In the
delivery.
meantime, directed to comply.
Yes,
officer.
sir, I lost them. I'm sorry, my lord, because there was some
Yes.
statement. Hand delivery of the order may kindly be.
Yes.
Bill number 26.
Yes.
Vishruth C.
Petitioner, Your Honor.
ಪರವಾಗಿಲ್ಲ, ಮಾಡಿಲ್ವಾ?
The court asked me to
No, have
verify.
you complied that office
Yes,
objection?
yes, it's
Where?
court fee, ಇದ್ ಮಾಡ್ಬೇಕಿತ್ತು ಅಂತ ಹೇಳಿದ್ರು.
No, preamble portions of the annexures, objection, IA to be filed, deposit.
No, preamble-
Details of the annexures from annexure L to be stated in the.
It is all done, except for G and H के preamble are the same. So it is available,
Of annexures from L to be stated in the writ petition.
that is also carried out.
Where is that? You have not taken the file itself.
No, it's all, I have replaced everything.
And when you have complained?
3 weeks ago, Your Honor.
No, this is after that this has been raised, Mr.
No, this, after the first objections were raised, I have taken the file, I have complied,
This is
except for one.
4/12/2025 then. Or 4/12/2025 ಎಂಗುರಿ ಬರ್ತದೆ. ಮೇಲ್ಗಡೆ ಡೇಟ್ ನೋಡ್ರಿ. ಏನಿದೆ? ಕಂಪ್ಲೇಂಟ್. ಮತ್ತೆ ಏನಾದ್ರು ಗೊತ್ತಾಗುತ್ತೆ. ಇಲ್ಲಿ 4/12/2025 ಅಂತ ಹೇಳ್ತಾನೆ. 1/24 ಅಂದ್ರೆ ಈ ಡೇಟ್ 2025 ಹೆಂಗ್ರಿ ಬರ್ತದೆ 4/12. Yes, what is this, Mr.?
The petition by the JDR, Your Honor, challenging the order page number 16. Your Honor, brief facts of the case is that the original suit was for recovery of possession from the tenant. I was a tenant under the husband of the respondents.
Yes.
It was decreed against me. The possession was handed over vide the memo dated 27/10/2014. It is at page number 59.
Yes.
Right after the memo that I filed,
Now that, what is that in that order we are challenging?
In the
Execution.
order that is being challenged is police protection for the taking possession of the property and the arrest warrant.
No, you said you are already handed over the position.
Yes, yes, that is what I'm coming up to. Per 27/10/2014 wide memo, I have handed over the possession of the property. Here, the respondents file an application saying that a portion of the property has been handed over, not the entire possession of the property has been handed over.
No, according to you, you have handed.
I have, and I have. So right after that, they file an application for the appointment of court commissioner dated 10/11/2014. It is at annexure F. No order was passed. After that, I filed. Yeah.
You have handed over that
Possession of the property.
You are not in the possession.
Yes,
You are out of that.
yes.
Even if the police, they have ordered for a police protection and execution, how will it affect? You
No.
are outside that.
No, no, no. It's not only about the police protection. There is an arrest warrant against me. That is the reason why I'm here at this point of
If I may
time.
submit, my lord.
Now, let me complete.
Yes,
Okay.
yes.
So
Why you arrest for
there is a court commissioner application that was filed by the respondents. No order was passed. That was IA number 5. And IA number 20 is I who filed the appointment of the court commissioner.
For what?
Right after the order, which ordered for a arrest warrant against me. That delivery of the possession was not handed over. After an inquiry was conducted by the trial court, where there was no court commissioner that was appointed.
Yes.
So right after the order that was passed, I filed an application for the appointment of court commissioner. For both IA number 5 and IA number 20, a common order was passed. No court commissioner was appointed.
What is the common order passed?
That here, the court comes to the conclusion that the inquiry is already conducted. There is no need for the appointment of court commissioner. That is the conclusion. And after, right after that, the JDR was taken into custody for about 30 days.
Yes, mister, he has not handed over the position.
My lord, if I may submit, this one, my lord, in this case, what has happened is that after the execution proceedings was filed, he files a memo stating that I have handed over the vacant possession. However, the entire portion of the property has not been handed over. To that regard, we also file a contempt case, and the High Court orders the execution court to conduct an inquiry and determine if the entire possession has been handed over. In that regard, there is a judgment, my lord. With that, in that regard, there is an order which has attained finality. Kindly come to annexure of the petition, annexure G, page number 64, my lord. This is the inquiry conducted by the execution court.
Yes, 64, show me.
64. Annexure G.
64, yes.
My lord, in that second page, about 10 lines down, my lord. DW1, this is after the inquiry. DW1, he clearly admits that he handed over only 15 by 20 feet property to the decree holder. And he further stated that excluding that property, there is a vacant site and house existing up to the Kolar Road. What has happened in this case is, my lord, ಮೊದಲು ರೆಂಟಿಗೆ ಕೊಟ್ಟಾಗ 2001ರಲ್ಲಿ ಮನೆ ಮುಂದೆ ಇರೋ ವಟಾರ ಸೇರಿ ರೆಂಟಿಗೆ ಕೊಡ್ತಾರೆ. In the 2004 eviction case ಅಲ್ಲಿ, after reaching the finality in about 2012, they are asked to vacate. In the meantime, what he does, in 2012, he constructs a small shed in the Vatara. He hands over the possession of the house, but doesn't hand over the possession of the vacant site.
Is that suit schedule?
Suit schedule, my lord, if kindly see the certified copy of the plan, page number 32, my lord.
$37 is the schedule, Your Honor.
Schedule.
37.
Yes.
My lordship may kindly see. Premises with vacant space bearing kata number so and so, measuring east to west 25 feet, north to south 15 feet, which he has handovered. And a vacant site measuring east to west 10 feet and north to south 20 feet. Mane munde iro vatara seri kodtare. He has handed over this 15 by 25 feet mane. But he doesn't hand over that portion.
Yes.
To that extent, inquiry has been conducted, order has been passed.
That is the reason why, after this conclusion that the court came to, I filed an application for the appointment of court commissioner to ascertain that I have handed over the entire possession of the property.
No, this order which he has shown,
Annexure G, my lord.
annexure G,
Yes.
They have not challenged it.
court has given a finding that you are not handed over.
Yes, right after the finding itself that that I had to file, that I have even in my application, I filed saying that I have handed over, including that 10/20.
Then when you have handed over remaining portion?
No. The entire portion was handed over in 2014 itself.
No, there is a finding in.
No,
annexure
the finding is because of this, there is,
that you have
I'll-
not
I'll-
challenged.
that was not challenged.
Then-
I mean, he's an illiterate, Your Honor. He is barely illiterate. So that is the reason, even after the court commissioner's appointment was rejected, it was not challenged. At this point of time, there is no need to precipitate the matter, the entire matter. Even I had suggested the trial court for the appointment of the court commissioner so that the entire proceedings can be concluded at once.
No, yes,
Lord,
now
if I-
verify, now he has vacated, what is that?
My lord, what has happened, factually, not to bring it, he has created a bogus Akupatra, and based on which he has taken a kata to that extent of 10/10.
No, whether he has taken.
He is still in possession.
I will tell you, even if it is granted, even government is
Please,
granted, but there is a degree,
Decree, please.
including that suit
Please,
schedule,
please.
whether he can have any, but 10 sale deed in respect of that,
Please,
there is a
please.
degree.
Please.
That he has to vacate.
Vacate, please.
If he is saying that he is not in that single piece of that land, suit schedule
Please.
property.
In the suit
If
schedule property.
confirmed by your client, whether still he is in the possession or not. Otherwise, we'll verify that if he is in the possession, directly we'll send him to that jail.
Please, my lord.
That is the case.
Please,
Yes,
please, please.
if you are there, even single inch of that property which is in the suit schedule.
Yes, Your Honor.
court will
See,
appoint a
this
commissioner
was,
and
this
will
was
send it
brought to the
the-
notice. Only thing is, just to make sure that since there was no proper verification on the ground,
Now take an instruction from your client and filed an affidavit saying that as per that suit schedule, he is not even in that inch of the properties, he is in the possession, he has left out.
Please.
He is also, then I will see what we have.
Please, please, my lord.
Till then, don't take any arrest this thing. Yes. Within the period of such day, then should be that the civil prison, that will be stayed for that period.
obliged, Your Honor.
Yes. But you are the only person or. any
Yes,
other-
yes.
Yes, please, my lord. I'm the only respondent.
Yes, we will take notice to all.
Please, ma'am.
Privateer is undertake to notice. Stay of. Order dated. Which is that order, mister? Order which is challenged.
Order dated 19th November 2024,
Page number,
16.
now what is that operative portion?
Operative portion.
Issue directed, send a letter to the PSA to give a police protection to the area while executing the delivery required. Also warrant against the JDR to undergo 2 months civil prison to collect. Yes, stay of. Order dated 19th November 2024 till next date of hearing.
My lord, a date may be given, my lord.
Use this matter on 27th. In the meantime, petitioner is directed to file an affidavit before this court, whether he has vacated entire suit scheduled property as on the date of passing that order.
Obliged, Your Honor.
Yes, you also verify from.
Please,
your
my lord,
side.
please, please.
Yes, in the meantime, directed to comply office objection.
Serial number 60, I seek indulgence, my lord.
Hmm.
Only one submission, my lord.
Hmm.
I was forced to enter into a Lok Adalat settlement.
Hmm.
And though I signed the agreement,
Hmm.
I find that there is an illegality
Serial
because
number?
this is 60, my lord.
60.
60. And it's a money claim which I have paid the money, only 3 lakhs is due
Yes.
as per my statement and as per the decree.
Yes.
Well, I'll pay that 3 lakhs, no doubt. But what they want the pound and the flesh, including the interest.
Hmm.
And they want to attach the property and they want to bring it for sale.
Hmm.
But I undertake to pay that 3 lakhs which is due. On the tomorrow it is listed. Let them not precipitate the matter tomorrow.
Kakala. And the petition has been filed after lapse of 5 years. Much water has flown. It is
Supreme Court has held, my lord, that
They are ready to argue the matter.
fraud can be brought about any time, my lord.
Yes.
Let them not precipitate the matter. I'll pay 3 lakhs rupees.
Monday. ಅದು ಯಾವ್ಯಾವ ಡೇಟ್ ಬೇಕು?
My lord,
Monday,
63, my lords. Court officer, madam, sir. 63 on date ಕೊಡ್ರಿ sir.
53 one date ಕೊಡಿ sir.
63.
Short date ಕೊಡಿ sir.
63 sir.
ಈ ಕಡೆ ಬನ್ನಿ ಮಂಡೇ ಅಂದ್ರೆ ಮಂಡೇ ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಪೊನ್ನ ಸರ್, ಪೊನ್ನ ಸರ್ 63 ಒಂದು ಕೇಳ್ರಿ ಸರ್ ಡೇಟ್.
ಪೇಜ್ ವೈಸ್ ಹೋಗುತ್ತೆ, ಸೀರಿಯಲ್ ವೈಸ್ ಹೋಗುತ್ತೆ. ವೇಟ್ ಮಾಡಿ ಸರ್, ಯಾರು ಇಷ್ಟೊಂದು ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರೆ ಆಗಲ್ಲ. ಕೆಲಸ ಮಾಡೋಣ.
Serial number 40.
ನಿನ್ನೆಗೆ ನಿಂತಿರೋದು 5ನೇ ತಾರೀಕು. ತಗೋಬೇಕಾಗಿರೋ ಡೇಟ್ ಇವತ್ತಿಂದ 6ನೇ ತಾರೀಕು ಫ್ರೈಡೆ ಬಿಟ್ಟು ಇಂಟ್ರಿ ಮಾಡ್ರು ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಹೇಳಿ.
ನಮ್ದು serial number 47 urgent hearing ಬೇಕಾಗಿತ್ತು.
ಸರಿ. ಅದ್ರಲ್ಲಿ dispute ಇರೋರು ಬೆಳಿಗ್ಗೆ move ಮಾಡ್ಕೊಂಡು ನಿಮ್ಗೆ convenient date ಕೊಡ್ತೀನಿ. ಆಯ್ತಾ?
ಅಲ್ಲ, urgent hearing ಬೇಕಾಗಿದೆ ಅದು.
47
47 ನಾಳೆ.
ಇವ್ರೇ ಸರ್ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ, ನಾಳೆ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು.
ಎಲ್ಲ
ನಾನು ಹೇಳಿದ್ ಕೇಳ್ಕೊಡಿ, ಬೆಳಿಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ರೆ ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಅಷ್ಟೇ. 47 ಆಯ್ತು, ಅರ್ಜೆಂಟ್ ಮಾಡ್ತೀನಿ ಬೆಳಿಗ್ಗೆ. 48
48 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ ಯಾವ್ದಾದ್ರು
6th ನಂತರ ಡೇಟ್ ನೋಡಿ ಸರ್. dispute ಇದ್ರೆ adjourn ಮಾಡಿ. ಇನ್ನೊಂದ್ಸಲ ಹೇಳೋಣ.
ಅರ್ಜೆಂಟ್ ಮಾಡಿ ನಾನು ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡ್ತೀನಿ.
49
6th ನಂತರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸರ್. 6th ನಂತರ ಒಂದು ಡೇಟ್. ಆಯ್ತು. ಆಯ್ತು. 10th ರೆಸ್ಪಾಂಡೆಂಟ್ ಐಎ ಫೈಲ್ ಮಾಡ್ರು. ಎಂಟ್ರಿ ಮಾಡಿ 60
ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಆಗುತ್ತೆ. 51
ರೆಸ್ಪಾಂಡೆಂಟ್
ನೆಕ್ಸ್ಟ್ ವೀಕ್
53
ಪಿಟಿಷನ್ ಎಂಟ್ರಿ ಮಾಡಿ ಸರ್ 12th ಎಂಟ್ರಿ ಮಾಡೋ ಮೇಲೆ ಎಕ್ಸ್ಟೆಂಡ್ 54 6ನೇ ತಾರೀಕು ಆಯ್ತು.
54
6ನೇ ತಾರೀಕು
ಒಂದು 12 ಮೇಲೆ ಹಾಕಿದ್ದೀನಿ.
59
ಸರ್ 6th 60 ಮಂಡೇ ಸರ್. ಮಂಡೇ ಕೊಡಿ ಸರ್.
ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದಾರೆ.
62
ಸರ್ 10th ಕೊಟ್ಬಿಡಿ ಸರ್. 10th ಕೊಟ್ಬಿಡಿ ಸರ್.
ಸರ್ 63 ಆನ್ಲೈನ್ ಇದ್ದೀನಿ ಸರ್.
ಪಿಟಿಷನರ್ ಇಲ್ಲಿದ್ದೀವಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್ ನಾನು 63.
ಯಾವ್ದಾಗತ್ತೆ ಕೊಡಿ.
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಸರ್.
63
ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಯ್ತು, ಹತ್ರ ಡೇಟ್ ಕೊಡಿ ಸರ್ ಆಗಿದ್ರೆ.
10th ಎಂಟ್ರಿ ಮಾಡ್ರಿ. 6310
ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಕ್ಸ್ಟೆಂಡ್.
65
7th ಹಾಕೊಂಡ್ಬಿಡಿ.
7
ಸಿಕ್ಸ್ತ್ ಒಂದು ನಿಮಿಷ. 10th ಹಾಕ್ಬಿಡಿ.
66
10th
ಮಾಡ್ತಾನೆ ಇರ್ತೀರ ಬೆಳಗ್ಗೆ ಹೊತ್ತು. ನೋಡ್ತಾನೆ
ಸರ್ 10th
ರೀಚ್ ಆಗಲ್ಲ ಅಂದ್ರೆ ಅದಕ್ಕೆ ಮೂವ್ ಮಾಡ್ತಾರೆ. ಅದಕ್ಕೆ ಬೇರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ವೆಕೆಟಿಂಗ್ ಸ್ಟೇನೋ ಏನೋ ಹಾಕೊಂಡು ರೀಚ್ ಮಾಡಿಸ್ಕೋಬೇಕು. ಏನೇ ಇಲ್ಲ ಸರ್, ಏನೇ ಇಲ್ಲ ಅಂದ್ರೆ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದು. ಅದನ್ನ ನಾನು ಹೇಳ್ಕೊಡಕ್ಕೆ 67 ಇದು ಆ ಮೆಮೊ ಆಗಿದೆ. 65
10-3
ಮುಂದಕ್ಕೆ ಬರಬಾರ್ದು. ನಾನು ಇನ್ನ ಮುಂದಕ್ಕೆ ಜನ ಕಾಯ್ತಾ ಇರ್ತಾರೆ. ಯಾವ್ದು
ಒಂದು ನಿಮಿಷ ಬೇರೆ ಕಡೆ ನೋಡೋಣ. ಒಂದು ನಿಮಿಷ ಬೇಜಾರು ಮಾಡ್ತಾರೆ.
7 ಫ್ರೈಡೆ
ಯಾಕೆ
ನಾನು ನೋಡಿ ಇವತ್ತು ಅಯ್ಯೋ ಬಿಲ್ಡಿಂಗ್ ಮನೆಗಿದ್ದಾರೆ ಏನ ತಿಳಿಸಿದೆ ಏನು
ಆಯ್ತು.
ಸರ್ ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು ಸರ್. 73 ಎನಿ ಡೇಟ್.
76 77
Sir, interim order extend ಆಗುತ್ತಲ್ವಾ?
2 weeks ಆಗಿದೆ ಸರ್ ಅವಾಗ ಮಧ್ಯಾಹ್ನ.
ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಆಗುತ್ತೆ. 83 ಹೇಳ್ತಾ ಇದೀನಿ ಸರ್, ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಈ ಬ್ರೇಕ್ ಕಂಟಿನ್ಯೂಸ್ ಆಗುತ್ತೆ.
10th ಕೊಟ್ರಿ ಅವ್ರಿಗೇನೋ ಇನ್ಕನ್ವೆಂಟ್ ಅಲ್ಲ, ಅವ್ರಿಗೇನೋ ಇನ್ಕನ್ವೆಂಟ್ ಇದೆ. 65 ಯಾರು ಬಿಸಿ ರೀತಿ ಅವ್ರದ್ದು ಇಲ್ಲೇ ಇದ್ದಾರೆ.
65, 13 ನಾ?
ಹಾ.
13.
Yes.
ರಜಾ ಇದ್ದಂಗಿದೆ ನೋಡಿ ಅದು.
13 ರಜೆ.
13 ರಜಾ ಇದೆ.
14 ಇಲ್ಲ.
17 ಬೇಡ, ಅದು ಒಳಗಡೆನೆ ಬೇಕು ಸರ್ ನನ್ಗೆ.
12.
ಆಯ್ತು.
ಯಾವ ಲಿಸ್ಟ್? ಇವಾಗ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ, ಅದು ಬೆಳಗ್ಗೆನೆ ಆಗೋಗಿದೆ. ಏನಾಯ್ತು ಅಂತ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಯಾರು ನೀವೇನ ಪ್ರದೀಪ್? ರೀಚ್ ಆಗಿರೋ ಮ್ಯಾಟ್ರ್ ಬಿಟ್ರಲ್ಲ. ಅವರೆಲ್ಲ ರೀಚ್ ಆಗಿಲ್ಲ ಅಂತ 5:15 ಒದ್ದಾಡ್ತಾ ಇದ್ದಾರೆ, ನೀವು ರೀಚ್ ಆಗಿರೋದ್ ಬಿಟ್ರಿ. ದೇವಣ್ಣ ಬರ್ಕಪ್ಪ. ಎಲ್ಲಿಂದ ಹೇಳ್ಬೇಕು ನಾನು? 47. ಅರ್ಜನ್